Court officer, proceedings mute ಇದೆ ನೋಡಿ.
ಏನ್ ಸರ್? ಹಲೋ ಹಲೋ ಹೇಳಿದ್ರಾ ಟ್ಯೂಸ್ಡೇಯಿಂದ? ಯಾಕೆ ಡೌಟ್ ಅಂತ? ಎಷ್ಟಿದೆ NCL?
Serial number 51, Manoj. I'm withdrawing the issue. Filing a memo to that.
Withdrawing.
Withdrawing.
$51.
51, Manoj.
Learned counsel for the petitioner files a memo Tuesday seeking to withdraw this petition. Memo on submission is placed on record. Petition is dismissed as withdrawn.
Much obliged.
Fresh memo, fresh matter. Accused has been languishing in jail. It's 138 matter. Convicted in both courts. Filed a criminal revision petition any day next week.
Next week.
Page-wise adjournments. Page number 7, number 37 to 42. Page number 8, number 43 to 50.
Other side is also there.
46, Krishna.
Please, no. Only week same.
At request of learned counsel for petitioner. All this matter next week on
20th September.
Please.
My lord, serial number 44, my lord. Appear for the petitioners. Pray for a week's time, my lord. Any date after 24th, my lord.
await records all this matter on 25th.
Number 55 minutes. Number 55.
Page number 9, number 52 to 60.
55 minutes. Week's time minute.
You are for whom?
Petitioner.
Request of counsel for petitioner, call this after 2 weeks.
At serial number 53, Milad.
27th September.
At serial number 53, Milad. I am for the petition in this case, Milad. Senior and I am not well, Milad. Kindly have it next week.
Request of learned counsel for petitioner, call this matter after 2 weeks.
1 week could is a Tuesday. Maybe have it on Tuesday. Oblige.
17. Page number 10, number 61 to 70.
65, my lord. Serial number 65.
Yes.
My lord, on 8/3/2019, my lord, I have filed a memo reporting the death of the petitioner, my lord, on 23/2019, my lord. I had not been able to get the certificate, I mean, the death certificate till now. Because I am not in contact with the family of deceased the petitioner, my lord. I filed the memo 8/3/2019 itself, my lord.
All right. Have deposit, you are for the petitioner?
Yes, my lord. Yes, my lord.
We deposited the fine amount.
I'm not sure, my lord. It may not have been. I'm not sure, my lord. I'll ascertain and report. Could it be taken up next week, my lord?
All right.
Highly obliged.
Fayaz Saab
Sri Fayaz Sahab BG.
At request of learned counsel for petitioner. All this matter next week, 20th.
20th, but 23rd, 23rd,
23rd.
highly obliged.
Serial number 63, my.
Ah.
2 weeks time.
Who are you?
Also, my petitions.
What is the offense?
379, sir.
Argue the matter.
Certified copies. At least 1 week. 1 week.
Not even 2 days.
What?
You were sleeping over from 17 to 2016 when the matter was admitted.
Please.
Can please, yes, sir.
ಅದಾಗಿದೆ ಸ್ವಾಮಿ ಇಲ್ಲ ಅಂತಲ್ಲ. I got a certified copy. That is it is.
What certified copy you want?
Miss ಆಗಿದೆ.
At request of learned counsel for the petitioner, all this matter on 19th. 19th you argue.
Please.
Page number 11, December 71 to 80.
My lord,
My lord,
79, serial
72.
number 79, my lordship.
70.
Kindly grant a week's time, my
20?
lordship. 79, my lordship.
You are for
Petitioner, my lordship.
request of petitioner, all this matter next week.
Oblige, my lordship.
Serial number 75, my lord.
Yes, sir.
I filed NOC Wakalak for petitioner on 10th. I seek 2 week time.
What's your
75,
What is your name?
V. Narendra.
Narendra.
Yes,
Registry to show learned counsel Sri V. Narendra undertakes to file wakalat. Filed or
filed on 10th.
submits that he has filed wakalat on behalf of petitioner. Registry to show his name in the cost list. Call this matter on next week or you want 2 weeks?
2 weeks.
Call on 25th.
What?
25th September.
Serial number 72, my lord.
Hmm.
May accommodate on 20th September. I have to file application on PO Act. As your lordship suggested to file application.
Request of learned counsel for petitioner, call this matter on 20th.
20th.
For orders, number 1, Sri Mahadev Swami P. Paper.
I am for the respondent, Your Honor. I had filed a memo and also I had filed an application, Your Honor, to bring the LRs on the record, Your Honor, respondents.
You filed,
I had filed yesterday, Your Honor.
it's not listed today.
The application is not put up, Mal.
Respondent is dead, is it?
Yes, yeah. I filed an application to bring the LRs on
This
record, Your
application,
Honor.
my lord, there is no relationship between the petitioner and the deceased and the LR of the application.
Learned, you have filed wakalat for the LRs.
Yes, Your Honor. I had also filed the wakalat also, Your Honor.
Learned counsel for, what is your name?
Amrita, Your Honor.
H.A. Manjunath. is
H.A. Manjunath.
Counsel for respondent. Has filed wakalat and application on behalf of LRs of the respondent.
Yes, Your Honor.
Registry to put up the said application. All this matter on 19th,
19th, but 20th.
20th.
Your Honor, 19th only is okay, Your Honor. 20th, my senior will not be in the station. Your Honor.
23rd, my lord.
20.
23rd.
Yes, grateful, Your Honor.
Number 2, Sri Mohammad Khan A, Sri K.B. Naveen Kumar.
My lord, appearing for respondent, my lord. Last week, on the last occasion, the advocate for filed NOC, retirement.
Who was filed?
Advocate for petitioner.
There is no representation on behalf of petitioner. Registry to issue court notice petitioner. One minute.
He sent retirement notice also.
Issue bailable warrant to the petitioner for a sum of rupees 10,000.
16th October. December 3, Sri Somshakray RP, Sri Vijay Kumar Bhatia.
Hearing for petitioner, my lord.
Respondent, my lord. I filed a memo reporting death of petitioner has
Petitioner.
to be abated.
Petitioner death ಆಗಿದೆ sir.
Memo ಹಾಕಿದ್ರು sir.
ಏನಾಗಿದೆ?
At 29/8/24, respondent filed a memo along with death certificate of the petitioner. 138 proceedings.
We'll file the death certificate.
Petitioners,
Petitioner death ಆಗಿದೆ.
what do you say?
Close ಆಗುತ್ತೆ. Has to be 50% ಬಂದಿದೆ ಅಷ್ಟೇ, that's all.
You don't want to recover? You don't want to recover the money?
Lord, what has happened is the legal errors in the record because he's the accused. That is the reason.
I'll place your submission and I'll close it.
ಅಲ್ಲ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, ಮೆಮೊ ಫೈಲ್ ಮಾಡಿ ಐ ಆಮ್ ಫಾರ್ ದಿ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಮಿಲಾಟ್. ಮೆಮೊ ಮೇ ಬಿ ಕ್ಲೋಸ್ಡ್ ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ ಮೆಮೊದಲ್ಲಿ.
ಯಾರು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಎ ಮೆಮೊ.
ನೀವೇ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಅದೇ
It will not be abated.
Death certificate active sir.
Merely because the respondent says and it will not abate. Your interest of your client is involved. If counsel does not know the law,
ಹಾಗೆ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಮಿಲಾಟ್.
I'm talking about your counsel who's on record.
Please.
How much he has deposited?
Notes.
50% ಏನೋ ಕೊಟ್ಟಿದ್ದು.
ಬರ್ಕೊಳ್ಳಿ. Who has reported the death? You had reported the death?
No,
Who had
we have,
reported the death?
we have to report.
I have reported.
We have-
Respondent reported the death.
So you want this matter to be closed?
Closed, man. Because I am the complainant before the court below. The accused is expired.
You recovered some amount or not?
The deposit is there. This honorable court already ordered for issuance of check. LCR is before this honorable court. So if the record goes to the trial court.
What
I will
about
be able-
remaining amount?
7 lakhs.
What is the paid?
Only 7 lakhs is deposited. Total amount is 55 lakhs.
So you don't want to recover that?
I will go under the some other proceedings.
Huh?
Recovery proceedings before the assistant registrar is pending.
All right. 70 lakhs.
70 lakhs.
7 lakhs is, how much is paid?
7 lakhs is deposited before the date.
Worked. So death reporting is also by you?
Please, man.
Learned counsel.
I have
for
produced the death
petitioner
certificate also.
And learned counsel for respondent are present before the court. Counsel for respondent has filed a memo reporting the death of petitioner Shri D. Ravi Kumar, having died on 1/11/23. The death certificate is also annexed along with the memo. Full stop. Learned counsel for the respondent, while the memo seeks to close this petition in view of death of petitioner. Full stop. Close this petition in view of, close this petition as abated in view of death of petitioner. Full stop. In view of the judgment, the case of Rameshan versus State of Kerala, passed by the apex court. 2020, volume 3, SPC, page 45. The petition would not abate by itself on the death of the petitioner accused when there is a sentence of fine imposed. Full stop. In view of the respondent seeking closure of this petition on the ground that he has already initiated proceedings for recovery of the amount.
Sale process is pending.
Huh?
Only sale process stage is there. Auction sale conduct is there.
That's up to you.
Please.
The petition could be closed. Accordingly, I pass the following order. This petition is disposed of on the ground that the petitioner has died and on the memo filed by respondent. However, liberty is reserved to the respondent to recover the amount of the dishonored check in the manner known to law.
LCR may be returned back.
The amount is deposited before which court? Trial court?
Magistrate court.
The respondent is at liberty to withdraw the amount deposited by, have you deposited?
Deposit.
Madidara?
Madidara.
Deposited by the petitioner. The trial court shall disperse and release the amount in favor of already such an order is passed in favor of respondent by way of electronic transfer upon the respondent complainant furnishing relevant bank details on proper identification. The records ilva awaited here. Records are not here.
Please.
ಇದು ಸರಿಯಾಗಿ ಲಾಸ್ಟ್ ಪೇಜ್ ಫ್ರಂಟ್ ಹಾಕಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಫ್ರಂಟ್ ಬರೋ ಆಮೇಲೆ ಮಾಡಿ.
Number 4, Sri G.J. Sunkapur.
For petitioner, my lord. I filed a retirement memo on 10/10/2022, my lord.
For petitioner?
Yes, my lord. ಕೇಸ್ ನಡ್ಸಕ್ಕೆ ಯಾವುದೇ ರೀತಿ ದಾಖಲೆಗಳನ್ನು ಒದಗಿಸ್ತಾ ಇಲ್ಲ ಮೈಲ, ಅದರಿಂದ ನಾವು ರಿಟೈರ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ. ಇದರಲ್ಲಿ ಆಲ್ರೆಡಿ 10/10/2022 ಫೈಲ್ ಮಾಡಿದ್ದಾನೆ ಮೈಲ. ಅವ್ರನ್ನ ರೆಫರ್ ಅಡ್ವೊಕೇಟ್ ಇಂದ ಇದಾಗಿತ್ತು ಮೈಲಾಡ್, ನಮಗೆ ರೆಫರು, ಅವರಿಗೂ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದ್ವಿ.
He is residing in which place? Where is he residing?
State of Andhra Pradesh, madam. Sikandarabad.
After this petition, whether suspension was ordered? Not ordered.
Please, madam.
Suspension was not ordered.
No, madam.
So he is absconding.
Yes, madam.
What is the report of the police? It is sent by whom? Now police is Secunderabad. DG IGP. Where police sent by DG IGP. No? He is residing in Hyderabad or Secunderabad?
Sikandarabad, my lord.
ಬರ್ಕೊಳ್ಳಿ. Void order dated 19/7/24. This court ordered issuance of NBW against the petitioner. The report is received. Stating that the efforts made by the police have turned futile as the whereabouts of the accused is not known. Reissue NBW to the accused through the Commissioner of Police, Hyderabad. If the accused is not traced and apprehended, Commissioner of Police, Hyderabad shall provide an explanation as to why he is not traceable. The NBW is returnable by 2 weeks, 2-3 weeks, 30th.
30th September. Number 5, Sri Kemparaju.
Applying for the petitioner, my lord. My lord, in this matter, office, my lord, has raised an objection, my lord, asking me to file certified copy of the judgment, which is already filed before the court, my lord. I have an acknowledgement for having produced the same. Even in the High Court website, my lord, it is shown that it is forthcoming in the website as well, my lord,
What is forthcoming?
stating that the certified copy is filed before the court. I have an acknowledgement, my lord, even on the last date of hearing, I had made the same submission, my lord. On 16/7, I have produced the certified copy of the lower court judgment, my lord.
Is filed
It
accordingly.
is filed. I have an acknowledgement.
Registry to verify if the certified copy of the judgment is filed and put up the same. As counsel for the petition submits that she has filed the certified copy and has retained the acknowledgement of the same. What about notice to
It is
respondent?
paid. PF is paid. On 22 August, I have paid, my lord.
What is happened? Notice to
It is awaited.
Await.
an await police report available or not available?
138 of NI Act, my lord. My lordship had allowed the IA, subject to depositing of 50%. Needful is done, my lord. PF was paid.
Now,
on the-
why is the police report? Issue notice, police reporting one. Await. Report of service of notice to respondent.
30th September.
Yes, Mr. Lakshman.
Number 6, SPP.
Petitioner statement. The offense is
Report.
380. Accused was convicted by the
Await.
trial
Await.
judge.
Await report.
Await report. 2 weeks time maybe, because Tamil Nadu.
Await report, call on 30th.
30th September. December 7, Sri S. Kumar.
Non-furnishing of address, 2 weeks, granted to comply. Needful done, issue notice to respondent.
15th October. December 8, Shri Chandrakant Tariga.
For the petitions, pray for weeks time to pay the process.
All right. Week's time granted at request. Needful done, issue notice to R2.
Please, ma'am, much of in connected matter.
16th.
Obliged.
December 9, Shri S. Balakrishnan.
I appear for the petition. Lord, these are all 138 proceedings, my lord. Revision petition number 594 and 595. Amount to my lord 2 lakhs and 2 lakhs. It's admitted by the complainant that check was issued for security Thereafter, the entire money was paid. The trial court and the first appellate court observed, despite no doubt, the complainant admitted that he has received the amount covered by the check. But once the check is issued, it's an offense. That's how the conviction was held, my lord. 2 lakhs received, it is admitted by the complainant that the entire amount was received.
Entire amount was?
Received by him. And for the same check, he initiated the proceeding. 594 may kindly be followed.
Why is it listed now?
For admission, my lord.
Not for admission.
All the 5 matters, amount is paid.
Not listed for admission. For release of the amount.
Release of amount.
Where is your lawyer?
Your Honor, advocate has not turned up. I'm responding for 604 and 605.
What is your name?
T.S. Krishna Prasad, sir.
Hmm?
T.S. Krishna Prasad.
All right, we'll have it next week. Let him bring his count. Bring your lawyer next
Your
week.
Honor, ತುಂಬಾ hardship ಆಗ್ಬಿಟ್ಟಿದೆ, ತುಂಬಾ ಕಷ್ಟ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ಅಮೌಂಟ್ ಅದು ಏನ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರೆ ಅದನ್ನ ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು ಇದ್ ಮಾಡಿಸ್ಕೊಡಿ ಅಂತ
ನೀವು
ಹೇಳ್ಬಿಟ್ಟು.
ಲಾಯರ್ ಇಟ್ಟಿದ್ದೀರಲ್ಲ?
ನಮ್ ಲಾಯರ್ ಇವತ್ತು ಬಂದಿಲ್ಲ ಸರ್ ಅವ್ರಿಗೆ.
ಬರ್ಲಿ, ಲಾಯರ್ ಬರ್ಲಿ. ಲಾಯರ್ ಬೇಕಾಗಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ವಕಾಲತ್ ವಾಪಸ್ ತಗೊಂಡು ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೋದು. ಲಾಯರ್ ಇಟ್ಟ ಮೇಲೆ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
ಅಮೌಂಟ್ ನ ಇದ್ ಮಾಡಿಸ್ಕೊಟ್ಬಿಡಿ ಸರ್.
ಮಾಡ್ರಿ, ಕರ್ಕೊಂಬನ್ನಿ, ಮಧ್ಯಾಹ್ನ ನಾನು ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ, ಈಸ್ ಔಟ್ ಆಫ್ ಸ್ಟೇಟ್ ಇದಾರೆ.
You can't do anything. Work. Counsel for petitioner is present. There's no representation on behalf of respondent counsel in 9.1, 2 and 3. No notice is ordered?
Not yet ordered.
Why?
Cast list shows that not yet ordered. Notice may kindly be issued.
No, sir. Order suspension is ordered.
No, my lord.
Sir. Be the first thing that will be ordered. How can it be?
Cast list indicates notice not ordered.
Suspension is ordered. You have not deposited. Have you deposited the amount?
Blood, I was informed deposited. I will ascertain and make submission.
All right, issue notice to respondents. No, 9.1, 2 and 3. In 9.4, respondent is present, but his counsel is not present. Is this matter on? Advocate ಹೆಸರು ಪರಮೇಶ.
ಸರ್,
ನಿಮ್ಮ
ಪರಮೇಶ್.
ನಿಮ್ಮ ಹೆಸರು ಕೃಷ್ಣ ಪ್ರಸಾದ್. I will list it next week, 18th or 19th. Tell your lawyer to come. Is this matter on? 19th.
Please, ma'am.
Suspension is ordered already.
Please.
19.
Chamber 10, Sri Prasad BS.
Pass over the matter. Kindly pass over the matter. Application also ready, filed.
For what?
The delay in filing affidavit, my lord, complaints. Now it's a file. Today it's a file.
Now, what is the non-compliance?
Non-compliance, my lord, the IFI is not filed, my lord. The affidavit is not filed.
You're filing today.
Today it's a file, my lord. In the cost is concerned, my lord, today during the course of time I paid, my lord, because my lord, Belvin fund anta burde. I'm not able to trace, my lord. Now, my lord, my clerk is went to the.
What is the urgent order you're seeking?
My lord.
What is the urgency?
There is no.
You do it, I will list it on Tuesday.
Please.
Senate council submits, you would do the needful during course of the day.
Please.
He is permitted.
Please.
Is this matter on 17th?
Yes. Please.
Yes.
Chamber 11, Sri Ratnakar.
My lord, on petition number 1,
Counsel is not available, so I'll change my counsel, so humble request to grant me one date, sir.
Change your counsel.
Yes, sir. It's not been available.
Hmm.
I'll change my counsel and I'll comply with the objections.
All right. At request of a petitioner who's physically present seeks time on the ground that he wants to change his counsel. All this matter, you need 1 week?
1 week time, sir.
I'll call this matter on 24th.
Thank you, ma'am.
December 12, Sri Jeevan K.
It's appeal for the respondent. Lordship had directed 2 weeks back, my lord, to the petitioner to deposit the amount as directed by the Honorable Court. An application for extension of time was also filed. In spite of that, they have not paid me.
Sorry, can you repeat that?
Lord, an application for extension of time was filed by the appellant petitioner, my lord. And my lord, this Honorable Court was pleased to allow, whereby granting only 2 weeks time to deposit. Lord, I don't think so, my lord, they have deposited the amount. Interim order was granted subject to the payment of 50% of the check covered amount, my lord. But 2018 PCR was filed. In the year 2021, Lord, Learned Magistrate Court, my lord, convicted the petitioner
So he
here.
has not complied with the order.
We have not complained, madam, but we contacted complainant and agreed for settlement. Actually, he agreed to pay the amount on the 10th of October, an hour before, so.
You
after
execute
that-
the order. He will execute the order.
Yes, yes, sir, the process here.
Learned counsel for the petitioner is present, seeks time on the ground that there is some talks for settlement between the parties. However, the fact remains that pursuant to the order passed on 22/7/24 and thereafter the extension granted by this court on 30th August 24, petitioner has not complied with the order to deposit the amount as ordered. Stop. List this matter on
Immediately after vacation. Because 10th like clear marti immediately after vacation, Mina.
I have no instructions, my lord, with respect to settlement happening.
list this matter on 20th. Meanwhile, respondent is at liberty to execute the order if
Grateful.
yes, if there is a if the amount is not deposited.
Grateful.
December 13, Sri Shekharappa.
Manoj, I'm applying for the respondent, Manoj, I'm filing Wakalat, Manoj. Respondent.
What's the name?
D. Prabhakar, Manoj.
Huh?
D. Prabhakar. D. Prabhakar, Manoj.
D. Prabhakar.
Yes.
Learned counsel Shri D. Prabhakar files wakalat on behalf of respondent. Name is taken on board. Registry to show his name in the cost list. Suspension ಆಗಿದೆಯಾ?
D.
This matter for admission?
Yes, Manoj.
Copy you received?
No, Manoj.
Copy on good. One set of copies to be furnished. Yes, learned XCGP.
30th September 14, SPP.
What is the compliance?
365, 340.
Compliance entry.
So my lord, we have to furnish
2, 3.
office.
Party.
2 weeks time.
2 weeks time granted to comply. Objections raised by registry. Mohan Kumar.
1st October. December 15, Sri Mohan Kumar T.
Await report call after 2 weeks.
Appear for the petitioner, my lord.
Await.
Please, my lord.
Mohan, you are not well.
I'm fine, my lord.
2 weeks.
Please, my lord.
December 16, Sri Manjunath MR.
Number 16 is it? Yes. How did you do?
Objection raised by the registry is overruled. Issue notice to respondent.
16th October. December 17, Sri Nishit Kumar Shetty.
Each time may be granted to comply office objection, my lord.
Next time granted to rectify the objections.
Grateful.
24th October. December 18, Sri Chetan Kumar.
Weeks time, same, 2 weeks time.
27th October. December 19, Sri C.R. Rajgopal.
For the respondent complainant, please.
Petitioner, my lord, have served the copy, my lord. Last hearing, it has been ordered for serve the copy. I have served, and there is a chances of settlement, my lord. Kindly 2 weeks time may be given.
You have filed application for extension.
Yes, my lord. Yes. DD is also ready, my lord. We need to deposit.
16.
You have not deposited.
We have not deposited, my lord.
May I submit, please, my lords, for the complainant, my lords. My lords, on 18/4/2024, a coordinate bench of this honorable court was pleased to order that the IA for the suspension of sentence will be allowed only if the balance of 50% is paid within 4 weeks, my lords. This is in April, my lords. Again, in this month, 9, 5 months on, they have not paid anything, please, my lords. And today, again, they are before this honorable court asking for an extension. My lords, this is a 16-year-old case, please, my lords. The check was for an amount of just 2 lakh. The amount awarded also is 2,05,000. They're just dealing this, my lords, and we have not moved any application to execute the orders of sentence on the accused person out of humanitarian consideration, my lords. But it seems they are taking advantage, please, my lords.
My lord, petitioner is a 75-year-old lady, my lord. We can argue on the matter,
That's only on the
but there is
condition
a
of the IA being
scope of
passed.
settlement, my lord. There is a scope of settlement. We are discussing, my lord.
And pay the amount.
Yes, my lord, we are ready to deposit the amount.
When are you going to deposit?
Tomorrow itself, my lord.
Tomorrow?
DD is ready, my lord.
Ready?
DD is ready, my lord.
Give it to her.
No, it is in the name of the court, my lord, trial court.
You deposit it.
Yes, my lord, we are ready. At that time, only
What is
we
the
were
amount?
70,000, my lord.
What was
50,
ordered?
30,000 already deposited, and 70,000 we have to deposit, my lord.
So that becomes 1 lakh.
1 lakh.
What is the balance?
Another 1 lakh.
All right, you deposit this.
Yes, my lord.
Learned counsel for the petitioner has filed IE number 2 of 24 seeking extension of time to deposit the amount as ordered by this court dated 18 April 24. He submits that he is having a demand draft for rupees 70,000.
70,000.
He intends to deposit before the court. He is permitted to do so in the registry. He also submits that he has already deposited 30,000.
30,000 before the trial court, my
Trial
lord.
court by the order of the appellate court.
Yes, my lord.
By the
Trial
order-
court, my lord.
By order of the appellate court, he must have deposited.
Yes, my lord.
The order of appellate court. Full stop. This you have taken in whose name?
In the trial court.
Trial court registrar, right?
Register. Shidalgat.
Counsel for the petitioner is permitted to deposit the amount. Trial court shall receive the same. When you will pay the balance amount? 1 lakh?
No, my lord, there is a settlement negotiation is going on. I have discussed with the previous counsel who is in record. Yesterday also he told, next week or so we will sit and discuss and we will settle the matter, my lord.
I am also on the additional wakalat, my lords. There's a second wakalat.
All right, is the talks going on?
My lords, nothing has come to the complainant's notice as of now, my
All
lords.
this matter on 25th
Yes, my lord. 20.
to report settlement.
Yes, my lord.
Grateful, my lords.
Meanwhile, shall let her withdraw the amount.
Yes, my lord.
For called. Para. Have you filed any application for withdrawal?
Nothing as of now, please. my
Learned
lords.
counsel for
I
the
may be
respondent makes a oral request permitting the respondent complainant to withdraw the amount deposited by petitioner. This court deems it appropriate to accept the oral request and same is permitted. Respondent complainant is permitted to withdraw the amount deposited by the petitioner before the trial court. Full stop. The trial court shall release the amount in favor of respondent complainant by way of electronic transfer upon respondent furnishing relevant bank details on proper identification. A list on 25th, report settlement.
Grateful, please, my lords.
December 20, Sri Ajay Govindraj.
Yes. Objections you have cleared, Mr. Raj?
Cleared. Except that one objection where my lords, certificate copy was to be produced in respect of the magistrate's court's order.
Objections raised by the registry at serial number 4 is overruled. 4 weeks' time is granted to produce the certified copy.
Very well.
Yes.
Now, my lords, on merits, the dispute between the husband and wife.
Hmm.
One of this petition is filed by the husband.
Hmm.
This is a case, my lords, where a divorce proceeding was pending before the parties. During the pendency of the divorce proceedings, my lords, the wife initiated this domestic violence proceeding, which has culminated in allowing the petition. And that was questioned by the petitioner, my lords, in the Sessions Court in an appeal. Now, my appellate court, my lords, has gone on to dismiss my appeal, upholding the order of the magistrate court. My lords, the order is a replication of the magistrate court, my lords, without any. Look, I'll point out. My lords, the parties were married on 28/2/2013. They stayed together for only 4 months.
Stayed for 4 months.
Only 4 months. Thereafter, they were separated, and proceedings were going on in the family court. My lords, now the domestic violence court, my lords, magistrate court holds that have inflicted violence on her. Kindly have a look at the order, my lords. Para 16, Lords, page 16, para 18 and 19.
Of?
Ink page, magistrate court order, Sessions court order, my lords. Kindly have a look at para 16, ink page 18, Sessions court order. My lords, what it, para 16? Ink page 18.
Page 18.
18. Reasons and Thakbutto.
Reasons.
My lords, at para 16.
Yes.
In order to prove her contention, the petitioner has filed her chief examination and relying upon the documents which are marked exhibit P1 to P10. In her affidavit, she has reiterated and reaffirmed her contention taken in the petition. She is cross-examined at length by the learned counsel for the respondent. In the cross-examination itself, it is suggested to her that she is subjected to cruelty by her husband. She has admitted that she is residing away from her husband for the last 6 years. And my lords, she has admitted she is receiving 10,000 rupees per month as maintenance from July 2015 in the case filed by the respondent for divorce.
So you are paying 10,000 rupees.
Absolutely, my lords. I've been paying from 2015 onwards. Despite which, my lords, the domestic violence court says I have to pay 2 lakh rupees compensation and 10,000 every month.
Already you continue to pay. We'll stay that order of that compensation.
Hello, what happened, my lord? Before the Sessions Court, I deposited 1 lakh rupees already. That has not been. Kindly have a look at para number, page 23, para number 23, my lords. Page 20, page 23, para 23. For the reasons stated in the aforesaid paragraphs, I have come to the conclusion that there is no need for interference in the order of the trial court. On 24/4/2023, the counsel for the husband has filed a memo with demand draft of 1 lakh. The wife petitioner before the trial court has appeared before the court, but she has not received demand draft. Hence, demand draft is kept in the safe custody. Subsequently, also the wife has not come forward to receive the demand draft. But it's not about the money. She wants to harass me. That is the issue.
Whether divorce has happened or not.
Why not? Divorce has happened. My petition has been dismissed. Her petition has been allowed. MFA is pending before the division bench.
What is dismissed?
My petition for divorce was dismissed.
Okay.
She had filed a petition for restitution of conjugal rights.
That's
That was
allowed.
allowed. No, both are before the division bench have filed appeals against both the both the orders.
Yes.
And my lords can kindly see, I have deposited the money, 1 lakh rupees, she's not taken it. She refused to receive it.
Don't worry. Why are you getting worried about if she doesn't take it?
Allah, but my lords
You
are
have
saying,
done your job.
continue to pay and tell the
No, now as per the order of the Domestic Violence Code,
Yes.
does it say that till the time of your divorce or till lifetime?
ಇಲ್ಲ, it says lifetime ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
ಹೌದು.
Lifetime ಅಂತ.
Is your contention, is it your contention she's remarried?
No, I'm not saying that.
You have to still pay.
That order was stayed by the Sessions Court upon my depositing 1 lakh rupees.
Correct.
That 1 lakh is still in deposit, she's never not taken that money at all.
Right, that petition, that appeal of yours has come to an end.
No, yes, come to an end.
Appeal is now.
No, it's before my lords now.
Appeal is dismissed,
Yes,
confirming the order of the DV court.
yes,
So the order of the trial court stands.
absolutely.
So you pay 10,000, let that amount be there.
Yes.
We'll see what happens in the division bench and argue. Anyway, you're separated, go live your life.
But what I'm saying, my lords, is, kindly have a look at the order, my lords, it cannot be sustained at all. I'll only need 2 paragraphs, domestic court though.
All
That's
right,
why I sought for a
what is
stay.
it that you want now? Can I now pass an order on merits on main?
No, that can be stayed, my lords.
All right, I'll stay it. I will stay it.
ಅಲ್ಲ, but my lords are saying conditional ಅಂತ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
You continue to pay the 10,000.
That I have stopped long back. After this order was passed, I have stopped paying that because before the family court, my lords, the order was pay until dispose of the petition.
What is she doing?
She's working, my lords, in some hospital.
Berkoli. Heard learned counsel for the petitioner. What are you doing? What's your avocation?
I'm a contractor.
Contractor. And she is working as?
In some hospital, my lords, I'm not very
No,
sure.
hospital, doctor irtare, pune.
Doctor ಅಲ್ಲ. The administrative side she's working.
Heard learned counsel.
ಅವ್ರಿಗೆ ದುಡ್ಡು ಬೇಡ. They want to.
Most of these matrimonial cases.
Absolutely, my lords.
Mr. Ajay, you know.
Yes.
All about ego.
Absolutely.
And man, till the time he survives in this earth, he will not let go his ego. Man means even women.
I understand.
Issue notice to respondent.
I sought for stay of the order.
Yes. Orders on IE, 1 of 24. There shall be stay of the impugned judgment passed in criminal miscellaneous number 147 of 2014 by the Metropolitan Magistrate Traffic Court Roman 2 at Bangalore, confirmed in criminal appeal number 346 of 23 dated 27/1/24 by the 55 Additional City Civil Sessions Judge Bangalore. Subject to the condition, the petitioner deposits 5,000, what? 5,000 rupees as interim maintenance till the appearance of respondent.
But will deposit before this court only or?
For this.
Very well.
But otherwise you have an account number of the respondent?
I'll do it here itself.
No, the 10,000 where you are depositing?
It stopped long back.
No, how you are depositing that?
I was paying in cash sometimes, I was paying by check.
Do you have the account number?
I don't think so. Madam.
Already you deposit here.
I'll deposit here.
If the amount to be deposited before this court till the appearance of respondent.
But what is the amount, my lords?
5,000 rupees you have to deposit. Continue to deposit 5,000 till appearance of respondent.
Very well.
Notice to respondent.
Obliged.
Already the matter is pending before division bench.
Yes. It is pending. In fact, one round of my lords, it was called in the chambers and she was spoken to and she's agreed in principle to let go.
Then better you sort it out there.
Absolutely, but that's what.
So that divorce is granted and you can part ways.
Yes.
16th October. December 21, Shri T. Radhakrishna Shetty.
Needful done within a week's time. Notice be issued to respondent. Radhakrishna Shetty.
Shri T. Radhakrishna Shetty. 16th.
All this matter next week.
December 22, Shri Muhammad Tahir.
Appearing for petitioner, my lord.
Suspension is ordered.
Yes, my lord.
Await report.
Interim order, maybe.
Huh?
Please. Suspension is done.
Await.
24th September. December 23, Sri Venkatesh TS.
Done, my lordship.
Done?
Need-
Learned counsel for petitioner submits needful is done. The same is in order. Issue notice to respondent. Returnable by. Hold on.
16th October. December 24th,
Zahiruddin.
Syed Zahiruddin.
Yesterday I have filed the wakalat.
Appearing for petitioners.
Kindly next week, madam.
Your Lordship.
Naveen Reddy.
Yes, madam.
Yes, Syed.
Appearing for petitioner, my Lordship.
All right. Suspension ಆಗಿದೆಯಾ?
Yes, sir. Yes, Lordship.
All right. Call this matter after 2 weeks.
Please.
Respondent
Much
has
obliged.
filed wakalat.
Respondent, madam. Please.
Much obliged.
20th.
List for admission.
Tuesday. Next week. 24th. 25, Sri M.V. Maheshwarappa.
Petitioner. Await
report. Await report of notice of respondent.
30th. December 26, Pauline Priyanka B.
Needful done within 2 weeks. Needful to be done within 2 weeks.
30th
Follow.
September. December 27, Sri Venkatesh.
This
What
is
is
regarding maintainability is concerned.
How then?
The office has not raised the objection.
What is this?
That is challenging the order passed by the 29th HMM court regarding recall.
Recall
The
application,
presence of the accused need
Recall.
not.
24,
warrant recall application was rejected by the.
Through video conference did not entertain.
Recall of warrant was rejected by this court.
Not this court,
Trial court.
trial court,
Ah,
challenging the revision petition filed the petition.
Even. 24.
Regular date was on 5/9/23. On that day, accused counsel, that is petitioner counsel, did not appear and not filed the exemption application. Thereafter, immediately 8/9/2023, file advance application along with recall application. Permit the petitioner to through video conference because he is working in USA, my lord. Because one that is company name. I am producing the document to that effect authorization, employment authorization letter and also visa card, passport. He is residing with USA. For that's why the counsel appearing for the petitioner approach before the trial court through video conference only. Recall the NBW application has been filed. The same has been rejected by the trial court on 8/9/2023. Along with co-accused 4, 5, 10, my lord. Again, the petitioner is the accused number 4. And 5 and 10 again appeared before the trial court. Then only consider the recall application. My submission is through VC.
you are which accused, Mr. Counsel?
Accused number 4.
4.
Petitioner is the accused number 4, my lord. Rest of the accused already and even
Where is the order? Which is that order here?
8/9/2023, 26 page number.
Speaking order.
The alleged offense
Order
only 323, 324, 504 and 506. Only relatives quarrel regarding complainant and the accused. That's why I am praying the honorable court to set aside the order and permit the petitioner to appear before trial court through VC. There is no mandatory regarding accused presence.
So
Counsel
IA
is
is
subject.
rejected, 4, 5 NBW issued. So now what is, this is filed only by 4, right?
Oh, again, 5 and 10 appeared before the trial court.
It's recalled.
It has been recalled.
Nimdu madilla.
Only regarding 4 is concerned, I am filing the present petition.
All right, where is he? Where is accused number 4 now? Where is the petition?
He is working in,
I told you last time you keep him present on VC.
yeah, exactly.
He can't come.
He can't come, that's why.
All right, then let him come. And police will bring him.
But because he's.
If he's too
some
busy with his work.
difficulties, Some. due
Was he
to-
present through VC
Yeah, exactly, present through VC.
for the trial court?
Yes, exactly.
All right, keep him present here.
That's why direction may kindly be issued
Not obeying the order. of
before
court.
the trial court.
But before trial court, sir, you want that warrant to be recalled.
Yes, through
Keep
VC.
him present here.
Well, that's why here it is now, today is unable to appear. Because unable to appear.
And he can appear.
Next in any date, may kindly be.
All right. This matter on next week, 19th or 20th?
19.
19th. Keep him present through VC.
Definitely.
The petitioner, accused number 4, is directed to be present through video conferencing along with the madam, through video conferencing, full stop, on 19th,
Obliged.
call on 19th.
19th September, December 28th, Shri Sheetal Soni.
None appears. 2 weeks granted to rectify the objections.
27. December 29. Shri S. Raju. Shri MC Jaikirti.
Put it. Put it.
For the appellant.
Yes.
For the appellant.
Seeking
extension of time ಬರ್ತೀನಿ. ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸೇ ಫೈಂಡ್ ಔಟ್ ಮಾಡಿರಲಿಲ್ಲ ಸುಮ್ಮನೆ 6 months ರೆಕಾರ್ಡ್ಸೇ ಅಲ್ಲಿಗೆ ಪ್ಲೇಸ್ ಮಾಡಿರಲಿಲ್ಲ ಕೋರ್ಟ್ಗೆ.
ಎಲ್ಲಿ?
ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ.
Right.
ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಇಲ್ಲಿಂದ ಹೈಕೋರ್ಟ್ ಇಂದ ರೆಕಾರ್ಡೇ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಪ್ಲೇಸ್ ಮಾಡಿರಲಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
You are for?
ಅಪೆಲೆಂಟ್ ಮಲ.
Not your instance, the matter was remanded.
Please.
No date was fixed by this court to appear?
No,
Date was not fixed.
that date was not given.
Peruse the letter. Dated 6/6/24. The learned principal, senior civil judge and CJM Ramnagara. Requesting for extension of time for a period of 6 months for disposal of the case. This court deems it appropriate to extend 4 months period from today for conclusion of the proceedings. It is made clear that if the parties to the proceedings do not cooperate with the court, the appellate court is at liberty to impose costs, including exemplary clause costs. Accordingly, request made by the so-and-so is allowed period for conclusion of the proceedings is extended by 4 months from the date of receipt of copy of this order.
Please,
Hearing on
You have appeared
please appear at one.
in the,
In the trial, first appellate court.
who's not appearing now? Respondent.
The respondent, nobody appearing on behalf of the respondent.
Why?
Don't know.
All right.
Hearing on IS, December 30, Sri Akram Pasha K.
For petitioner, my lord, I'm filing IA number 3, my lord. My lord, DD ready ಇದೆ, my lord. Deposit ಮಾಡಕ್ಕೆ 1 week time ಬೇಕಾಗಿತ್ತು, my lord.
And for the respondent, my lord, we'll be filing wakalat by Monday.
You have taken the DD in whose name? Court name?
Court time, yeah.
What was ordered? When was it ordered? Time has lapsed.
9/8 ಗೆ ಆರ್ಡರ್ ಆಗಿತ್ತು, my lord. 4 weeks time ಇತ್ತು.
ಯಾವಾಗ? When, ಯಾವಾಗ ಆರ್ಡರ್ ಆಯ್ತು?
9/8/2024, my lord.
Now you have filed some application for extension.
Extension 1 week, my lord.
All right. Learned counsel for the petitioner. You are filing wakalat?
By Monday, lordship.
What is the name?
Veda SN. Veda SN.
Learned counsel so-and-so undertakes to file wakalat on behalf of respondent. Registry to show name. Bharatpadima. The cost list. Full stop. Learned counsel for the petitioner. You served a copy? ಪಕ್ಕದಲ್ಲಿ ನಿಂತಿದ್ರೆ ಕೊಡಬಾರ್ದ? What kind of practice you do? Filed an application seeking extension of time to deposit the amount as ordered by this court. On the ground that she has already procured the demand draft in favor of this court. Under the circumstances, a week's time is extended from to comply the order passed by this court on 9/8/24. Full stop. This matter for admission. Deposit ಮಾಡಿ 1 week time is granted.
Number 31, Sri Nehru MN, Ramakrishnan, yes.
Petitioner, my lord.
Respondent in this
case. In this case, my lord, the petitioner is an accused. The conviction has been passed on
You are
130.
Nehru, MN Nehru,
My partner, my lord.
partner. What is your name?
Hemchandra.
Hemchand. Yes.
In this case, my lord, as per the first appellate court, we have deposited 20% of the amount in the lower court. And thereafter, our appeal that has been dismissed. So that without preferring the criminal revision petition, the entire 80% of the fine amount that has been already deposited in the year of 2022, my lord. In meantime, my lord, regarding that conviction, that fine and 6 months imprisonment that has been given. But oversight, we are not aware of that. So in between, the accused is brought before the trial court by way of arrest. Subsequently, I filed a revision petition before your lordship, and later he has released on bail by executing the bond and depositing 1 lakh rupees. As per that, that is the entire amount that has been deposited long back, my lord. So last occasion, my learned friend has said that they are not taking the reference from the lower courts for having deposited that amount. The entire order sheet, it clearly reflects, my lord. Page number 20 and 21. Your lordship, page number 20 and 21, my lord. Page number 20, my lord. On 19.3, my lord, the 4,40,000 rupees that has been paid by way of DD 35,807 of 8,319 drawn on Karnataka Bank, Indiranagar, my lord. But and next page, my lord, on 7/1/2021, the entire amount that deposited 17,60,000 rupees by way of DD 506314 drawn on ICICI Bank, Domlur branch. Accordingly, 22 lakhs already deposited in the year of 2022, my lord. Last occasion, my learned friend has submitted before your lordship regarding for having deposited 17.5 lakhs. There is no reference.
No, not 17.5. The issue was with regard to the 4,40,000, the 20% that was deposited, my lord. I'm not casting aspersions on my learned friend. Even I have seen the file noting. The issue is in the cash branch. When we verified, there are only 2 entries, my lord. I may be permitted to furnish a screenshot of what I got in the cash branch. The 17,60,000 I'm not disputing, but there is no entry.
Entry for what?
Entry as far as the 4,40,000 is concerned, my lord. When we inquired with the cash branch, they say that there may be a possibility that the DD may have lapsed. Hence, there is no entry.
The order sheet is produced now.
I'm not casting any aspersions on my learned friend, but there is no entry at all on that. Therefore, they say.
Go and find out.
No, my lords, I've already inquired. They're saying there is no such deposit in their entries. Therefore, that's not being reflected here. And I've secured the screenshot. So their explanation is that the DD may have lapsed for the 4,40,000. There are only 2 entries. 17,60,000 is not disputed. 1 lakh was for the suspension of sentence.
So 4,40,000 is the one.
Please, ma'am. Please. So they are also unable to provide an explanation for this now.
So that means you have paid the entire amount.
Entire amount.
Suspension of sentence is ordered.
Yes, suspension.
Alright.
Yes, my lord.
Good.
And he's already released on by
Third learned counsel for the petitioner. IA 2 of 22 is filed to condone the delay of 67 days. Being satisfied with the reasons assigned and cause shown in the affidavit annexed to the application. Delay of 67 days is condoned. The trial court shall verify with regard to the deposit made by the petitioner amounting to rupees 4,40,000. On 19/3/2019, correct?
Yes, my lord.
Deposited by DD number 305807 dated 8/3/2019. As to whether the said amount is in deposit for the court or whether it is whether the DD has lapsed. Call this matter on. Which court it is?
This is deposited in the trial court. my
Bangalore,
lords.
Thank
trial
you.
court.
Call this matter on 27th.
Much.
My lord, in the meantime, may we be permitted to withdraw the balance amount, 17,60,000.
No objection.
You're now paid that you're wanting to challenge this now?
No, we are not challenging.
We
Only
will be
thing is
permitted.
our sentence has to be set aside, that's all.
Not counsel. Have you made any application?
It's already allowed, my lords, on 14/8.
Filed application, it is
Please,
allowed.
before this court, my lords, on 14/8 I had filed
Hmm.
for release of the amounts. The other side said no objection and an order was passed to that effect. The only issue was there, we were also under the impression that 22 lakhs has been deposited. But now this issue has arisen. So I will not be able to withdraw whatever is there as of now because it says 22 lakhs in the order. In your lordship's order,
That order passed.
14/8, my lords, 14/8/20.
Purple. In pursuance to the order dated 14/8/24. The petition, respondent is at liberty to withdraw the amount
17,60,000.
of rupees 17 plus 1 lakh, alva.
1 lakh is a suspension order, my lord.
1 lakh regarding the suspension of
Suspension.
that has been
security to
deposited before
suspend.
this court
That
at
is
the time of granting bail, my lord.
No, that is deposited,
That is deposited before this court.
17,60,000.
Please.
Is deposited before the trial court. In Bardrima, read out what you read. Which is reflected before in the trial court records as it is contended by learned counsel for respondent. The balance amount of 4,40,000 is not finding its place in the records entry of the trial court. Hence, respondent is at liberty to withdraw 17,60,000 before pending before the trial court. Deposited before the trial court by way of a electronic transfer upon respondent furnishing relevant bank details on proper identification.
Grateful, man.
Chamber 32,
Chole.
Sri M. Sharas Chandra, Sri Hemant Kumar Esa,
Appear for respondent. Respondent. Just to release the amount of 50% deposited amount money.
What is the check amount?
8 lakh, my lord. They have deposited 4 lakh, my lord.
Check is for how much?
8 lakh, my lord. 5,000 is fine amount.
Learned counsel for the, there's no representation behalf of petitioner. Learned counsel for the respondent is present. He has filed an application seeking withdrawal of the amount deposited by the petitioner. Objection to this application is not filed. Being satisfied with the reasons assigned and cost shown in the affidavit annexed to the application. A number 1 of 24 is allowed. Respondent is permitted to withdraw the amount deposited by the petitioner. Full stop. Trial court shall release the amount deposited by the petitioner in favor of respondent complainant by way of electronic transfer upon respondent furnishing relevant bank details on proper identification and on proper identification. Full stop. However, it is made clear that this order would be subject to outcome of this petition. In case the petitioner succeeds, respondent will be liable to refund the amount along with prevalent bank rate interest. Next.
Number 33, Shri S. Shivkumar.
Petitioner is an IA for condemnation of delay of 91 days.
Notice is not served?
No, not at,
Notice has to go.
no, my lord, so the application is pending, my lord, for condemnation of delay.
Right, whether notice has gone on that?
No.
Issue notice on main and IA.
16th October.
Follow on.
16th October.
Please.
34, Shri Ravi Kumar NR, Shri Pawan Kumar ji.
Respondent will file an application seeking release of money deposited to trial court.
I'm filing an objection to the application, my lord.
Okay, registry will file, but file it in the registry. Any serious objection?
Serious objection means, my lord, my serious contention, my lord, there is no legally recoverable debt between the complainant
I'll
and the
list it
accused.
next week for consideration.
Please, my lord.
Go through that.
Only contention is raised is, one Ranjit Kumar had received a check. They have been misused it. There are findings by the trial court and the appellate court that Ranjit Kumar is not examined. He has not proved his defense, hence conviction.
It is
That
not,
is the
not
only
only that
thing.
one, my lord, because the only 2 days earlier, the amount
Sir,
which,
what is your objection for release of the amount?
please, my lord, my submission, my lord, earlier to the time, amount which has been given by the complainant to the accused, 2 days earlier, the amount he has withdrawn. He has not issued any check to the accused. He himself has withdrawn. That amount also deposited just 2 days earlier to his account. And he withdrawn himself. He stated that he has given by way of cash of rupees 16 lakhs.
There are 17
That
that we
is-
take a look at.
That is the main contention, my
Of
lord.
the trial court judgment.
Because he shows that he is having sufficient money in his account. That is why 2 days earlier, some amount has been transferred to his account. And 13th of August, he has withdrawn the amount, and 16th, he has paid the amount to the accused. My serious contention, my lord, he has not given any amount because the copy purchased by the Ranjit, that has been for the consignment.
Objections file model.
Objection.
Read out.
Para 4 of the objections, my lord.
Read
What?
it.
It is submitted that the petition has taken serious contention that there is no legally recoverable debt between the petitioner and the respondent. The check in question at exhibit P1 issued only for security purpose. For some other transaction with person called Ranjit for consignment of the coffee trading, the respondent has received the check from him and inserted his fancy number of amount and filed a false case against the petitioner. It is submitted that if the amount in deposit as per the order of the honorable court and if same is permitted to withdraw by the respondent, the petition will be put to great loss. This is the basic contention. Para 17 is the finding.
Hold on. 16th October. 16th October.
16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th October. 16th
Heard learned counsel for the petitioner and respondent. I number 3 of 24 is filed by the respondent seeking withdrawal of the amount deposited by the petitioner. On the ground that he requires the amount as he is suffering from financial difficulties. Objections to the said application is filed today by learned counsel for the petitioner, contending that he has a very good case on merits and knows that legally enforceable debt is existing between the petitioner and respondent. Objections raised by the petitioner is already the contention which was urged before the trial court as well as the the appellate court. The circumstances, this application could be allowed by imposing certain conditions. Accordingly, IA number 3 of 24 is allowed. But respondent to complainant is permitted to withdraw the amount deposited by the petitioner. Will stop. The trial court shall release the amount in favor of the respondent complainant. However, the same would be subject to outcome of this petition. In case the petitioner succeeds in this petition, respondent shall refund the amount with the prevalent bank rate interest. Respondent shall refund the amount along with prevalent bank rate interest.
Number 35, Sri Suresh Chottayanda.
This petition for announcement of the interim maintenance. But I filed by the wife.
Your
I
complaint
am for petitioner. The wife has referred this appeal under the DV Act.
for enhancement.
Enhancement.
So you were granted some amount
Yes, sir.
that is confirmed by the appellate court.
Appellant court, the trial court has ordered 30,000 per month and with the educational expense of the two daughters. The appeal, the respondent has preferred an appeal. In the appeal, only 25,000 is ordered.
On issue notice on main and IA.
Yes. And delay is there 165 days.
Let go and come back. Service notice ಹೋಗ್ಬೇಕಲ್ಲ.
Yes, sir.
36, Sri Hiremaಠದ Mahesh Ayurdraya.
Await notice. Await report.
Yes, September. For admission, December 37, Srimati Lakshmi Solla, Sri G Sukumara.
Okay, I agree to the respondents. This petition is already passed away and we have filed a memo. The appeal gets abated. Your Lordship, they should have filed it, but the Lordship told me to file. I got the death certificate and I have filed before your Lordship. In this case on 8th August. So this appeal gets abated.
You have not been appearing in the matter, Mr. Sukumaran?
No, my lord, I appealed and filed this memo, my lord.
No, on the last two hearings, they were appearing and I passed over the matter twice.
My lord. I thought it gets abated.
No, you were
No,
busy.
my
but
lord, what has happened here? The proceeding gets abated after I filed it, informed the court. I thought they said they will clarify and come to before the court. That's what the other
did you
side has
file?
said.
You have filed something.
I filed that memo. Your Lordship wanted me to file on 88, my lord, and I filed on 88 memo.
So it's basis of your memo that the death is
No, Your Lordship told both of them has to file a memo whoever got a death certificate.
all right. See,
And since your Lordship has directed me, I able to proceed with his wife and I got it the death certificate. And I thought they said they were not aware of it. They said they will come back to you after verifying. I said, okay, I left it over there.
If
Thinking
confirmed-
that they will tell the court and my appearance is not necessary in this
So I
case.
will close this
Yes, my lord.
petition.
Yes, it has to be, the appeal gets abated, my lord. The revision gets abated.
This is arising of the DV Act.
My lord, yes, what has happened, see me, is 7,000 per month it was granted. They challenged before the first appellate court is session date. That was dismissed, it is confirmed. Against that both orders, they came before this court. That's all.
So that 7,000 remains, order remains.
Yes.
So you can execute that order.
That execution is pending because of the interim stay. It was there. That was
Good.
that we will proceed according to
All
this trial court
Learned
procedure.
counsel for the petitioner and learned counsel for respondent are present. Learned counsel for the respondent. filed a memo dated 8/8/24 reporting the death of the petitioner who died on 18/4/24 and has annexed the death certificate along with the memo. Full stop. Learned Senior Counsel Shri, what's his name, Mr. Lakshmi?
Ramesh,
Ramesh Puttige Ramesh.
yeah, Puttige Ramesh.
Senior Counsel Shri Puttige Ramesh, appearing on behalf of Lakshmi, Srimati Lakshmi S. Holla, submits that the matter would have to be closed as the petitioner has died. Full stop.
As an abated, madam.
As abated.
Yes, madam.
Full stop. It is seen that there is no dispute with regard to death of the petitioner Shri Pushparaj E. In view of his death, this petition would have to be closed. However, the petition may not abate in view of the judgment of the Honorable Apex Court in the case of Ramesh versus State of Kerala reported in so and so. The respondent would be at liberty to enforce and execute the order in a manner known to law. Accordingly, this petition stands closed, reserving liberty to the respondent to recover the amount of maintenance.
Yes, madam, maintenance.
Amount of
As per the
maintenance
order dated 20th September
in a manner known to law.
2013.
I would have passed the order, but I wanted to do it in your presence.
Yeah, yes.
Because you are not online also.
No, yes. ma'am. Oblige.
Number 38.
And for the
Shri
respondent,
H.
my lord.
Bhagwa. Shri N.R. Girish.
Yes, Mr. Radhakrishnan.
Inspect-
Radhakrishnan.
True, my lord. I have instructed my client to be present, but he was telling continuously that he is not keeping well. This is the position.
Is there any settlement agreement?
The settlement we have agreed. My lord, check amount is
May-
70.
My client has also agreed for 1 lakh, my lord, but the petitioner is not coming forward and he is not presenting before the.
He is telling that nan Usharilla Swami antane
I'll direct him to be present.
Please,
Whether he is inclined to settle or
he is ready to settle. Only thing is, he is not coming.
keep him, you'll keep him present or you want me to secure him?
Not necessary to secure. I will inform him. Or else I make one request, my lord. If let's me kindly partly allow the revision, fix it for 1 lakh. 3 months sentence is there. That will be, that may be removed, my lord.
Oh, you have, what is the order?
My lord, this is at
75,000 check amount, my lord.
page 40, 40, my lord.
32,000 is the.
Page 40, my lord.
Order ಏನಿದೆ?
My lord,
1,52,000.
ಹೌದು sir. Check amount is 75,000.
So you are agreeable for 1 lakh?
1 lakh.
Both
My
of you.
learned friend is also agreeing for that.
How much you have paid?
Already 70,000 deposit. I have no
30,000
objection to
30,000 you have to pay.
30,000. Remaining 30 I will pay.
Bring it next week.
Let's make kindly see instead of today. Let's make kindly pass order.
No, how can I pass out of that? He has to come, you have to file application for
That is true, that is true.
147 Aki.
That is true.
I'll keep him present.
Then let's make it 2 weeks kodi sumi avtar no.
25th, 26th?
Please.
27th or 25th, 25th or 27th.
Yes, sir, Mr. Radhakrishnan.
Please, my lord, in fact, I am making efforts because the 3 month sentence is there. I specifically told him to come today. Nan hushariಲ್ಲ ಮಾತಾಡ್ತೀನಿ ಸ್ವಾಮಿ ನನ್ಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ ಒಂಥರ pretending is talking like
Attention. So bailable warrant will resolve that illness.
That will be, there is no problem. Only thing is having on record, getting that order, I feel little bit embarrassing.
Barkali.
Please, my lord.
Learned counsel for the petitioner and respondent are present. Both submit that they are willing to settle the matter. Petitioner has already deposited 70,000.
Please, my lord.
He is ready and willing to pay the balance 30,000. Petitioner and respondent to be present before the court on 26th.
Please.
Not 26th, my lord. 25th or 27th.
25th.
Yes.
before the court. Either physically or through video conference.
Please,
But if you are filing, you have to file IA.
please.
December 39, Sri B. Siddeshwara, Jay Kumar ji.
Petitioner in this case, my lord. My lord, 138A proceedings, my lord. My lord, order dated 2/8/2024, coordinate bench has reserved the matter, my lord. For the parties have arrived to the settlement, paying a check amount. Check amount has been paid. Subsequently, the respondent complainant wanted more amount. We are trying to pursue the matter, but she is not willing to come. Even today, they are not present. In the last date also, I tried to pursue them, my lord, they are not present. Lord, what has happened in the trial court is they have made a double the check amount, my lord. Check is 10 lakhs, my lord. Now the fine is 20 lakhs, my lord. 10 lakhs has been received by the complainant by now, my lord. By the
How much
order
you
that-
paid him?
We have paid them, my lord.
How much?
10 lakhs, my lord.
When?
My lord, on 2/8/2024, the order is specifically states, my lord. On 12/1/2024, it was submitted before the court that the entire check amount has been paid to the respondent.
Order dated?
2/8/2024, my lord. In order sheet starts, my lord, there is a specific date, my lord, on 12/1/2024. It was submitted that before the court that the entire check amount has been paid to the respondent. On the day, the learned counsel for the respondent submitted some more amount needs to be paid to the petitioner to respondent. My lord, now check amount has been resolved. Now only the sentence part remains, my lord. They are not appearing. My party is trying to pursue there, my lord, but my lord, I would argue only on the sentence part, my lord, if my lord permit. Reduce the sentence, my lord, and
When did you pay the 10 lakhs?
My lord, basically, my lord, as first appellant court, I had deposited 25%. Over here, I had deposited 50%. Subsequently, 5 lakhs was paid on 12/1/2024. 5 lakhs was
Why didn't
paid.
you file a joint memo?
My lord, we couldn't file the joint. They didn't agree for the same, my lord. After receiving the amount, they turned down, my lord. That's the difficulty, my lord.
Vijay Kumar.
Last 2
Vijay
days also,
Kumar
they didn't
ji.
appear, my lord.
Learned counsel for the petitioner is present. There is no representation on behalf of respondent. Respondent and his counsel to be present before the court on 26th.
Obliged, my lord.
Number 40, Sri Subha Shastri N, Srimati Pratibha K M. Srimati Pratibha,
I'm informed that the parties have come to a terms, sir. They have agreed to receive 3,70,000 rupees, my lord. They are not present today.
Yuriaro,
You are an accused, petitioner.
your client.
2,50,000 rupees was deposited before the trial court.
What
On
is
the last
the-
date of hearing, your lordships
What is
allowed
the
the
fine
application
amount
for
and
them.
what have you deposited?
Sorry, Manoj?
What is the fine amount?
Fine now. 6 lakhs, my lord.
How much is agreed?
3,70,000, my lord. There were other transactions between them. Sale agreement was executed and later they had some real estate transactions also. Taking all that into consideration, 3,70,000 rupees is agreed between them.
How much is paid now?
2,50,000 is already deposited before the trial court. On the last date of hearing, your lordships allowed that application to take that money back.
Learned counsel for petitioner along with petitioner is present. There's no representation for respondent. Full stop. Call this matter on 26th.
Please, madam.
On that day, if you can file application if both of you are agreeable.
Please, madam. I'll do.
41, Sri Chetan Nag, yes.
Chetan
Sri Chetan Nag,
Kasur.
Pasor. December 42, Sri Rakshitar, Srimati Brinda A.
Appearing for the respondent, my lord. He is released, my lord. Respondent,
The same matter,
yes, my lord.
all settled?
Yes. Respondent is present, my lord.
So you have received the entire amount?
Yes, my lord. The entire amount has been deposited in the court's name, my lord, and we have got the permission to withdraw the amount also, my lord. We are in
This
process. No, my lord, trial courts, before the trial courts.
All right, so you file your joint memo,
My lord,
file a joint memo, you want to set aside the order, otherwise it is, you want to see that the order is set aside, or you want the case to be closed?
case to be closed, my lord. The
That
case
order
to be
will remain
closed.
of your conviction.
We'll file a necessary memo, my lords.
See, you have paid the amount,
Yes,
conviction
ma'am.
order will remain against you.
We'll file a memo, my lords.
You file it.
Okay. Sure, we'll file.
You have permitted to withdraw the entire amount?
Yes, my lord.
Just file that 147 application, both of you can sign, both the parties.
Okay.
He is your client?
Yes, my lord. Respondent. My client is not present before the court.
When do
A
you want?
date may be fixed.
When you want?
Lord's Wednesday.
All right. Both the learned counsels are present before the court. It is submitted by the petitioner that the entire fine amount has been deposited before the trial court,
Yes, my lords.
which is agreed and accepted by learned counsel for respondent. Respondent is present. And to compound the offense, list this matter on Wednesday, 18th.
Yes.
December 43.
Petitions.
Prakash MH.
Milord, kindly pass over. Milord, senior is in another.
Pass over.
Passover, December 44 adjourn, December 45, Sri Ajay Kumar, Sri Ajay Kadkolti, SPP.
Offense is 406,
Called
420.
Ajay.
The net session judge rejected the application and issued summons against the accused 1 to 4. That they are committed the offense under section 420, 406. The order.
Right, we'll pass over the matter. See, he may come. There's a filed application for stay.
December 46 adjourn, December 47, Sri Prakash KV, Sri Prasanna Kumar P.
Alteration of charges ka application case. Alteration of charge. ಅದರಲ್ಲಿ ಅಲಿಗೇಷನ್ ಬಂದು 44,12,000 ಇವ್ರ ಮೇಲೆ ಆರೋಪವಿತ್ತು ಸ್ವಾಮಿ, ಏನ್ ಲಾಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಬಟ್ ಅದು ಲಾಸ್ ಅಲ್ಲ, ರಿಕವರಿ ಮಾಡೋದು ಲೇಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಆಮೇಲೆ ರೀಸೆಂಟ್ ಆಗಿ ರಿಕವರಿನೂ ಆಗಿದೆ, ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಸೀಸ್ ಮಾಡಿ ಎಂಟೈರ್ ಅಮೌಂಟ್.
You filed application under 216.
Yes, sir.
Which accused are you?
Accused number 1 and 2 ಇರ.
For altering the charge?
ಹೌದು.
What's the
ಅವರಿಬ್ರು
offense?
ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರು ಮತ್ತೆ ಸೀನಿಯರ್ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್. ಸೀನಿಯರ್ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರು ಅಂಡ್ ಇನ್ನೊಬ್ರು ಮ್ಯಾನೇಜರ್ಸ್ 1 and 2 are. A3 ಬಂದು ಅಕ್ಯೂಸ್ಡ್. ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಸೀಸ್ ಮಾಡಿ ಎಂಟೈರ್ ಅಮೌಂಟ್ ರಿಕವರಿ ಆಗಿದೆ. ರೀಸೆಂಟ್ ಆಗಿ ಅದ್ರದ್ದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ. ಈ ಫೈಲ್ ಮಾಡುವಾಗ ಅದು ರಿಕವರಿ ಆಗಿರ್ಲಿಲ್ಲ.
So matter is the state.
Swami.
Stay is ordered.
Oh.
All right, admit.
My lords, may be permitted. Lords, my senior has argued in this matter in part. My lordship was pleased to hear. My lordship was pleased to grant leave to place citations on record in further of our contentions. May be permitted to.
ನೀವು argument ಮಾಡಿದ್ದೀರಾ?
ಹೌದು ಸರ್.
Both of you have argued. Is it?
ಹೌದು.
Yes, my lord.
What's the why then admit it can be disposed of?
Yes.
Give me.
Yes. Lords, one.
This is Bela Trivedi's judgment. I think this is recently passed.
Yes, my lords.
I've read this judgment.
Yes.
Passed on.
My lords, two contentions we have urged in this petition, my lords.
Yes.
My lords, the main contention is, my lords, once discharge is rejected, 216 is not maintainable. The challenge under 216.
Read that. Where is it?
My lords, I flagged the relevant para.
Yes.
Lords, may I take this quote to para 10, my lords?
Yes.
4 lines from the bottom, the court, start from the court.
Yes.
Thank you. The court exercising revisional jurisdiction under section 397 should be extremely circumspect in interfering with the order framing the charge and could not have interfered with the order passed by the trial court, dismissing the application for modification of the charge under 216 CRPC, which order otherwise would fall in the category of an interlocutory order. That may be permitted to read para 12, Miller.
1 minute, 1 minute. Section 2, which otherwise would fall in the category of an interlocutory order.
Yes, ma'am.
So 216.
Yes.
Is it appealable?
That is exactly why, my lords, Supreme Court discusses that 397 cannot be exercised for an interlocutory order.
Yes, read further.
Yes, my lords. My lords, in para 11, my lords, may I take my lords to line 5, my lords, section 216. The next parameter, para 11, line number 5, section 2.
Read it from the starting.
Yes, my lords. It is tried to say that section 216 is an enabling provision which enables the court to alter or add to any charge at any time before judgment is pronounced. And if any alteration or addition to a charge is made, the court has to follow the procedure as contained therein. Section 216 does not give any right to the accused to file a fresh application seeking his discharge after the charge is framed by the court. More particularly, when his application seeking discharge under section 227 has already been dismissed. Unfortunately, such applications are being filed in trial courts, sometimes in ignorance of law and sometimes deliberately to delay the proceedings. Once such applications, though tenably, are filed, the trial courts have no other alternative but to decide them. And then again, such orders would be challenged before the higher courts and the whole criminal trial would get derailed.
Yes, ma'am. Read further.
Yes, ma'am. Such it is to say that such practice is highly deplorable and if followed should be dealt with sternly by the courts.
So in this case, an application for discharge was
Rejected, my lords.
rejected.
Yes, ma'am.
Then he files 216
Yes, my lords.
by same accused.
Yes, my lords.
Your accused number,
1 and 2, Your Honor.
your application for discharge was rejected.
Yes, sir. Yes, sir.
Fact is correct.
Discharge, not discharge, Your Honor. Only alteration of charges.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ discharge ಹಾಕಿದ್ರ
ಹೌದು ಸರ್.
ಹಾಕಿದ್ರ ರಿಜೆಕ್ಟ್ ಆಯ್ತಾ?
Reject ಆಗಿದೆ.
Then you filed 216
ಹೌದು.
for alteration of charge.
Charges.
This is applicable to you. What is the other judgment you have?
Lords, the second citation is a coordinate bench of this honorable court, my lords.
Ah.
The second contention is, my lords, after witnesses have been examined, the higher court or the trial court cannot examine as to the alteration of charge, my lords.
Which para?
My lords, may I take my lords to para 17, my lords?
Yes.
My lords, taking into consideration the fact that natural risk, my lords, these are the facts, my lords. The relevant portion starts at the bottom line, my lords. By taking into consideration the entire charge sheet material and conduct of the accused, charge has been framed by the trial court. Subsequently, it cannot go back and pass the order like one which is challenged before this court. As discussed above, after framing the charge and recording of the evidence, court becomes functus officio, and it cannot alter the earlier order of framing of the charge. In that light also, learned trial judge has erred in passing the impugned order. As such, it has to be interfered. It's almost 17 witnesses have been examined, my lords.
In your case?
Yes, my lords.
So after that, he files for 216
Yes, my lords. In
alteration.
fact, after that, this honorable court was pleased to stay the process.
Your stay was granted.
Yes, my lords.
When?
But stay was granted. My lords, I'll just.
Doesn't appear. Huh? Stay was granted?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ.
Really, the stay. What has happened to the proceedings? Is it culminated or pending?
It's pending, my lords.
Pending.
This is coming up for the first time.
Yes.
No order of stay is granted. Do you file any application? Okay, ಬರ್ಕೊಳ್ಳಿ. That's all. You want to submit anything?
ಅಷ್ಟೇ ಸರ್.
So you're accused number 1 and 2. is it?
1 and 2.
Oh, this was argued by Prasanna.
Yes, my lords.
ನಿಮ್ ಕಡೆಯಿಂದ ಯಾರಿಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು? Who argued on your behalf?
ನಾನೇ ಸರ್.
You argued?
ಹಾಂ ಸರ್.
Did he argue the matter?
But he was
I don't
present.
remember hearing you. Before me.
ಇಲ್ಲ ಈಗಷ್ಟೇ ಸುಮ್ಮನೆ ಆರ್ಗ್ಯುಮೆಂಟ್. ಈಗಷ್ಟೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
ಈಗಷ್ಟೇ ಅಲ್ರಿ, ಮುಂಚೆ ಆರ್ಗ್ಯುಮೆಂಟ್
Lords,
ಮಾಡಿದ್ರು.
on the last occasion, petitioner counsel was not present.
ಮುಂಚೆ ಮಾಡಿರ್ಲಿಲ್ಲ.
ಇಲ್ಲ.
What is your case? Why you should, the alteration should be done? Who are you?
ಪ್ರಕಾಶ್.
Who is he? Bank manager, is it?
Yes, my lords, bank officials, both are back.
What is his role?
My lords, the role against,
PC Act is invoked.
yes,
PC Act.
Yes.
What is his role?
my lords,
Some cheating and forgery and fraud.
yes, my lords. On,
He has colluded.
yes, my lords.
Record. This petition is filed by the
The charge, my lords, will find at page 18, my lords, against the
1/8.
1/8.
This is the most rampant nowadays in all the banks.
The Supreme Court was in fact taken a stern view in this recent judgment, my lords.
Especially by the bank managers. Bank frauds, overdrafts, loans, creating an account, opening an account, giving, and one day either he's there or resign or retire and go home.
Extending inland credit facilities also. my lords.
Petition is filed by the accused number 1 and 2. Challenging the order passed by the special judge in special CC 73 of 2016. Dated 24/11/21. Whereby the application filed by the accused number 1 and 2 that is the petitioner's herein under section 216 of Code of Criminal Procedure came to be rejected. Wherein the accused 1 and 2 had sought for alteration of the charges. Full stop. It is the vehement contention of learned counsel for the petitioner that the impugned order passed by the learned special judges perverse, arbitrary, illegal, and is a patent error apparent on the face of the record, and hence the same requires to be set aside. And consequently, the application filed by the petitioner accused to be allowed. It is contended by learned counsel for the petitioner that the bank's internal accounting procedures and whether accused number 1 and 2 have caused any loss to the bank would be in the better knowledge of chief auditor of the bank, who has conducted internal special investigation and has provided the report.
Fact, my lords, they took up a contention before the trial court that it is the panel advocate who is responsible because he has given an opinion to extend credit facilities.
According to him, the question is whether the loss so caused is attributable to any staff, which has been answered as no by the chief auditor. Therefore, according to him, it is conclusively proved that there was no loss caused by accused number 1 and 2.
Yes.
It is also contended by learned counsel for the petitioner that the mortgaged property is intact and the question of loss does not arise. It would probably only be a case of recovery process which is getting delayed. It is contended by learned counsel that the provisions of section 216 contemplates alteration of charge which could be made by the trial court. In the present case, there is no material to show that any loss has been caused due to the act of accused number 1 and 2. And a charge has been framed against the present accused for the offences punishable under section 120B, read with section 409, 419, 420, 467, 468, 471 of IPC. Just correct me if I'm wrong.
Yes, ma'am.
And sections 13 within brackets 2, read with section 13, capital within bracket 1, capital C within bracket and small d of Prevention of Corruption Act 1988. Charges framed for these offences.
Yes, my lords. A1 and A2 are public servants.
It is also contended by learned counsel that the charge framed by the learned special judge is erroneous on the basis of incorrect material statements, false accusations made against accused 1 and 2, contrary to the internal audit report. Therefore, the charges framed would have to be altered.
No, it's in fact only one section, my lord. Section 420 has to be dropped is what they claim.
According to them,
Is there
as per
contention?
the application,
Yes, my lord.
not all.
Not
others.
all, not all.
Where is your application?
Application, my lords will find at page 24, my lords.
So whether in the prayer they have sought only for 420,
Lords, under the case they have sought for an entire-
467 and 68. Full stop. In the application, learned counsel for the petitioner before the trial court has pleaded to drop the charges for the offense punishable under section 420 and 467 and 468. Therefore, the application under section 216 came to be filed. That application was, you filed objections?
Yes.
Was seriously opposed by the respondent state on the ground that the said application is not maintainable. On the ground that once the charge has been framed against the accused persons, the question of alteration of the charge would not arise. And since there is a invocation of 120B of IPC, all the conspirators are to be held liable for the offences equally. And so also cases paid out against the accused 1 and 2 for the offences punishable under 420, 468, 467, 68, and all other offences for which charge has been framed. And it is vehemently contended by learned counsel for the respondent that no material and cogent reason has been placed on record to show that to alter the charge already framed by the court. It is also contended by learned counsel representing the respondent that on the earlier occasion, an application for discharge came to be filed by the accused number 1 and 2. Same has been rejected.
Yes, ma'am.
They did not challenge that?
No.
Same is rejected, pursuant to which evidence also recorded.
Yes, my lord. 17 witnesses have been examined.
Evidence of the prosecution witnesses PW1 to PW17
Yes, ma'am.
is recorded, after which the present application is filed, which prima facie goes to show, that the application is filed only to protract and delay the proceedings. It is also vehemently contended by learned counsel for the respondent that the trial court has considered the submissions of learned counsel, appreciated the provision of law, and not being satisfied with the contentions taken therein, has rightly rejected the application, which does not call for interference at the hands of this court. Full stop. Learned counsel for the respondent, Shri Prasanna. What, B Prasanna, na?
P. Prasanna Kumar.
P.
Yes, ma'am.
Shri Prasanna Kumar P.S. has relied on two judgments in support of his case. One of the Honorable Apex Court reported in 2024 SCC online SC 2283 between K. Ravi versus State of Tamil Nadu and another. And a coordinate bench judgment of this court reported in 2021 Karnataka Law Journal 819. I have heard learned counsel for the petitioner and learned counsel for the respondent. The point that arises for consideration is whether petitioner is made out a ground to show any illegality, perversity, or patent error committed by the trial court, within bracket special court, while passing the impugned order. What order? The facts are not in dispute with regard to the offences charged against the petitioner accused 1 and 2, as stated here and above. It is also not disputed that accused number 1 and 2 had filed an application for discharge, which came to be rejected by the trial court. Thereafter, evidence of the prosecution witness PW 1 to 17 is adduced, and thereafter the present application is filed. Mr. Counsel, two aspects will arise here. One is the non-maintainability of this.
Yes, ma'am.
The second is on merits itself.
Yes,
So that is what is held by the apex court here.
yes, ma'am. That it is not permitted at all to entertain such.
Vehement reliance is praised by the learned counsel for the respondent in the case of K. Ravi stated supra, wherein the Honorable Apex Court at para 10 has held as under extract para 10 marked in red.
Para 10 and para 11.
And para 11 also. Full stop. On on careful perusal of the provisions of section 216 of the Code of Criminal Procedure, you've seen that 216 states reads as under extract 216 of CRPC. Two contentions are and legal issues arise in view of the judgment rendered by the Honorable Apex Court. Firstly, whether the application filed under section 216 of CRPC could be considered by the trial court pursuant to an application filed for discharge being rejected by the very same at the instance of the same accused. Secondly, whether the orders passed under section 216 of CRPC would fall within the category of an interlocutory order. Thereby falling within the category of section 397 subclause 2 of CRPC, which bars the revision petition, filing of revision petition on any orders that is passed on interlocutory orders. Full stop. As held by the Honorable Apex Court, section 216 is an enabling provision which enables the court to alter or add to any charge at any time before the judgment is pronounced. The Honorable Apex Court has further gone on to hold that section 216 does not give the right to the accused to file a fresh application seeking his discharge after the charge is framed by the court. And in the present case on hand, admittedly, charges were framed, an application was filed seeking discharge, which came to be dismissed, and thereafter the present application under section 216 is filed. Full stop. Therefore, in the present case on hand, when charge has already been framed by the court, it was open for the petitioner to have filed an application at the relevant time for alteration of the charge if he had not filed his application for discharge, to alter the charges on the grounds that is urged by him. But pursuant to an application filed for discharge being rejected, seeking to file an application to alter the charge thereafter under section 216, in my humble opinion, would not give the right or to the petitioner accused who filed such an application for alteration of charge, which has also clearly been held by the Honorable Apex Court. This is apparently clear that this said application is filed only for the purpose of protracting and dragging the proceedings, and not with a true intent to either alter or alter the charge framed by the court. It is also relevant to see that in the present case, prosecution has examined 17 witnesses,
Yes, ma'am.
and thereafter this application is filed. Under the circumstances, this court does not find favor with the petitioner accused having filed the application and having approached this court on a challenge made to the correctness and legality of the orders passed by the trial court. It's also relevant to note that the court, which has framed the charge and rejected the discharge application, cannot go back to alter the charge, which is not permissible. Full stop. Under the circumstances, I pass the following order. This petition is dismissed. What is the stage of the trial court proceedings?
That's 17 witnesses have been examined. 6 to 7 witnesses are remaining, my lords. That's all.
Petitioner shall proceed further in the trial, and in case he further files any other application similar nature to drag on the proceedings, trial court is at liberty to impose exemplary costs on the petitioner accused. I am not imposing cost here.
Grateful for the opportunity.
ಇನ್ಫ್ಯಾಕ್ಟ್ ಏನಾಯ್ತು ಅಂದ್ರೆ
Yes.
ಅರ್ಲಿಯರ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗತ್ತೆ ಅಂತ ಮಾತಾಡಿತ್ತು.
Huh?
ಅರ್ಲಿಯರ್
Huh.
first you now malad the accused wants to settle malad the first case criminal revision petition 555. ಅದು ಅಮೌಂಟ್ ಟೋಟಲ್ malad the
13,75,000.
13 lakhs ಇದೆ.
75,000.
ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ತೀನಿ ಒಂದು 4 months ಗೆ ಇನ್ನೊಂದು ನಾ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಲ್ಲ. Let the amount may be which has been deposited before the trial court can be released in your favor ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರಂತೆ. malad now malad if both cases compromise ಆದ್ರೆ ಸರಿ, otherwise malad amount may be released with respect to malad the second case. With respect to malad the first case malad 23rd may be given malad my party has to take instruction. ಯಾಕಂತಂದ್ರೆ they have also filed a suit for malad the recovery of malad the interest since
is
it is a commercial one.
What is the amount deposited in the second case?
Second case is 10 lakhs rupees, my lords.
You have
Total
depo-
fine amount is 20 lakhs. We have 50% of the amount we have paid.
Deposited.
Yes, your honor, before the trial court.
ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಇನ್ಫ್ಯಾಕ್ಟ್ malad we have also filed it is a commercial transaction. malad the interest part has to be I may permitted to malad go with respect to malad the civil case. With respect to malad this offense is it can be malad the closed, but I have to malad the present before the court malad my party 23rd may be date may be given. On the very same day malad if one case he is going to withdraw, he is going to malad the compromise, then malad we are not ready. In ಇದ್ರೊಳಗೆ ಇನ್ನೊಂದು ಕೇಸು let him take malad another 4 months, let him clear the both the cases.
First, we have withdraw that first one. We are ready to settle.
No, he is not agreeable.
ಅಂತಂದ್ರೆ ಎರಡು ಕೇಸಿಗೆ ಟೈಮ್ ತಗೊಂಡ್ಬಿಟ್ರೆ ಒಂದಕ್ಕೆ otherwise malad the court cannot grant the time for another 4 months without any ಇದು.
Very difficult. Your
Both
honor.
are connected or both are separate?
ಅಲ್ಲ
Both are separate. Your
both are separate
Separate,
ಆದ್ರೂ
separate
transaction totally different ಆದ್ರೂ both complainant as well as the accused one and the same.
Transaction is different.
Yes, and the same hand loan.
Same.
Transaction is same.
Same transaction is same. ಅವ್ರೇನ್
How
ಹೇಳ್ತಾರೆ
it will affect you if you compromise the first matter?
ಅಲ್ಲ since he has come forward only to compromise the first case, ನಾನು ಎರಡರೊಳಗೆ I am not in a position to pay malad ಕೊಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಇನ್ನೊಂದು 4 months ಅದಕ್ಕೆ ಸುಮ್ ಡೇಟ್ ತಗೊಂತೀನಿ ಅಂತ ಅನ್ನೋ I cannot malad seek date without malad any joint memo from the accused.
Because
Second
civil
case
court
now
is-
they have to compromise.
Regarding interest, the civil court is they filed the civil suit also, your honor. Only first we deposit first case, your honor, 555. Then after clearing of first case, then you will pay the another second case, your honor. That is 10 lakhs rupees for the second case. First case is only 6,75,000 is balance. In 4 months, 4 installments you will pay, your honor. Monthly 1,68,000 we will pay. And he is also agreed, but now they are saying that second case is
ಅಲ್ಲ
also.
ಎರಡು ಕೇಸ್ ನ ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ಬಿಟ್ಟು ಇಟ್ ಇಸ್ ಬೆಟರ್ ಅಂತ ಯು ಫೈಲ್
Yes.
ಬೋತ್ ಕೇಸಸ್ ಟೇಕ್ 6 months or 4 months.
No, the second case is they withdraw the deposit amount, then will.
Totally. Order sheet ಕೊಡಿ. So in the second case, it is 20 lakhs. is it?
Yes, your honor. 20 lakhs. Check amount is 15 lakhs, fine amount 20 lakhs. ಅದರಲ್ಲಿ including we deposited including interest ಅಂತ ಹೇಳಿ ಮೆನ್ಷನ್ ಆಗಿದೆ ಸ್ವಾಮಿ. Then again seeking for civil case ಅಲ್ಲಿ interest pay ಮಾಡ್ಬೇಕಂತ ಹೇಳಿ they have
Learned counsel for the petitioner and respondent are present. Counsel for respondent is filed. IA number 1 of 23. Seeking release of the amount deposited by the petitioner. Learned counsel for respondent petitioner does not have any objection
No objection.
in the amount being withdrawn or dispersed in favor of a respondent complainant. Hence, being satisfied with the reasons assigned and cost shown in the affidavit, this court deems it appropriate to allow the application. Hence, IA number 1 of 23 is allowed. Respondent complainant is permitted to withdraw the amount deposited by the petitioner before the trial court. Full stop. The trial court shall disburse disburse the amount deposited by the petitioner before the trial court by way of electronic transfer upon respondent furnishing relevant bank details on proper identification. Call this matter after 2 weeks.
Date may fix.
Date will be given.
Yes, 27, not 30th. Okay.
30th, I will be not in station. No, yeah, I will be in Davangere. Sorry, my lord. In fact, 30ಕ್ಕೆ ಇರೋದಿಲ್ಲ. 26th ಆದ್ರೆ ತೊಂದ್ರೆ ಇಲ್ಲ.
26th.
26th.
Call
Please.
26.
Revision by
Yes, sir.
the
Your Lordship,
accused.
a humble submission. 4 checks were given. All the other 3 checks cases have been completed, the trial court. The judgment is produced along with this.
Copy Kudi. It is a stage of admission, my lord. It is for me to convince your lordship. And
Your Lordship, the 3 together he has cross-examined in length. And the trial court has found that he is guilty.
now, so
Found
far
what?
as
Found what?
Found he is guilty and he has to pay. Each one, the first check was 4.5 lakhs.
File this case.
We have filed the case.
You are a petitioner here
I am the respondent here, Your
and
Lord.
wait for your turn.
Please, Your Lordship.
Lord, this is a matter where the accused has referred this revision petition. My lord, the records were called for. It seems the records were not received by this honorable court. If the records are received, I have also filed an application for seeking leave to lead evidence and also to recall PW1 and to cross-examine PW1. My application is also there. Therefore, my lord, my submission is a matter which is required to be remanded for consideration. And so far as the merit is concerned, my lord, the notice itself is a defective notice. The check amount is 3,50,000, whereas the notice is issued, notice at exhibit P8 is issued for an amount of 17 lakhs. So that is not in compliance with the section 138 Negotiable Instruments Act. Then, my lord, plea and the statement under section 313 were recorded simultaneously. Now, it's a case of summary trial. The procedure to be followed is a summons case. Now, in this case, my lord, insofar as summons case is concerned, my lord, the plea will be recorded the moment the accused appears before the court and before the commencement of evidence. Statement has to be recorded only at the fag end after the conclusion of the evidence of the complainant. After the completion of the prosecution evidence, then the statement under section 313 has to be recorded. Whereas in this case, my lord, both are recorded simultaneously and then the matter is posted for cross-examination of PW1. This is a procedural irregularity. And even otherwise, my lord, he could not appear before the court, before the trial court because of various reasons, my lord. Then, my lord, in his absence, the judgment is passed. The learned magistrate had ordered for issue of NBW. And without securing his presence, even when the NBW was pending, my lord, the learned judge just passed the judgment of conviction. Therefore, my humble submission is, my lord, it's a matter which requires to be remanded. Therefore, the records may be called, my lord.
You have deposited the amount?
This
order sheet code. Suspension is ordered.
The time is there till 21st. 20% was deposited in the trial court, my lord. For the remaining amount, there is time till 21st of this month, my lord.
Yes, now you can.
Your Lordship, totally 17 lakhs is the checks paid.
One transaction?
It is for one transaction. He has splitted it as 4.5 lakhs, 4.5 lakhs, 4 lakhs, and last one 3.5 lakhs. Altogether 17 lakhs.
Same day it was given.
No, different dates. 1 month difference it was given.
All are related to the same transaction.
Same transaction, Your Lordship.
In all other cases, he has been convicted.
Yes, Your Lordship.
You have challenged those?
My lord, I don't have instructions so far as the other cases are concerned, my lord. Only this case has come to me.
When is that order?
3rd September, Your Lordship.
3rd September, just
2024.
this month only, last week. You'll be having time for 1 month.
All were tried together?
All were tried together, only Your Lordship.
It is incorrect
One
submission.
cross examination for all the 3 in length.
They were tried differently, separately. It is not a common evidence,
It was a common.
but the common judgment is not passed.
No, it was separately passed. But he has taken that.
There was no
same-
common trial, my lord.
What's the name of your client?
My client is Chandrasekhar, H.M. Chandrasekhar.
You have examined yourself?
In this case, no, my lord, we are not even cross-examining the
case?
PW1.
The other case?
Other case, I have no instructions, my lord, because
Page
not
number
appeared in the
5, Your
trial court, my
Lordship.
lord.
The accused
I am
got
appearing only
examined
before this
himself as
honorable court in
PW1
this
and
matter
no
only.
documents are marked from his end.
Only in this case, I am appearing, my lord, not in other cases. Therefore, I don't have any instructions. Because in fact, I was unaware about the conviction in the other cases. Said to have been passed on 3rd of
You
this
comply
month.
the order, deposit the amount. You'll admit the matter and hear it. Record. Admit. Check your records. Hold on. So you may get 3 more cases now of the conviction. Now he has given you information, Stanley has given you.
I have to say whether he comes to me or he goes to somebody else. Grateful.
What is the transaction?
Your Lordship, it was for an apartment which he was building. He has given some 16.45 lakhs.
You are buying the apartment.
Yes. And
He did not give that.
no, and when we inquired over there, he has done it for different other people also.
Several other people.
Several other people. Yes.
So he's a builder.
He is into real estate, he is telling, but he was doing that one. Upon that guise only, he has taken the money.
You can file an application for withdrawal if you want. We'll consider that. Amount he has deposited, he would deposit.
We will do it in the lower court, Your Lordship. Or
You file. Yes, he got still time. Let him deposit.
please,
Then you can file.
please, Your Lordship. Oblige, Your Lordship. The date is given or
Date.
30th. Oblige. Your Lordship.
Madam Lakshmi, I have disposed of that matter. You're waiting for that.
On request, Your Lordship. After disposing the matter, if she is entitled, let her withdraw that, whatever it is deposited. Because after divorce, they are not entitled for except the child. Wife is not at all entitled. So if she is entitled, let her withdraw the deposit amount. That sentence to be added, Your Lordship.
No, how? Any proceedings is still pending?
No, proceedings are not still pending. But only in respect of divorce petition, it was divorced in the division bench. Against that order, they did not approach any Supreme Court or something.
Divorce is granted.
Yes, please. So she is not entitled, her child is entitled and petitioner's mother is entitled. She is also alive. That's why if she is entitled, let her withdraw. Only son is entitled, but not the wife.
Oh, that will create a further litigation. And nobody will get, it will be lying in the court or it will go to the state. She will not
But
benefit.
mother is also there, Your Lordship. She may entitle.
No, the amount you have already deposited, some amount,
Some amounts are.
that will go to her.
Child is entitled, not the wife,
All
according to
right,
me.
child only,
Yes, please.
child or mother, whoever
Child
is,
and mother,
whoever
not
is,
the wife.
Madam, whoever is succeeded before the trial court
Yes, please.
will benefit the order because of the death. Now, whether child is, mother is divorced, not divorced, nimde case, Mr. Sukumara. I was telling her that I've already disposed that case.
Yes.
So she wanted to, she's making a submission that if you are entitled to,
Whichever she is entitled,
if at all she is entitled, is what she's trying to say.
because his mother is alive.
Who's the petitioner's mother?
Petitioner's mother, Pushparaj's
My
mother
lord,
is there.
Very simple is that, my lord.
See, you have lost the case for maintenance.
Yes, please.
She succeeded. She'll be entitled to recover the amount which you have already deposited, number one. Number two, for the estate, she will be entitled to recover whatever she's entitled as per law.
As per the
It's
trial
okay.
court order.
No,
As per the order of the trial court.
whatever it is okay, but.
I am
the-
not going to again
yes,
probe
please.
onto the matter. This
No,
court
my
is
lord.
not a fact-finding court.
My lord, the very simple is that the petitioner before the revision petitioner is that is passed away. The suit gets, that case gets abated. And whatever the trial court proceeding, that will take a law into
Yes,
the own court.
yes.
That is not before your lordship.
Yes.
So what has happened? And she, last time also, a colossal ignorance, she said, I'll make a legal ARC, LRs and all. That will not arise in this case. So I just kept quiet. I said, okay, let her, she consult a senior and come back. That is your lordship wanted, I filed it. Now, as for this revision petition is concerned, it gets abated after the report of a death. There ends the matter.
All
Yes, madam.
That cannot be done.
Yes.
Yes,
This-
she is
that-
entitled, whichever she is entitled, not all.
No, but that also cannot.
Whatever order is passed by the trial court, this court is not abating the proceedings. Not abate. This is closing.
Yes.
Abatement means everything comes to an end.
Yes, please.
This
In respect
closing,
of the petitioner.
closing leaves reserving liberty to him to recover in the manner known to law. Manner known to law is again open for you to go and challenge if there is any recovery proceedings.
Yes.
Yes, next.
Number 50, Sri Hemant Kumar Sir, Sri P. Nataraju.
Here for petitioner, my lord, in 593 of 2022, my lord, the 50% deposit has been deposited, my lord. In the my humble submission, my lord, in 855 of 2022, I filed an application for extension for deposit the amount, my lord. The matter may be settled, my lord.
Howda?
We have
Settlement is going on, my lord.
Then you talk for settlement. no?
and maybe no objection to withdraw the amount, my lord.
We'll extend the time.
Yes, my lord. Time may be extended, my lord. In first matter, my lord, they are deposited 50%, my lord. It may be withdrawn.
How much time you want?
2 week, my lord.
Work colleague. Learned counsel, madam, your learned counsel for the petitioner submits that the negotiation for settlement is midway between the parties. Which is affirmed by the learned counsel for respondent. In criminal RP 593 of 2022. Madam, other orders and the mail, I put criminal RP 593/22 on that. You have filed any application?
No, my lord, not application.
Learned counsel for the, you have deposited?
Yeah, please, my
Learned
lord.
counsel for the respondent makes a oral request to permit him to withdraw the amount deposited by the petitioner. Learned counsel for the petitioner fairly submits, he would not have serious objection in respondent withdrawing the amount, as settlement talks are midway. Full stop. Under the circumstances, respondent is respondent is permitted to withdraw the amount deposited by petitioner before the trial court.
Trial court, man.
Trial court. Full stop. The trial court shall release the amount deposited in favor of respondent complainant by way of electronic transfer upon furnishing relevant bank details on proper identification. Full stop. Next, orders on in criminal RP 855 of 2022 on IE number 2. This application is filed by the petitioner seeking extension of time to deposit the amount as ordered by this court on 7/7/22. Peruse the affidavit and the submissions of and on hearing the submissions of learned counsel for petitioner, 2 weeks' time is further extended from today to comply the order. Dated 7/7/22, correct?
Yes, please, my lord.
Call this matter on. When you do settle?
30th, my lord.
30th. Let's call this matter on.
My lord, one submission, my lord. Trial court record to be sent back to the trial.
Call this matter on 30th. Registry to send back the trial court records. In both the cases.
What's up?
And secure the same.
Number 52.
Better secure, madam. Send back the records. I think you may probably settle the matter. Let it be. Send back the trial court records.
Number 52. Sri Santosh.
I appear for the respondent counsel, your lordship.
I appear for the appellant. But there are
Based
two
on the
cases- There are two cases initiated against the petitioner, my lords. 2 checks have been involved. So I have, as per my instructions, the petitioner is making attempts to settle the matter with the parties, my lords.
So what do you say, Mr. Ravi Kumar?
I have not received any instruction from the party regarding the settlement, your lordship. Only thing I received the instructions
There
that
are 2
based
checks
on
involved.
order-
One is involved in this case, my lords, and another case is also been initiated against the petitioner for the said Kadur court.
What is that number?
My lords,
Division is filed by you.
no, my lords, it's still pending in the trial court, my lords. Still pending in the
Same
trial court.
party.
Same party.
You speak to your friend.
I'll speak.
You speak to him and see if it can be settled. I list it next week. You report settlement if any.
Please.
Learned counsel for the petitioner submits that petitioner is inclined to settle the matter with respondent. He is liberty to do so. List this matter on 27th to report settlement if any.
Much obliged.
53 adjourned. Number 54. The Nagaraja. The Sukumaran.
For the petitioner in this case, my lord. This case, in this second matter, first matter, my lord was pleased to grant order of stay. The direction to deposit 1 lakh rupees and pay the monthly maintenance. I am filing the acknowledgement for having paid the amount, my lord. Transferred it to NEFT to the petitioner's account furnished. Sorry, respondent's account furnished. In the first matter, my lord, there were the other side has NEFT do acknowledgement ಇದೆ. Counter files memo ಜೊತೆಗೆ 1 lakh ಮತ್ತೆ 7,000 ಅಂತ ಇದೆ. ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್ ಅಕೌಂಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ.
ಯಾರಿಗೆ ಮಾಡಿದ್ದೀರಾ ಇದು?
ಅನಿತಾ ಅಂತ ಇದೆ.
ಎಷ್ಟು ಅಮೌಂಟ್?
1 lakh ಫಸ್ಟ್ ಇದ್ರಲ್ಲಿ
ಅಲ್ಲಿ ಅನಿತಾ ಹೆಸರು ಮೇಲ್ಗಡೆ 1 lakh ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಕೆಳಗಡೆ 7,000 NEFT ಮಾಡಿರೋದು ಎರಡೂನು. ಅವ್ರ ಅಕೌಂಟ್ ಫರ್ನಿಶ್ ಮಾಡಿದ್ರು ನಂಬರು, ಅದಕ್ಕೆ ಕಳ್ಸಿದೀವಿ. So compliance of the order of this honorable court is from my side I have done, needful is done. So far as the other side has raised objections with regard to maintainability of the proceedings, this 397 proceedings, I was directed to address on that issue. The facts of the case are, my lord, the respondent herein has filed initiated proceedings under DV Act, and interim order of maintenance and rental allowances was granted. Against that interim order, I have filed appeal before the district sessions court under section 29 of the DV Act. In DV Act proceedings, they have also, they are in the respondent herein has also challenged the order of trial court for enhancement. My appeal came to be dismissed for setting aside of the trial court order, and their appeal was allowed and the amount was enhanced to 10,000. 7,000 was granted in all, 4,000 plus 3,000. That was enhanced by additional 3,000, total 10,000. And against which I have assailed before my lords in the 2 revision petitions. 397 may kindly be, I may be permitted to read 397 CRPC.
What is it? So what is challenged in the second matter?
The second matter, the order of appeal court passed in their appeal, enhancing the amount 3,000. And in that, the previous bench has passed, the trial court shall not take any coercive actions. That has to be kept in abeyance because in view of the order passed in the first case.
So it was enhanced to 6,000 per month.
And to another one 4,000
for main petition.
3,000
totally 10,000 was granted.
What was granted by the trial court?
7,000, 4,000 plus 3,000. That was enhanced by 6,000 and 4,000, totaling 10,000.
Lordship.
And the 397 proceedings are filed before my lords in the present
All right.
revision.
So 7,000 to 10,000 it is made.
And in the 876 main matter, my lord, that is challenging my dismissal order. In that, my lord has directed me to deposit additional 1 lakh rupees. And to pay the monthly maintenance directly to the respondent's account. That just now I filed a memo to that effect. I have completed the interim order. The order was on 12th of August. On 6th of September, before expiry of 1 month, 4 weeks was granted. Before expiry of 4 weeks, I have deposited that amount.
All right.
397 proceedings, they have questioned that the maintainability of the proceedings, my lord. 397, I may be permitted to read.
Lordship, before can hear the matter, there is a deliberately, intentionally, a wrong account number has been furnished. I have been checked up, I did not get my amount to the credit. The parties before this court. And I have furnished, it is intentionally, I don't know deliberately or what, but the account number has been wrongly furnished, not credit to my account. So Lordship may direct these parties to, because it is getting expiry on 7 and another 3,45,000 is there. Let them correct the interim maintenance and it may call on 17th, my lord.
This is the check and account
DD,
number
they-
was. Let me.
FDF, my lord, both I have furnished everything, even the cross check also I furnished. I am not able to get this amount in spite of 4 years. My lord, I am here. I am holding it. Memos, they should have given a memo earlier. I would have pointed out to them.
From Canara Bank, I have transferred
whichever
whatever
bank
the
my lord,
account
you should-
number he has furnished.
Should come to my.
I will get that document and furnish to them.
I am here, I am furnishing here, my lord.
ಅಲ್ಲ ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ ನಾನು I am not disputing.
No, you have deposited the amount to the account of Mrs. Anita,
Yes.
correct?
ಅಲ್ಲ NEFT ಮಾಡಿದ್ದೀನಿ.
ಅದೇ NEFT ಅಕೌಂಟ್ಗೆ ಮಾಡ್ಬೇಕು.
ಅಕೌಂಟ್ಗೆ ಮಾಡಿರೋದು ಸ್ವಾಮಿ.
ಯಾವ
ಅದು
account?
ಅಕೌಂಟ್ ನಂಬರ್ ಡೀಟೇಲ್ಸ್ ತಗೋಬೇಕು ಸ್ವಾಮಿ. ಅವ್ರು ಅಷ್ಟು ಮಾತ್ರ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ತಂದಿದ್ದಾರೆ.
Why he will send it to wrong account?
1 ಲಕ್ಷ ರೂಪಾಯಿ
I had told
how
you
I
this thing.
can.
The account, your lordship has passed an order, I should furnish the detail of my account number. The second day itself, I furnished, a copy is furnished here. The checkbook, account number, everything.
Now, how do you say it is not complete?
Now only he has furnished a memo for which account is, it's
ಅಲ್ಲ ಅವ್ರ
credited.
ಅಕೌಂಟಿಗೆ ಬಂದಿದೆಯಾ ಇಲ್ವಾ ನೋಡಿ ಹೇಳ್ಬೇಕು
ನಮ್ಮ
ಆನ್ಲೈನ್ ಅಲ್ಲಿ.
account ಬಂದಿಲ್ಲ, I have one number extra ಹಾಕಿದ್ದಾರೆ, it's not come to my account.
Where is that memo?
Before your lordship.
ಅದೇ ಅವರೇ ಚೆಕ್ ಕಳ್ಸಿರೋದು.
Where is that
ಹೌದು.
memo?
ಅದೇ ಇದಕ್ಕೆ
The
ನಾವು
memo,
ಕಳ್ಸಿದೀವಿ.
ಇವಾಗ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ರಾ?
ಕೊಡಿ ಸರ್.
You give the memo here also?
ಹೌದು ಹೌದು ಈಗ ಜಸ್ಟ್
Yes,
ಕೊಟ್ನಲ್ಲ.
yes, my lord. He just furnished the memo.
Let's see what is.
Even he was, in fact, he has brought a DD for 1 lakh in the name of court. I have asked him to cancel it and transfer to the account. ಅವರು ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಕಳ್ಸಿದೀನಿ ಅಂದ ತಕ್ಷಣ I inquired with my neighbor office and I found the register post. Immediately I sent on to him that photographs and he has approached the Canara Bank. Let me make my submission.
NEF, you have sent a wrong account. I am
ಅದನ್ನೇ
only saying-
ಹೇಳ್ತಾ ಇದ್ದೀನಿ. I will get the details from the bank. Why are you not allowing me to
I am-
make submissions?
You have sent a wrong.
Not
account.
deliberate, should not
I
make
know,
such
when you
submission.
acknowledge the receipt itself, you are telling before the court that you have not received it. That itself shows the thing.
NEFT to R Anita ಅಂತ ಬರ್ದಿದೆ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ ಏನು ಕೌಂಟರ್ ಫೈಲ್ಸ್ ಅಲ್ಲಿ ಅದು ಡೀಟೇಲ್ಸ್ ಬರ್ದಿಲ್ಲ. ನಾನು ಅದನ್ನ I will
Whether your
secure.
client has checked in her account whether she has received.
She is not received. She is
ಬ್ಯಾಂಕ್
before-
ಅಕೌಂಟ್ ಚೆಕ್
before the
ಮಾಡಬೇಕು
court.
ಸ್ವಾಮಿ.
She has checked up today also, it is not received. That's why I am bringing it to notice.
Respondent
Because
petitioner is
my lord,
present before
when they
the
sent
court.
a wrong account number, it
Which
won't
is the
get
account
credit to
number?
her.
Where it is wrong?
My lord,
Where is it wrong?
Is it 3
ಅವ್ರು ರಾಂಗ್ ಅಂತ ಹೇಳೋದಕ್ಕೆ ಎಲ್ಲೂ
my lord,
It is wrong.
1125. My lord, 72500. 10 is missing, my lord.
00.
33, my lord.
Is only one single 3.
Single 3 is there, 33.
ಅಲ್ಲ
should have
ನನ್ನ
come.
ಟೈಪಿಂಗ್ ಅಲ್ಲಿ ಅದಾಗಿದೆ ಆದ್ರೆ ನಾನ್ ಕಳ್ಸಿದ್ದು ಅದು
ಅದು-
ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್.
No, where it is wrong?
No,
ಅಲ್ಲ ನನ್ನ ಮೆಮೋದಲ್ಲಿ ನನ್ನ
ಇರ್ರಿ.
it should be single 3. 33 is there.
ಯಾವುದು?
ಇದು ಅವರು ಕೊಟ್ಟಿದ್ದ ಮೆಮೊನಲ್ಲಿ.
ನನ್ನ ಮೆಮೋದಲ್ಲಿ ಅದು ರಾಂಗ್ ಟೈಪ್ ಆಗಿದೆ. ಒಂದು ಎಕ್ಸ್ಟ್ರಾ 3 ಬಂದಿದೆ ಅಂತ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಹೈಲೈಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Extra 3.
ಅಲ್ಲಿ 33 ಅಂತ ಬರುತ್ತಲ್ಲ 1033 ಅಂತ ಮಿಡ್ಲ್ ಅಲ್ಲಿ
1033 it has come, no lord.
ಹೌದು.
ಅದು
But
3
actually our account number is 1034. Single 3.
Double 3 ಅಂತ ಹೇಳಿದಿರಲ್ಲ.
Single, ಅವ್ರ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಅದರಲ್ಲಿ 33 ಇದೆ.
You see your memo.
ಅವ್ರ ಮೆಮೋದಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ರು ಅದನ್ನ ನಾನು ಹಾಕ್ತೇನೆ.
ನೀವೇ 33 ಕೊಟ್ಟಿದ್ದೀರಾ?
But I have furnished the cancellation check also.
You have written 33.
That's true, my lord, that the covering letters I am
Making
sorry.
a big hue and cry of it.
No, covering letter I have filed it.
Maybe, sir.
Yes, ma'am.
Is it not a mistake committed by you?
It is also error, which is, I put extra in this memo. It is. But what has happened, way of abundant caution, I have enclosed her checkbook, cross checkbook, way of abundant caution. Because that IFSC code and
ಯಾರ
all
account
should-
ಗೆ ಹೋಗಿದೆ ಇವಾಗ?
ಐ ವಿಲ್ ವೆರಿಫೈ.
I'll
ಅದನ್ನ ಇವಾಗ
verify,
ತಿಳ್ಕೊಬೇಕು
my lord.
ಸ್ವಾಮಿ. ಹೇಳಿದೀನಿ ಈಗಲೇ
Verify
ಇನ್ಸ್ಟ್ರಕ್ಷನ್
ಮಾಡಿ.
ಮಾಡ್ತೀನಿ.
Mr. Sukumaran,
Yes, my lord, yes, my lord.
no doubt you have given the cancelled check for,
Yes, yes, yes.
but in the
Adinali,
memo,
all particulars are mentioned. That is why,
but in the memo filed by you,
my lord, I'm not telling you, they must have also by oversight would have sent it, it will go to some other.
ನಾನು
account.
ಎರಡನ್ನೂ ಅವರಿಗೆ
This is why I'm
ವಾಟ್ಸ್ಆಪ್
telling,
ಮಾಡಿದ್ದೆ.
let him rectify and send it to me one day. And the case can be
Sir,
called.
yes, he is not going to benefit it by sending it to wrong address. He will be rather in difficulty
But I
to
will be,
recover that amount.
I will be in peculiar citizen because I have not encashed. it
You
did
have
not come
committed
to
an
the-
error by giving the wrong account number in your memo.
Yes, I had given that, I admit, my lord.
Your
But
mistake.
way of abundant caution, I have given a cross empty check.
He has believed your version and he has also not.
No.
Both are not diligent. So no, you need not point fingers at each other.
I am partially diligent and partially negligent. Yes, my lord. That is why way of abundant caution, I had given it the
But
check.
one more thing, what you have mentioned again, maybe typographical error of that IFSC code.
Yes. IFS code.
00000117. That's also correct.
That
How
is
did this tally then?
00001117.
If you write the IFSC code and the account number different, it will not tally in the account when you transfer money.
Yes.
The IFSC code is correct.
IFS code, the account number extra 3 is typed in memo, but I have produced the original copy of the check, my lord.
Correct, Ri.
Correct.
Now,
Yes, my lord.
your contention is that he has sent it to some other
Sent it to the
and you
account.
have not received.
I will not receive.
Even if he makes a mistake, it will not tally for him, the transaction will not go through. Because the account number and IFSC has to tally.
Tally, otherwise it will.
Send any RTGS or NEFT.
That is why I'm asking.
Madi, you find out from
ನಾನು
your
find
client.
out ಮಾಡ್ತೀನಿ.
I will list it on Monday or Tuesday.
Yes, ma'am.
Tuesday.
This can be rectified, that your lordship may.
ಇವತ್ತೇ
I will
ವರ್ಕಿಂಗ್ ಡೇ ಲಾಸ್ಟ್
let him know. It is-
ಮತ್ತೆ ನಾಳೆ ಸೆಕೆಂಡ್ ಸ್ಯಾಟರ್ಡೆ ಮಂಡೇ ಇಸ್ ಆಲ್ಸೋ
I'll post it on Wednesday.
Yes, my lord.
You check, tell your client to go by immediately to the bank.
Today
If it is-
itself I will
If it
send
is not transferred, stop it and pay the amount.
As for the Xerox
As
copy
per
of the
the-
check I had given.
Cancel check ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಅವ್ರು.
ಕೊಟ್ಟೆ ನಾನು ಎರಡು ಕಳ್ಸಿದ್ದೀನಿ ಅವ್ರು ವಾಟ್ಸ್ಆಪ್ ಮಾಡಿದ್ದೆ ಅದನ್ನು ಎರಡು ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದೆ ಅವ್ರಿಗೆ
ಯಾರಿಗೆ?
ಪಾರ್ಟಿಗೆ.
ಕ್ಯಾನ್ಸಲ್ ಚೆಕ್ ಮೇಲ್ ಮಾಡ್ಬೇಕು ಅದು ಅವರ ಮೆಮೊ ಮೇಲೆ ಹೋಗ್ಬೇಡಿ.
ಇಲ್ಲ ಮೆಮೊ ಎರಡೂನು ನಾನು ಫೋಟೋ ತೆಗೆದ್ಬಿಟ್ಟು ಇಮಿಡಿಯೇಟ್ ಕಳಿಸ್ದೆ ಅವರು 6ನೇ ತಾರೀಕೆ ಕಟ್ಟಿದ್ದಾರೆ. ಆದ್ರೆ ಐ ಡೋಂಟ್ ನೋ ವಾಟ್
Do that transfer now. What about the other case?
The
other
same
case
thing, my
is
lord. It is also arising out of the same copy.
against enhancement I came.
Against that also, my
That
lord.
is
It may be taken or connected, called out on Wednesday.
Learned counsel for petitioner and learned counsel for respondent are present along with their respective parties. There is some confusion with regard to the deposit made by the petitioner in favor of respondent. As the NEFT is claimed to have been, amount through NEFT is claimed to have been sent by petitioner. But the respondent submits that she has not received the amount. It appears there is some error committed in mentioning the account number correctly. Parties to verify and make the submissions, and if not deposited, the amount shall be deposited to the account of respondent. Call this matter on 18th.
Obliged.
one submission in the first matter. Interim order was granted, 4 weeks time was granted. That is expired on 9th. That needs to be.
Interim
because-
order is extended till next date of year.
No, my lord. What has happened? The earlier petition, there is a clear order by your lordship. The foremost, my lord, I will convince the earlier one more petition which was filed. The learned judge said disabled and it is
ಕೂತ್ಕೊಳ್ಳಿ ಮಾ.
passed before
Madam,
this,
ಕೂತ್ಕೊಳ್ಳಿ. Please.
passed to this court. There is with 1 lakh with an observation. There is a make submission. Now what's happened, lordship? There was 152 days delay. The interim order, he said, the interim order says only to pay as and when arises. And also the arrears of 3,52,000 rupees totally spending. I mean, excluding this. Including this, I'm telling you, 3,52,000 is spending. That is way back of 19 orders, the year of 19. And what has happened? The first, the foremost, the revision itself is not maintainable. Question of one order your lordship has granted with a condition.
I will hear you on Wednesday. Let him, first you take the amount. I will hear you on Wednesday in all these aspects.
Yes. But what happened, my lord? That earlier orders, the both are arising after the same. One revision is your lordship is granted. Another revision, what has happened? There is no orders or requirement for passing in it's a double order of a single judgment.
Correct.
Yes, that's all I'm telling.
I've understood it. In
Yes.
one case.
Yes, madam.
Of 7th
No,
of-
no more talk, my lord. Your lordship gets it. First and foremost, my lord, there cannot be a double revision also.
No, it will not be.
I know, we will hear it on 18th, my lord.
Because
Let
both-
that amount be given to that
Both
lady.
are arising out of one order.
Yes, my lord. Let
But
my
it-
friend give
it's
that
not-
amount,
it's not the
pending
com-
amount to the lady first, because she is.
Not the common order, my lord. Separate orders are passed. In fact, the
Separate order.
separate order is passed.
On?
Appeal filed by me, it was dismissed by separate. order.
Appeal is arising out of which order?
Appeal is, appeal arising out of DV Act,
that
original
is only one
proceedings.
order.
One order. Two appeals are filed, one by me, other by
There
other.
is an order of maintenance.
Please, my lord.
Of 7,000. Challenged by you, challenged by him.
Please.
So order emanating is only one.
But I did not challenge before your lordship.
So there is an enhancement
Trial court.
made in
Here
his
the
appeal.
two appeal is there.
In your appeal, it is dismissed. So there is no two order. Of course, two orders by the appellate court.
Two
Order of
orders by the
trial court
appellate
is
court.
only one.
Arising out of the
But
same.
arising out of the original proceedings is common. But the objections raised by the other side is that before the other bench that they have not challenged this dismissal order. As an abundant caution, I have filed this first, which is now connected first matter.
Consider.
Otherwise, I would not. ಅದಕ್ಕೆ ನಾನು ಸುಮ್ಮನೆ ಇದ್ದೆ ಬೇಡ ಅಂತ
All right, you
merge
rectify
ಆಗುತ್ತೆ
this,
ಅಂತ.
rectify this first.
Please, my lord.
Obliged. Number 56, Sri Rajaram, yes. Vikas, yeah.
For the respondent, my lords.
Yes.
Deposited the amount, my lord.
Huh?
We have deposited the amount.
The council submits that he has complied with the order of this court. Yes.
I'll verify and I'll file an
Have
rescission
any objection
application
in
for.
him withdrawing the amount?
Yes, ma'am, I'll file an application, my lord.
I will file application.
Taro, you have any objection him withdrawing the amount?
Please, my lord, I will consult my.
Call this matter after a week. Verify, Madi. Sorry. Verify if it's filed.
Yes.
Next. Brinda.
Your lordship,
57, Srimati Brinda.
Your lordship, in this matter, there was a connected matter which was posted yesterday, your lordship, in 113424. And your lordship had, was pleased to pass a similar order in today's matter 110 as well. But it was not listed yesterday for various reasons, but it is listed today, your lordship. This is a 138 case.
Heard learned counsel for the petitioner issue notice to respondent. Order of sentence dated 23/10/2019 in CC number 959 of 2019 passed by 16 additional chief metropolitan magistrate confirmed in criminal appeal 1088 of 21 dated 1/7/24 by the 65 additional city civil and sessions judge Bangalore is hereby suspended. Petitioner shall be enlarged on bail subject to the following conditions. Petitioner shall deposit 50% of the fine amount inclusive of any amount already deposited before the trial court within 4 weeks from today. Petitioner shall execute a personal bond for ₹1 lakh with like sum surety to the satisfaction of trial court. Call this matter along with the criminal RP number
Your lordship, 1134. 134.
134.
1134, 1134.
All right, 1134.
Please, Your Lordship.
That is what you wanted?
Yes, please. Please, my lordship.
58.
For petitioner, my lords.
Yes, Mohan.
My lord, I have preferred this petition against the concurrent conviction, my lord. Within fine amount of 4,60,000 has been ordered.
Heard learned counsel for the petitioner issue notice. Orders on IE1. Order of sentence. Dated 29/11/23, CC 2217 of 19. Passed by Principal Civil Judge JMFC Mysuru. Confirmed in criminal appeal 455 of 23, dated 19/7/24 by First Additional District and Sessions Judge. Is hereby suspended. Petitioner shall be enlarged on bail, subject to following conditions. Same order, 50% personal bond 1 lakh.
Obliged, my lords.
Kumar,
For 59, Sri
I am
Kumar
for
Dev.
petitioner, my lord. Present petition filed against the conviction order passed in 138 of enact proceedings.
same order. Madam.
I have
Okay,
filed suspension
Bhaktirama?
of sentence.
Third learned counsel, 50% and 1 lakh personal bond.
Machabu.
Yes. Yes.
Next matter, my lord.
Serial number 60, my lord.
60 matter. That is we are proposing a settlement.
Ah,
So trial court ಅಲ್ಲಿ ನಡೀತಾ ಇದೆ. Some 2 weeks may kindly be granted, but by this
settlement ಆಗಿಲ್ಲ ಇದು.
ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ
Very likely of settlement, my lord. Even the other
ಏನಾಗಿದೆ, ಅವ್ರು ಹಣ ಕೊಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಒಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ. ಸೊ ಮಗು ಮತ್ತೆ ಹೆಂಡತಿ ಇಬ್ಬರಿದ್ದಾರೆ. ಆ ಪ್ರಾಪರ್ಟಿದು ಖಾತಾ ಮಾಡಿಸಿ ಗಿಫ್ಟ್
ಮಗುಗೆ.
ಮಾಡ್ತೀನಿ ಅಂತ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ದಿ ಒಬ್ಟೈನ್ ಇನ್ ದಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಪ್ರಾಮಿಸ್ ಮಾಡಿದ್ರು. ಅದು ಈಗ ದಟ್ ಇಸ್ ಗೋಯಿಂಗ್ ಆನ್ ನೌ.
All right, I'll have it after.
in the process. So 2 weeks may.
25ನೇ ತಾರೀಕು ಹಾಕು.
25 ಅಲ್ಲಿದೆಯಾ?
ಅಲ್ಲ, ಅಲ್ಲೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
Yes, ma'am.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
After vacation.
No, 25th. Learned counsel for both parties submit. The parties are exploring the possibility of settlement. Means list this matter on 25th September to report settlement, if any.
ಅಲ್ಲ, ಅಲ್ಲಿ ಏನಾಗಿದೆ, 11B ಖಾತಾ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ. 11B ಖಾತಾ ಆದ್ಮೇಲೆ ಇವ್ರು ನಮಗೇನಾದ್ರು ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡ್ಕೊಡ್ಬೇಕು. ಸೊ ದಿಸ್ ಇಟ್ ವಿಲ್
25th ಒಳಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಕಷ್ಟ ಆಗುತ್ತಂತ ಸ್ವಾಮಿ.
Another maybe after vacation. my lord.
30th.
ಆಗುತ್ತೆ ಅಷ್ಟರಲ್ಲಿ.
30th, I'll post it after the.
Yes, very well. We can
ಅಲ್ಲ,
make
ಇವ್ರು
our
ಎಷ್ಟು ಬೇಗ ಮಾಡ್ತಾರೆ ಅಷ್ಟು ಬೇಗ ಆಗುತ್ತೆ ಅಷ್ಟೇ.
It's okay. Now settlement is
30th.
going on. That is always good, better than
Yes.
ಎಸ್ ಮೇಲೆ
matter.
We agree also.
And with there we come closure. It may go a little bit here down. If that day it doesn't happen, seek some more time.
Very well.
So,
30th ಮೇಲೆ.
all right. Yes, 30th.
Yes.
Other matters 2:30.
I need permission, my lord. Serial number 80. Records are awaited, my lord.
80.
80. I am for the petition.
All right, await records. Hold on.
27.
Entry order may be extended.
Interim order extended till next. ಏನ್ interim order ಅದರಲ್ಲಿ?
Suspension of 4 weeks ಅಂತ ಏನು ಮಾಡಿ. Till at date ಅಂತ ಏನಿದೆ.
No, what is the offense?
138.
ಅದರಲ್ಲಿ ಏನ್ interim order? There will be conditional order.
Please.
No interim order.
Serial number 69, my lord. Dispute on
Come
husband
at
and wife.
2:30.
ಆಮೇಲೆ ಇದ್ಯಾವ್ದು ಅರ್ಜೆಂಟ್ ಆಯ್ತಲ್ಲ ಅದ್ರಲ್ಲಿ ಇಂಕ್ರೀ ಮಾಡ್ರಿ ಏನಿಲ್ಲ. ಹಲೋ. ಹೇಳಿ ಸರ್.
Court officer.
ಹೇಳಿ ಮೇಡಮ್.
Sir Girija Hiremat, High Court, HCGP Dharwad.
ಓಕೆ. ಹೈ ಟೆನ್ಷನ್ ಅವನು ಯಾವ ತರ ಇದೆ ಪ್ರಸನ್ನ DP ಶಶಿಕುಮಾರ್ ಗೌಡ. ಮನೆಗೆಲ್ಲ ಬಂದಿದ್ದಾರೆ ಒಂದೇ ಇದರಲ್ಲಿ ಹೌದು ಒಳ್ಳೊಳ್ಳೆ ಪ್ಲೇಸ್.
My lords, may I make one submission, my lords? Serial number 76, my lords, I pray for short. Serial number 76, my lords, I pray for short accommodation, my lords.
On time,
Yes, my lords, please, my lords.
which serial number?
76.
Was this argued partly?
Yes, my lords.
Agita?
Yeah, before Previous
Yes.
bench minutes.
Argument ಆಗಿತ್ತಾ? Huh?
Previous bench,
ಇಲ್ಲ, argument ಆಗಿತ್ತಾ?
ನಿಮ್ ಮುಂದೆ ಆಗಿರ್ಲಿಲ್ಲ my lords, ಬೇರೆ
ಇಲ್ಲ.
bench ಮುಂದೆ ಆಗಿತ್ತು.
When you, what's the offense?
394 and 324.
All right, at request of learned counsel for petitioner, all this matter next week,
Please, my lords.
20th on 10th ತಾರೀಕು.
28th September.
Please, my lords.
My lord, serial number 69, my lord.
Yes, madam.
Petitioner for my lord. 2 weeks requested to 2 weeks time, my lord, because of our compromising baro ತರ ಇದೆ.
69, huh?
Yeah.
You are for petitioner,
Yes, my lord.
Shashidhara.
Yes, my lord.
What is this offense?
Challenge the conviction order, my lord, section 494 of CIPC.
Learned counsel for petitioner seeks time.
Factual background with respect to the judgments alone, my lords. That would, my lords, give a very clear picture to this honorable court whether, my lords, an order could have been passed. Because primary submission would be the state was, my lords, satisfied with the order of the appellate court. The state said the order of the appellate court is correct. Though on a point of law which my lords have been pleased to pass, the order, the effect of the order has been detrimental to me. I'll argue on that, my lords. I wouldn't take much time. My lords, may kindly turn to first, my lords, the trial court judgment, page number 43 in the first petition, my lords, 100159. Review judgments, I have several, my lords.
All right, because I don't remember now this.
Please, I will.
2020,
Please,
4 years later.
Please.
Question
Now-
is whether review is permissible now, because you are now trying to review the order.
Review and a recall of the earlier order in revision, my lords.
Recall is not permissible.
Both are permissible is what the Honorable Supreme Court says. Even if a bar under 362 is not absolute, it would not render this Honorable Court functus officio despite an order having been passed on merits. There are several judgments, my lords, on that. I wouldn't.
But let's go through that first.
Please.
Hurdle of whether it is maintainable.
Or not, please. I've already served on the state, my lords, on the learned HCGP. We have served the citation.
Madam was here, what is
Your
happening?
lordship, morning only I have received, your lordship. 1 o'clock, round about 1 o'clock, your lordship. I have not gone through with the judgments.
The state perhaps would require some.
Heard this?
We have served this, my lords.
Madam, have you received this
Please,
compilation?
your lordship. Please, your lordship. Morning, round about 1 o'clock, I have received, your lordship. I have not yet gone through, but
You
it is our
better go
contention,
through.
your lordship.
You better go through this first. Let's understand it.
My lords, I will as well submit my brief written submissions. Primarily arising out of one point of law, my lords. Primarily, Even that has been served, my lords. That has been served.
This also has been served.
This has been served, as well as the entire compilation of citations we have served.
All right, maybe you can address now.
I will address, in fact, even the state would
How
be.
much time you will take?
I'll try to finish maybe within 20 minutes, I'll try to initially put forth the case. Then subject to what my lords would.
No, you are not, need not touch upon the facts. You can only go only on.
Only on the law, my lords.
Law.
Only on the law.
And we will leave it to her to read through the compilation filed by you.
Please, my lords. Law on the maintainability is what I will submit first, my lords. The first judgment may.
Any learned counsel waiting for any settlement? ಯಾವುದು ಬೆಳಗಿಂದ ಯಾವುದು settlement? Okay. Yes, Mr. Raman.
Please. But the first judgment, my lords may kindly look into. This is 1993 supplementary 4 SEC page 595. 36025, we'll have to read notes, please. Court not to alter judgment, save as otherwise provided by this court or by any other law for the time being in force. No court, when it has signed its judgment or final order, disposing of a case, shall alter or review the same, except to correct a clerical or arithmetical error.
So this is clear.
This is clear, my lords.
So
now
it will arise only where a situation is a clerical or arithmetical error.
Arithmetical error. In addition to that, the judgments of the Honorable Supreme Court, my lords, would even add to this when there is violation of principles of natural justice. That's one scenario, my lords. When there is fraud played on the court, one of it wouldn't arise, fraud wouldn't arise perhaps. Then when without jurisdiction, if an order comes to be passed by the court, and without powers that are if at all the court has no powers to pass certain orders. Under such events, my lord, still the order passed on merits as well could be recalled as such.
But that is not the situation in your case here.
But in my case, I come under at least 3 brackets here, my lords. One is on the point of jurisdiction. Secondly, my lords, there having not been an appeal or a revision filed by the state challenging the judgment in appeal, and the state submitting before the court in revision that we have nothing to say as far as the appellate court's judgment is concerned. We have no grievance on that. State having said that, then perhaps, my lord, reversing the benefit of set off granted to the accused perhaps couldn't have been done. One. And then moreover, if at all the revisional court intended to, my lords, proceed to pass by reversing or by modifying or altering an order accrued to the accused in any manner, if that was intended to be altered, then the accused would be required to be heard, especially on that point, by issuing a notice that this is what the court intends to do. What is that you have to say on it? So these 3 points get covered. Now, I will supplement this with the.
Madam, you are able to hear. You are
Please,
able
Your
to
Lordship.
hear.
Please.
Yes, sir.
The first judgment may kindly be seen, my lords. I'll draw my lord's attention directly to, but this does not arise out of 362. However, the principle with regards to finality of judgments having been discussed from para 16 and para 17, I'll directly draw to my lord's attention to para 18 and a portion of para 19, my lords. Para 18 at page 25. Justice is a virtue which transcends all barriers. Neither the rules of procedure nor technicalities of law can stand in its way. The order of the court should not be prejudicial to anyone. Rule of stare decisis is adhered for consistency, but it is not as inflexible in administrative law as in public law. Now, from here onwards, it would be important, my lords. Even the law bends before justice. Entire concept of writ jurisdiction exercised by the higher courts is founded on equity and fairness. If the court finds that the order was passed under a mistake and it would not have exercised the jurisdiction, but for the erroneous assumption, which in fact did not exist, and its perpetration shall result in miscarriage of justice, then it cannot on any principle be precluded from rectifying the error. Mistake is accepted as valid reason to recall an order. Difference lies in the nature of mistake and
This
scope.
is actus curiae neminem gravabit.
Please, my lords.
No act of the court shall prejudice a
Harm
man.
anybody, please, my lords. Primarily on this.
That is a well-established principle.
But further, I'll just conclude the parameters therein. I'll skip one sentence and then continue to read. But the root from which the power flows is the anxiety to avoid injustice. It is either statutory or inherent. The latter is available where the mistake is of the court. In administrative law, the scope is still wider. Technicalities apart, if the court is satisfied of the injustice, then it is its constitutional and legal obligation to set it right by recalling its order. I will skip the rest of the portion of that. Para 19, my lord, second sentence, basic philosophy inherent in it is the universal acceptance of human fallibility.
Your briefing counsel should also see the judge and tell you to stop when I'm not listening to you and underlining something.
Please, please.
Or Gaelic. Yes.
Para 19 second.
Yes.
Para 19 second line, my lords. Basic philosophy inherent in it is the universal acceptance of human fallibility. Yet, in the realm of law, the courts and even the statutes lean strongly in favor of finality of decision legally and properly made. Exceptions both statutorily and judicially have been carved out to correct accidental mistakes or miscarriage of justice. Even when there was no statutory provision and no rules were framed by the highest court indicating the circumstances in which it could rectify its order by the courts, culled out such power to avoid abuse of process or miscarriage of justice. So I will have to therein convince or satisfy this honorable court that there has been some miscarriage of justice, perhaps unintentionally. It is evident from the orders of the court, including this order of this honorable court, as to why it is unintentional. I will demonstrate that later, my lords. Now, my lords, may kindly turn to the second judgment, my lords, at page number 40. State of Punjab versus Davinder Pal Singh Bullar, 2011,
Yes.
14 SCC 770.
You can sit down, my friend.
I will draw my lord's attention. Here there was an acquittal which was challenged by the state in appeal. Later, the High Court had taken a suo motu action against a police officer. My lords, may kindly turn to para 46 at page number 65. Without going into any other details, only one para, and in fact, a part of it, my lords, may kindly permit me to read.
Yes.
46. My lords, before that, my lords, may kindly see at the top of that page, Roman 3,
yes,
bar to review, alter judgment.
Yes.
This arises directly from 362, whether it is a bar or not. Para 46, my lords, is the conclusion or the ratio laid. If
No,
a judgment has been pronounced without...
Let us also read 44.
Please, please, please. There is no power of review with the criminal court after judgment has been rendered. The High Court can alter or review its judgment before it is signed. When an order is passed, it cannot be reviewed. Section 362 CRPC is based on an acknowledged principle of law that once a matter is finally disposed of by a court, the said court, in the absence of a specific statutory provision, becomes functus officio and is disentitled to entertain fresh prayer for any relief unless the former order of final disposal is set aside by a court of competent jurisdiction in a manner prescribed by law. the court becomes functus officio the moment the order for disposing of a case is signed. Such an order cannot be altered except to the extent of correcting a clerical or arithmetical error. There is also no provision for modification of the judgment. Moreover, the prohibition contained in section 362 CRPC is absolute after the judgment is signed. Even the High Court, in exercise of its inherent power under section 482 CRPC, has no authority or jurisdiction to alter, review the same. Now, after my lords observing this, what the Honorable Supreme Court observes may kindly be seen, my lords. 46. If a judgment has been pronounced without jurisdiction or in violation of principles of natural justice, or where the order has been pronounced without giving an opportunity of being heard to a party affected by it, or where an order was obtained by abuse of the process of court, which would really amount to its being without jurisdiction, inherent powers can be exercised to recall such order for the reason that in such an eventuality, the order becomes a nullity and the provisions of section 362 CRPC would not operate. In such an eventuality, the judgment is manifestly contrary to the audi alteram partem rule of natural justice. The power of recall is different from the power of altering, reviewing the judgment. However, the party seeking recall alteration has to establish that it was not at fault.
So what is your case here? This court has committed.
May I humbly submit this, my lords. My lords, the learned magistrate, while convicted me for offence under 457 and 380, did not pass an order on set off at all. Order on set off is mandatorily to be passed as the wordings of the section go. Where, my lords, if I have been in custody for 1 year and the sentence which has been imposed on me itself is 1 year, I naturally, my lords, get the benefit of it. If there are 2 cases also, depending on the date in the second case when I've been in custody, I would get that benefit, not essentially from the first date of custody in the first case. Second case custody commences later. So the learned magistrate was required to view the records of the court as such, because it is the learned magistrate, my lords, that issues a body warrant for my production from the prison. After issuance of it, I am produced before the said court by the prison authorities. My lords, an important event that takes place upon I being produced or an accused being produced is, but the court decides as on that day what should be done with the individual who has been produced, whether he is required for investigation or in the said case, and thereafter should he be sent to police custody or to be remanded to judicial custody. And these orders would be, my lords, orders under section 167 of CRPC. An accused gets remanded to such custody as the court deems fit. Such custody would mean police custody or judicial custody. But the police make an application for my production in the second case, saying that I am in custody in the first case. They say I am required as an accused in the second case and I am produced before the court. And after I am produced, I am, my lords, remanded to prison in the second case.
JC.
In JC. My custody in the second case commences on the day I was remanded to prison in the second case.
Correct.
Accordingly, what follows is thereafter in every subsequent case, the same thing follows. Now, lords may kindly appreciate this. It is only the trial courts which are aware of the records here. Primarily, my lords, the application made by the police under 167 seeking my production and section 267 for issuance of the body warrant. What is the order passed? The order sheet would indicate to some extent. So the learned magistrate, my lords, in the judgment, the order is silent. Though the sentences for 457 and 380 passed were to run concurrently, that's a separate issue, but set of benefit, my lords, was not accorded to the accused. So the order was silent. In appeal, my lords, these petitioners before, my lords, the accused, they challenged the conviction and also the order not, and also the absence of an order on set off.
Before the appellate court.
Before the appellate court. During the hearing of the appeal, notice the submission is made that the conviction is seriously not challenged.
That is
By
all.
the accused. The accused, though my lords had filed the appeal challenging the conviction.
Not question the
Did not
conviction per se.
Per se on merits, and they accepted the conviction, which is specifically recorded in the appellate court's order.
So what was challenged then?
We then sought only a relief of set off being granted to us. Meaning thereby, my lords, that from the date of our first production before the concerned magistrate in each of these 9 cases, kindly grant us set off. But different dates they are all. Mostly they are different dates except for 3 common dates or 1 or 2 common dates. But the learned appellate court was specific. The order passed was these 2 petitioners were given the benefit of set off. Meaning thereby that in the 2nd case or 3rd case or 4th case and up to 9th case, from the first day I was produced in the 2nd case, from that day until the date of the judgment passed of conviction, I was accorded the benefit of set off. Similarly, 3rd, 4th, 5th, up to 9th case, we were given the benefit of set off. Now, my lords, this after, and in fact, the court below as well, the appellate court as well observed what were the dates of my arrest or production. Now, my lords, accused, now this would be important, my lords. The petitioners or the accused, they again approached the Honorable High Court. But this would be necessary because even I had missed this until this stage. Until my preparation for these arguments yesterday or a couple of days back, I had missed this. Notice, may kindly see page number 17 of the petition. What was the prayer made by the accused in these revision petitions? Notice page 17, which is the cause title of the.
Yes.
The revision petition is filed under section 397(41) of CRPC and prayed to set aside the judgment of Principal District and Session Judge Karwar in criminal appeal number so and so. But, and I will skip that, my lords, after the date 22/6/18, and prayed that the petitioners have already undergone the sentence of punishment and are entitled to, this would be important, avail the set of benefit under section 428 of CRPC, but they are still languishing in imprisonment. So this is what was sought. Now, my lords, even during arguments, my lords, before this honorable court, my lords, if my lords would kindly turn to page number 22 there in my lords, para 9. Para 9, 10, and 11, my lords, may kindly permit me to read in entirety.
Yes.
Learned counsel further contends that his main argument before the appellate court was to grant benefit of set off under section 428 CRPC, which is though granted, is not specifically mentioned in the order, thereby forcing the petitioners to approach this court in the present petition. My lords, there was no challenge at all. Then, learned counsel for the petitioners restrict his argument only to the second prayer, that is to grant the benefit of set off under 428 in the present case. On these grounds, he seeks to allow the petition with regard to granting of set off under section 428. Lords, may kindly appreciate, we had sought for availing the benefit. But there would be a difference, my lords. But this honorable court or any court would pass the order of set off. The prison authorities, my lords, in their register will have the task of when there are multiple cases, calculating each person's custody from which date to which date in each case.
Correct.
Whether there is consecutive running of sentences or concurrent, set off granted or not. So this is the calculation which the prison authorities are required to do. We submitted before the court and our revision indicates that we sought for availing the benefit. Now, what did the state submit and which would be important, my lords? Para 11. Per contra, learned High Court government pleader for respondent state contends that the judgment of conviction and order of sentence passed by the trial court and confirmed by the appellate court is perfectly in accordance with law. Material evidence on record and the same does not require any interference by this court. Learned government pleader further contends that the relief sought for by petitioners herein before the appellate court has been partly granted with regard to the benefit of set off under section 420 of CRPC, and hence there is no requirement of this court to entertain the present petition. On these grounds, he seeks to dismiss the petition as the relief sought for is already granted by the appellate court. My lords, may kindly see now, there is no grievance of the state. Now, my lords, more important, my lords, may kindly appreciate, if state had a grievance, they ought to have challenged, my lords, the appellate court order under section 377, subsection 3, or under section 386, C3.
So what was the set off granted by the appellate court?
But the appellate court granted set off in each of the cases, my lords, from the time I was in custody in each of the individual cases. Meaning, my lords, on my first production before the said trial court, upon a body warrant, from that day my custody commences. Even this court, my lords, in all the 9 cases in revision, has specifically observed in different paragraphs. Para 19 specifically gives the date as to on which day I was in custody or arrested. Lords, may kindly see para 19 for a moment.
Yeah, you can go according to your preparation of arguments. After para 11, you want to read?
Para 11 would be necessary, my lords. I thought I'll come back to that later. Would be necessary, my lords. With this background, my lords, may kindly appreciate, perhaps this could be the grievance of the petitioners as such. Whether this necessitated or not, my lords, may kindly see. Whether the said question, the points which asked for consideration, perhaps in my most humble respectful submission, perhaps wouldn't have arisen. Maybe it was for the petitioner's counsel to submit specifically on availing, which would have been a direction to the concerned prison authorities. If they had submitted that the prison authorities are required to calculate the dates of custody in each case and thereby accrue or effect the benefit of set off to the accused, maybe this problem wouldn't have arisen.
Now, what is said here is that the appellate court has granted the benefit of set off.
Please,
was given?
It was given.
Then what was the need to approach this court again?
The need to approach was not on the merits. It was challenged. Yes, conviction was challenged. Subsequently, they said no. But the prayer sought was, my lords, though benefit is given, it has not been availed.
Given but not availed.
Not availed. Now, how would it be availed, my lords? He is totally left to the prison authorities. But this is something, my lords, which gets played around so much by the prison authorities. Sometimes, of course, I don't intend to cast any allegations, but it does happen because it's a challenging issue, my lords. It remains a challenging issue for the reason concurrent running of the sentences, consecutive running of the sentences, calculations are all different, my lords.
Can you read that order of the appellate court? Let's see if it have it.
Please, my lords. My lords, may kindly turn to 35. Page 35 is the appellate court order.
What is the setup that is given?
Lords, page 42. But before that, I'll read page 41, last paragraph, para 13. In view of section 428 of CRPC, specifically mandates that period undergone during inquiry or trial shall be given set off. Here in this case, on careful perusal of the impugned judgment, no reason is assigned by the learned CJM why he declined to exercise power under section 428 of CRPC is not explained, and therefore the impugned order is not giving benefit of section 428 of CRPC is perverse, and accused cannot be prevented from taking benefit of section 428 of CRPC. As found from the impugned judgment, intention of the learned CJM is not extending benefit under section 428 is very clear that he did not want accused persons to enjoy benefit of 428 of CRPC. Hence, such restrictions cannot be made by the CJM when statute itself mandates benefit to the convicted person. Hence, accused 1 and 2 are entitled for the benefit under section 428. Therefore, impugned sentence passed without extending benefit under 428 is perverse, illegal, and calls for interference and requires modification. Accordingly, point number 2 is answered partly in the affirmative. But thereafter, next page, minutes order. In the order, minutes, the fourth part therein, it's fourth para. accused number 1 and 2 are entitled for the benefit under section 428 of CRPC for the period undergone during the period of inquiry and trial.
All right.
So this was, my lords, this benefit was made available to the accused. This was granted, the relief sought was granted. First, it is for the prison authorities thereafter to calculate when there are multiple cases of this nature. Accused approaches in revision, primarily, my lords, praying therein, seeking an order that he be, there has to be seeking a direction that he is entitled to avail the set of benefit. So, my lords, the petitioners ought to have submitted before the court for a direction that the compliance of the appellate's court order is required to be made from the date they are in custody in each case. That perhaps is
By
what.
giving this passing of the order, appellate court order,
Please, move.
whereby you are given the benefit of set off.
Please, move.
This was not communicated to the jail authorities.
It was, my lords. Orders in the due process directly they go to the prison, my lords.
Correct.
Essentially.
So why you did not avail it?
But it is for the prison authorities to calculate, my lords. Now, this challenge, my lords, always remains. As a person who is in custody, at the most, my lords, I can only go and make an oral request or give something in writing. But as, in fact, at the time, as on the date of my conviction by the learned magistrate, my lords, I had completed the sentence in all the 9 cases. However, because set off was not given, I did not have the benefit. But the moment the appellate court had passed the order of, my lords, extending benefit of set off, the prison authorities ought to have released me. For that reason, my lords, I had approached this honorable court in revision, my lords, seeking that an order be passed that I am entitled for the benefit to avail the benefit of set off.
What is this order? You have been given the benefit of set off by appellate court.
Please, my lords.
No dispute.
No dispute.
You agree to that.
Please, my lords.
You are in your prayer, you are making the same prayer to avail the benefit.
To avail the benefit.
See, what is given to you is, if not availed by you, it is your mistake.
But I cannot avail while I am in prison in any manner. There is no process in law under the code that an accused makes an application to the prison authorities. There may be a process under the prison manuals and on the administrative side, perhaps, yes, that is there. But under the code, my lords, there is no process except for approaching the court. The accused cannot, in any capacity, approach directly the jail authorities, except maybe orally they would go, my lords, or else something to be given in writing. That's the reason, my lords, if their approach to this honorable court perhaps could have been avoided, the other way of, my lords, seeking a relief of this nature was to file a habeas corpus petition and therein say that despite having been given the benefit of set off and the sentence having been undergone, my lords, at the time of the judgment passed by the learned trial court, I have been in custody for more than 3 or 4 or 5 years thereafter. So there ought to have been perhaps an application made or a habeas corpus petition filed, or else a revision. But perhaps revision wouldn't have been maintainable except to the extent of maybe availing the benefit as such.
So
At the most, my lord, there ought to have been a submission made by the learned counsel appearing for the petitions therein, that even a direction by this honorable court in revision that he has undergone the entire sentence by invocation of the appellate court's order. Perhaps that also would have been sufficient. Maybe that has not been brought to the notice of this honorable court while arguing the revision petition. This exercise of filing a revision perhaps was not necessary at all.
Yes.
Please. So my submission, my lords, is only on this point. Now, my lords, 401 may kindly be seen. My lords. My lords, I submitted on what were the powers. My lords. Maybe if this was submitted, the present order, which is in challenge, my lords, or which is sought to be recalled, wouldn't have been passed by. Now, 401 may kindly be seen, my lords.
No, now, tell me one thing. How many cases you were involved in?
9 cases, 9 revisions presently filed, my lords, before this honorable court.
No, before that, appeal.
One more case, my lords.
Totally, how many cases and how many appeals?
My lords, appeals were 9.
So in all
9
cases,
revisions.
all cases set off was granted.
In all cases, set off was granted in appeal.
So according to you, you have completed the sentence.
I have completed the sentence, my lords, on the day the trial court's judgment was passed. Today, I am in prison for at least 6 more years.
6 years.
6 more years.
And what prevented you from filing a petition for illegal detention?
Okay, now that my lords may kindly see, the order in revision took away the benefit that had accrued to me, my lords, which was extended by the appellate.
How?
My lords may kindly see the order in revision, my lords. My lords, page number 32, my lords. Page 30 to para 24, may I kindly read, my lords. It is seen that the petitioners herein are tried for various offences in separate trials. Therefore, the petitioners would not be entitled to benefit of set off under 428. In the present case, petitioners have been convicted in several cases for several offences of theft and convicted separately by way of separate trials. Hence, they cannot claim double benefit of under section 428. The same period being counted as part of the period of imprisonment imposed for committing the former offence and also being set off against the period of imprisonment imposed for committing later offence as well. Therefore, the period of detention during trial and investigation undergone by the accused herein, they would be entitled for the benefit of set off only in the case in which they have been arrested, for which already this court has passed an order in criminal RP number 100115 granting benefit of set off. I am of the considered opinion that the benefit sought by the petitioners for grant of set off under section 428 cannot be granted in the present case for the aforesaid reasons.
What is that 100115?
No, that is another revision petition filed wherein we are not challenging that order presently. So I have been granted benefit in that, as my lords has observed here. So that doesn't come to be challenged. That perhaps, my lords, arose from the first case as such. Because first case, I would have completed the sentence by them. So I don't remain to be in prison in the first case. So that has not been challenged. So benefit, my lords, in all these 9 cases, if my lords would see, in all the 9 cases, the benefit of set off has been extended in this particular revision only. So the other 9 revisions for which I am before this honorable court, my lords, presently remain. Now, as on today, my lords, I would have, if 2 years are taken.
No, by this order, your petition came to be dismissed.
Please, my lords.
But the fact remains that the set off which was granted by the appellate court is not disturbed.
That is what I would most kindly see. Even an observation to that extent, if would be made by this honorable court, my lords, as by way of a clarification, I would be content, I would seek the benefit. For a moment, my lords, I'll just read the last portion, my lords, page 35. Therefore, the period of detention during trial and investigation undergone by the accused herein, they would be entitled for the benefit of set off.
Where are you reading?
My lords, page 34. Sorry, 33, my lords. Page 33, 9th line from top, my lords. Therefore, the period of detention during trial and investigation undergone by the accused herein, they would be entitled for the benefit of set off only in the case in which they have been arrested, for which already this court has passed an order in criminal RP number 100115 granting benefit of set off. I am of the considered opinion that the benefit sought for by petitioners for grant of set off under 428 cannot be granted in the present case for the aforesaid reasons. So my submission is, even if there is a clarification by this honorable court that the benefit granted by the appellate court, my lords, to me, indicating from the day of my arrest in each of the cases, from that day, I get the benefit of setup. And that is not disturbed by an order passed by this honorable court. That would, my lords, perhaps make me, I would perhaps be released from prison. That also would suffice without going into the other. My lords, I would as well indicate in each of the cases, my lords, page number 32 or 33, my lords, indicates the same.
In all the cases, offense is the same,
Offenses are the same.
but different cases,
Different cases, my lords.
different incidents.
Different incidents in all the 9 cases or 10.
Different crime numbers.
In fact, my lords, I've submitted earlier, my lords, these offenses 457 lurking house trespass and, my lords, theft is something where the individual goes to a house and commits theft. That is the prosecution case. 120B can be even when an individual is in prison or even when an individual is out of country. But the allegation in 2 of the cases here is that we have committed theft by going into the house on this particular nights, whereas these people were in the prison in custody on those nights.
On record.
On record. But it happens, my lords. All these many cases get piled up against individuals to statistically, my lords, conclude an investigation. 1, 2, 3, my lords. Of course, police to some extent, I won't say they be justified, but as a compelling reason, a modus operandi seen of these individuals, they my lords, maintain a MOB, which is called as modus operandi bureau. They see in a particular area who are the individuals who commit this kind of a theft. And the pending cases of investigation where charge sheet has not been filed, they just come to be added. So in addition to that, my lords, I even have the benefit in 5 cases for the second petitioner of juvenility. He was a juvenile in 5 cases as on the date of the incident. I submitted that on the earlier occasion, my lords. Maybe if at all this honorable court would clarify that the order of sentence, order of set-off granted to me is not disturbed in any manner, and that from each of the dates indicated in this revision order, my lords, would be entitled that I'm in custody from those particular dates. Even a clarificatory order is passed, my lords, I would be content that I would be out of prison immediately. But these are indigenous persons. I've even produced their photographs, my lords. As I understand, they were, my lords, they were represented by legal counsel all through, standing counsel during trial, standing counsel.
What was the imprisonment ordered in each case?
My lords, 2 years for 457, 1 year for 380. We have a chart as well, my lords. We have made a chart. In fact, in our return submission, we have produced that as well, the dates. So, my lords, 2 years for 457, 1 year for 380. Sentences to run concurrently would mean that they will have to undergo 2 years. Only 2 years in each case. As on the date of the judgment itself, my lords, in each of these cases, my lords, in the first case, which I am arguing, my lords, 1000159, as on the date of the judgment of the trial court, the accused have undergone 3 years, 2 months, and 25 days. As on the date of the judgment.
Of trial court.
Of the trial court, my lords, 2018 this is.
3 years?
3 years, 2 months, and 25 days. My lords, my return submission, page number 27. Return submission, paragraph number 6, page number 25 or 26 minutes.
Hmm. 27. The chart which you have made.
Please, my lords, the chart. In each case, my lords, the first case, 3 years, 2 months, and 25 days. Second case, 3 years, 2 months, 27 days. Third case, 3 years, 5 months, 4 days. Fourth case, my lords, 3 years, 8 months, and 8 days. Fifth case, 3 years, 8 months, and 11 days. Sixth case, 3 years, 8 months, and 18 days. Seventh, 4 years and 1 day. eighth case, 3 years, 11 months and 27 days, almost 4 years. And the ninth case, my lords, 3 years, 1 month and 27 days. My lords, this is as per the calculation of their production and remand by the learned magistrate. And these dates we have taken, my lords, from the orders of this honorable court in revision. Para 19 indicates these dates.
All right, if you have overrun the sentence, why did you keep quiet and why did you file this petition instead of going into the rigmarole of
Habeas
technicalities?
corpus. I would have only other option for me was, my lords, habeas corpus. Only habeas corpus. But my lords, I just submitted. My lords, for a moment, if the order of this honorable court in revision is to be given strict effect, then I will have to be in prison for the next 9 years. My lords. Next 9 years, at least. But even for murder cases, my lords, individual is in prison for 14 years max, though it is life imprisonment. 433, my lords, the state's power says 14 years. Even in that, they get remission and many times 9 years or 10 years they come out. My submission is only this much, that they have undergone the sentence if the appellate court order is put into effect. If my lords is convinced with this submission, my submission is, my lords may kindly observe in the order the dates in para 19 of my lords order, my lords may kindly see. Para 19, my lords, page 29. In each of the case, this honorable court has observed the date of arrest. Therefore, in the present case, it is not in dispute that the accused were arrested on 27/4/2015. The dates I have noted in my table, my lords, is what we have taken from the orders of my lords. Even if there is an observation that from these dates we are in custody in each of the cases. It's para 19 in all the cases, my lords. Same para. But dates are different. So even if it would be taken that we are in custody from this date onwards, my lords, my humble submission is, my lords, that even if a clarificatory order is passed, perhaps there wouldn't be a strict need to review or recall the order of such. And we have also been cautious enough, my lords, to mention these dates for the reason that the learned appellate judge, my lords, had taken note of a date which is the first date of the arrest, one common date for all the cases. My lord's order is to that extent, my lords, totally correct for the reason that first date of custody cannot be taken to all the cases. My lords had specifically observed same case. What is the meaning of same case? My lords has in detail discussed.
Corrected, para number 23.
Please, my lords. So para 23 onwards, yes. So given this, my lords, arrest in the first case cannot be taken into all the subsequent 8 cases. In each case, when I was produced before the court and remanded on body warrant, that is the date, my lords, this
For
honorable
reckoning.
court.
That is the point of date for reckoning.
Point of date for reckoning. Even if that benefit is given, my lords, perhaps these other details wouldn't be necessary as such.
So what is the order in criminal RP 100115? Where is that?
We have not challenged that, my lords.
No, where is that order?
We do not have that order. We can seek a copy of it.
File a Lydian order.
100115.
Criminal RP. You have the file with you? File.
But the records were not called for, my lords. My lords deemed it not necessary on the last occasion. Just to satisfy my lords may kindly see the next petition. It's page 32 in the second petition. Again indicates 100115.
all these crimes have been committed one after the other, is it?
But different, even we have given a chart as well as far as the dates of the offences are concerned in our petition, my lords. They're all one after the other. And no crime on one single date, there's no such offence. Different dates. Two 2011 onwards, my lords. Sorry, 2010 onwards.
Yes.
My submission says that now, if at all, even if there's a clarificatory order by this honorable court, my lords, that the order passed in appeal is not, remains as it is, extending the benefit of set off to these petitioners. And my lords, even if a date would be indicated in my lord's orders now as to from which day they have been custody in each case, we would be able to avail the benefit of the set off granted by the trial court, by the appellate court. To that extent, my lords, may kindly be pleased to allow these petitions. Though there are several other issues with regards to 267 body warrant, custody from which date, my lords. We have relied on the citation, but may not be necessary as such.
The record 10115 illa. You didn't find it with you?
We do not have that. As we never intended to, my lords, challenge that because we already had got the benefit in that case. There was no necessity. We can still, my lords, for whatever reasons, we would still secure, we'll see those records as well.
Yes, Madam Girija.
Please, Your Lordship. Your Lordship, the main contention in this matter, Your Lordship, I have heard the arguments of petitioner, Your Lordship. Now question arises, Your Lordship, the second revision petition, Your Lordship, maintainability of the petition. This is the second revision petition filed by the petitioner, Your Lordship. Under section 397 clause 3, Your Lordship, second revision is not maintainable. So the very
review or revision.
Review, my lords, is what we have sought. Though the office has numbered it, my lords, as a revision petition, my lords may kindly see the memorandum of criminal review petition filed under section 362 read with 482 of CRPC. But there is no possibility or there is no provision to number a criminal petition or a number of filing or as a new filing as a criminal review petition. A civil review petition does arise, but a criminal review petition does not. That reason, my lords, the office has given the number as criminal revision petition. The other way of doing it for us was, my lords, file an application for recall in the same revision petitions earlier. So irrespective of that, my lords, perhaps the petition, the nomenclature itself, my lords, would indicate that our prayer is 362 read with 482 of CRPC. There are other judgments also, my lords, of the Honorable Supreme Court. If need be, I can rely, but perhaps they may not be necessary.
Yes, madam, you go through the,
Worship.
what are the other citations that you want to rely?
My lords, please, I will draw my lord's attention to.
What you now just read is only about the jurisdiction
When it would arise, my lords.
of the court.
Now, please, my lords. Now, my lords, may kindly turn to page 102, Neve India Insurance. My lords, here there was an order passed in revision filed by an accused, wherein the Honorable Court in revision observed that there shall not be any, so that the employer shall not proceed against him departmentally. Now, that, my lords, created some issue for the employer, and thereafter they challenged it. My lords, the original order was not passed in revision. Revision came to be disposed, granting relief to the accused or the revision petitioner. Subsequently, an application came to be filed under 362. Kindly extend this benefit as well was what was sought, where the Honorable High Court was pleased to extend that benefit. Now, that, my lords, was later sought to be reviewed by the, my lords, Neve India Insurance Company. Now, my lords, may kindly turn to page 105. Para 10. Again, the same judgment Devender Pal Singh is relied upon, my lords. I'll still read, my lords, the first portion of the order of this judgment. Para 10, page 105. But the above contention of the learned senior counsel for the respondent is fallacious for two reasons. The first is that section 362 of code is expressly subject to what is otherwise provided by the code or by any other law for the time being in force. Though this code pointed out in Davinder Pal Singh that the exceptions carved out in 362 of the code would apply only to those provisions where the court has been expressly authorized either by the code or by any other law, but not to the inherent power of the court. This court nevertheless held that the inherent power of the court under 482 is saved, where an order has been passed by the criminal court, which is required to be set aside to secure the ends of justice, or where the proceedings amounts to abuse of the process of the court. I will skip the next para, my lords. Para 11 may kindly be seen next page. The case on hand is one where the respondent secured an order from the High Court behind the back of his employer, that his conviction will not have an impact upon the service career of the respondent. The High Court did not have the power to pass such an order. If at all, the High Court could have invoked, after convicting the respondent, the provisions of the Probation of Offenders Act so that the respondent could take shelter if eligible under section 12 of the said act. In this case, the High Court ventured to do something which it was not empowered to do. Therefore, the respondent cannot take umbrage under section 362 of CRPC. I will skip the rest of the para there. The next para next of the portion would only say that the opposing respondent itself had got the benefit under 362, who cannot now oppose the Neve India Insurance Company, that they cannot be granted it. Now, next judgment would be relevant, page 107. Daxaben versus State of Gujarat. Here, a petition under 482 had come to be allowed. Offense under 306 of IPC. FIR came to be quashed. The complainant later challenged it, that he was not heard in the matter. Now, thereafter, the Honorable Supreme Court, may kindly turn to page 110, para 21. 3 short paragraphs, my lords, may kindly permit me to read.
Yes.
In para 21, in Krishna Kumar Pandey, this court referred with approval to the judgment of this court in state of Punjab versus Devendra Pal Singh Bular, where this court held that the High Court was not denuded of inherent power to recall a judgment and or order which was without jurisdiction or in violation of principles of natural justice, or passed without giving an opportunity of hearing to a party affected by the order, or where an order was obtained by abusing the process of court, which would really amount to its being without jurisdiction. Inherent powers can be exercised to recall such orders. The High Court rightly found, in effect, that it had the inherent power to recall a judgment and or order which was without jurisdiction, or a judgment and or order passed without hearing a person prejudicially affected by the judgment and or order. The High Court, however, fell in error in not recalling the order dated 20th October. The High Court did not address to itself the question of whether it had jurisdiction to quash the criminal complaint and so on. The High Court erred in declining the prayer of the appellant for recalling its order dated so and so passed without hearing the wife of the deceased only because the original informant complainant, a cousin, brother, and an employee of the deceased had been heard. Hearing a cousin's once. So my submission is these three judgments of the Honorable Supreme Court would perhaps make it evidently clear, my lords, that powers do exist under certain circumstances, and those circumstances have been specifically indicated. I have also relied on three other judgments, my lords, of the High Courts as only as a persuasive value and not, my lords, as precedent. One is Calcutta High Court, my lords, at page 83. I don't intend to read it, my lords. Patna High Court at page 92. And one judgment of our Honorable High Court, my lords, a coordinate bench at page 121. Now, other judgments, my lords, would be relevant, would be page 138, power in revision. I don't intend to in detail go through that. Lords may kindly see in that particular judgment, the paragraph 11 onwards, 11 to 17 would be important, lords, would be necessary. It indicates as to what powers. Now, eventually, state, I submit, in conclusion, I would submit, state had not approached. But I would not say that an order was passed by this Honorable Court reversing the order of an appellate court. The position of law that this Honorable Court, or interpretation of section 428, which came to be passed by this Honorable Court, has affected the right of the accused, and that has, my lords, it has gone to his disadvantage, which perhaps now the jail authorities are not able to invoke the benefit which was granted.
Who argued for the petitioner? Who argued for the petitioner?
To my knowledge, then I'm informed that it was again through the
Legal services.
legal service. All through, even in appeal, my lords, I'm informed it is through the legal service authority.
Remember. All right, madam, just go through it.
Please, Your Lordship, and even the order, this Honorable Court has passed the order in their 2020, Your Lordship, and now it is 24. There is a delay also in filing. And Your Lordship,
Let us see. Let's go through that first.
please,
Even I have held in the order that already he has the benefit of the set off.
please, Your
Which is
Lordship.
given by the appellate court.
How do?
Now, the question is, by interpreting 428, what he claims that he had a better chance, which he was granted to him by the appellate court, is now trifled by the order of this court, is the one
Then
which has
he
to
would
be.
have not filed the petition before this Honorable
No,
Court
no.
only.
That is for the counsel who should have said so then
Said,
and argued.
please.
Then,
How?
before this court 4 years back when he argued. What he
Please.
submitted then, I don't remember now. My memory is not
Of
so
course.
sharp.
No, Your Lordship,
Nevertheless,
anybody
we will
cannot.
go through.
Submissions were not made, my lords. It's clear from the order.
Just look through the provisions of the 428 and see, because the other aspects are also involved in it as to how the review and revision can be entertained once again. That is another aspect.
That is,
In that even my only submission would be that these may have to be treated as an application in the revision itself. Even to that extent, if otherwise, my lords, I have to file a detailed, fresh application relying on all these documents again. It should, to that extent, or even if an order is passed by this Honorable Court, permitting me to convert these petitions into an application in the very same revision petition as such.
No, that technicality this court will not really mind. The question is whether your review is maintainable or if it is treated as a revision. Revision, of course, will not arise.
Revision is not, it cannot arise.
It is barred.
It is barred.
It is
Totally.
anyway
Even
barred.
I would say that.
397(3) is anyway barred.
There can't be a second revision.
There cannot be a second.
Please.
Question is only if there is a review, then whether there is any ambiguity of considering it under the provision of 362.
But for that, only this Supreme Court judgments is all that I would.
but in that
Supreme
the
Court
Supreme
says
Court
the
judgment
Supreme
which the
Court, whatever
petitioner
you have
comes.
relied, does not say that you can agitate it in 397.
I have not invoked 397. I've invoked only 362, read with 482.
In
Correct.
362 also, Your Lordship, at page number 65, wherein the petitioner counsel has referred the judgment, Your Lordship, paragraph 44. In earlier paragraphs, the Honorable Supreme Court has stated, Your Lordship, there is no power to review with the criminal court after the judgment has been rendered. The High Court can alter or review its judgments before it is signed. When an order is passed, it cannot be reviewed. Section 362 of CRPC is based on the acknowledged principle of law that once a matter is finally disposed of by a court, the said court, in the absence of the specific statutory provision, becomes the functus officio. And
That is well established principle, both in civil law and criminal law.
please, Your Lordship. Even if opportunity has not been given, then only. But in this matter, lengthy it was heard, and this honorable court has passed the order on merits, Your Lordship.
Petitioner counsel has hit his own foot,
Huh.
and rather not only his
That
own
is-
foot, he put the grave on the client, pushed him
Please,
further
Your
down.
How?
This
That
exercise
is
was
why
not,
in civil or criminal, you should know how to argue, when to keep quiet, when not to challenge, and when to say, I will withdraw my case.
Please, Your Lordship.
All right, just go through it. Just see. I will also go through it.
please.
Please, Your Lordship.
Barcode. Heard learned counsel, Sri Amber Korea. On behalf of Vishwanath. ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಲ್ಲ?
ನಾವು ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ. We are not.
It's better you file wakalat because you are not designated anyway yet.
Not, I understand we have filed, it was filed in Dharwad, my lords, because Mr. Vishwanath Bijagati, he practices
Which
there.
is-
It was filed there. I understand I have filed, I will anyway check, my lords, if not, I will file it.
Korea on behalf of Vishwanath Bijagatti for petitioner. Learned CGP Srimati Girija for respondent state. All this matter on. How much time you need, madam?
Next week, Your Lordship.
All right, released on 24th.
No, Your Lordship, 27, any Friday, Your Lordship, because Monday, Tuesday, criminal cases.
27th.
Please, Your Lordship.
27.
Please, lords. Deeply obliged.
Please, Your Lordship.
First our matters, number 41. Sri Chetan Nag. Chetan Nag, yes.
There's no representation in the matter is called out for the second time in the day at 3:50 PM. Call this matter on next week, 20th.
Number 43. Sri Prakash MH.
Yes, Mr. Prakash.
Sorry, my lord, I took password.
No problem. You're
Okay,
seeking
concurrent
suspension.
finding in,
Suspension.
suspension, my lord.
What is the offense?
Well, the arrest out of 138 Proceedings in the Negotiable Instruments Act.
Any delay?
No delay, my lord, sir.
Heard learned counsel for the petitioner. Issue notice to respondent.
For the
Orders on IA1. The order of sentence dated 7/2/18 in CC 1812/014 passed by 20th Additional Chief Metropolitan Magistrate Bengaluru. Confirmed in criminal appeal number 513 of 2018. Confirmed, Allah?
Please.
Dated 23/6/20 by the additional It is civil and sessions judge is suspended. Petitioner is enlarged on bail, subject to following conditions. Petitioner shall deposit
15% is
50% of the
deposited
final
in
amount,
the-
inclusive of already deposited.
Please.
You have deposited something?
15% what I have instructed, about 80,000. So before the lower, I mean, appellate court in appeal.
So inclusive of that 50% you deposit,
50%.
50. Inclusive of already deposited within 4 weeks.
Please. Lord, may I request, can it be bring down to some reasonable extent? 50% is.
No,
the-
this is a
the
standard order
final-
which I.
Yeah, yes, please, please. I can, I
I'll
know.
grant
it,
you 6 weeks instead of 4 weeks. 6 weeks from the
Please.
date of, from today. Rupees 1 lakh personal bond and surety.
Number 45, Sri Ajay Kadkol. Sri Ajay Kadkol.
Mr. Prakash, you are seeking reduction on any ground of medical and then it can be considered. Any medical reasons you are seeking for reduction of from 50% to reduction
No. So. the
because
case-
of your financial inability?
Yes, the thing is, the petitioner is defrauded by the person in, she stood, the allegation is that she stood as surety. Amount was given to one Srinivas who happens to be the.
That is on the again merits. sir.
Yes, yes, again. So,
This court would have considered if there is any medical emergency or otherwise.
no, no such things.
You see how much you deposit, then you can still seek time further.
Please. Oblige me.
45, Sri Ajay Kadkol.
Ajay, stay Bandela. This matter is called out for the second time in the day at 3:54. There's no representation. Call on.
Number 61, for final hearing, Sri Shankarappa. SPP.
What is this?
Argument is over.
This is that alteration,
Yes, my alteration 376.
376.
And that in this case, my lord, 376 punishment is shall not less than 7 years. And it may extend to life imprisonment.
That extension to life is there, but is it anywhere said it is shall not
Less than 7 years,
read that?
but such type of cases, Lord, even without a trial,
376. Which shall not be less than 10 years.
yes. 376.
But anyway, here the application that is filed is 216.
Yes,
216.
discharge application.
No, no. Not discharge.
The trial court rightly dismissed the application filed by the accused. Not
Discharge. This is application under 216.
yes.
What do you have, sir?
That did, dismissed by the session court.
This application filed by the accused is under 216 CRPC.
Yes.
This that Shankarappa who argued.
Yes, yes.
Mate, You're saying discharge.
Alteration of.
So alteration will not arise, is what your submission is.
Yes.
I'll pass orders.
Alteration cannot be,
I'll pass orders.
because great injustice will be caused to the
Not
victim.
injustice, you see the legal aspect of it, whether alteration is permissible. Already in this, he had filed discharge. He had filed earlier discharge.
No, my lord. 216 application. is,
Correct. Prior to
rejected.
216,
Yes,
was there any application for discharge filed by him?
only 216.
Huh?
216.
Mr. Lakshman. ಈ 216 application ಮುಂಚೆ discharge application ಯಾರು ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ ಸರ್, ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿ.
All right. Now, what is the stage of the trial?
Trial, I have to find out.
You should
I have
know
to
that all.
take
All
information.
details you should take out. The completion you are saying you don't.
Is there having any stay? The proceedings will be stayed. my lord.
Whether stay was granted in this? Huh?
On that day, submitted that there is a stay.
Entry mod ಇದೆಯಲ್ಲ. Further proceedings are stayed.
Yes.
2015. All right. This matter. On 18th,
Yes.
I will pass orders. So by then you secure instructions.
Yes.
Whether you give this to him, you check up whether earlier he had filed any application for discharge. All right, call him. Heard further learned counsel for both sides. Is this matter on 18th for dictation?
Yes.
For 62, Sri N.G. Parameshwarappa, Sri Harish Bhandareti.
For petition one. On a 2 weeks, maybe time may be granted for 2 weeks time.
Yes, where is Mr. Bhandari? What is this offense?
138, you are.
Why you want time? Why you want time?
I am proxy counsel, Your Honor. There is
No, it will not be given. Pass over. Argue the matter.
63 adjourned, number 64, Sri Prasad
Sir.
B.S.
Prasad B.S. What is this?
Sir, SPP.
Lokaಯುಕ್ತದ.
Convicted under section 354 IPC. That 9 years child. So convicted only for 6 months. Sexual assault against the 9 years child.
You ready your papers?
Don't have.
Pass over. Pass over.
Pass over.
Srinivasan.
5 adjourned, number 66.
Srinivasan.
The case Mohit Kumar.
Paper petition, my lord. Name said argument. For others, respondents argument.
ನಿಮ್ದು ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಮೋಹಿತ್ ಕುಮಾರ್. Mohit Kumar.
The Mohit Kumar.
As learned counsel for petitioners present. No representation on behalf of respondent to provide one more opportunity. Just this matter on date 23, 24, 25.
24.
24th.
Number.
Yes, Mr. Vivek.
Number 67, Srimati Ganga Baivi.
What is this case?
304, my lords, with 379A, my lords. Case of conviction. The situation, my lords, where the accident took place in the night. Lorry, while reversing, killed the person who was on the rear side of the vehicle. Lords, unfortunately, he died at the spot. There were crush injuries. The situation is, my lords, the person who died at the spot was along with three others in the place, my lords, and they are claimed to be the eyewitness, my lords. But my humble submission is none of them have seen the person, the accused. And my lords, they all contend that they have seen him on the next day in the police station, my lords. But your lordships,
Who are these witnesses, PW 1 to 3?
yes, my lords.
Who are they?
They are the neighbors and friends, my lords.
No, were they available at that point of time?
They were available at the point of time, my lords. Now, the position is, my lords,
That PW one complainant, he was going along with the deceased.
Hmm.
And
Yes.
lords, all the witnesses, my lords, the eyewitnesses alleged, the position is they take a contention that they saw the accused when in the cross-examination. They contend that they have seen the accused in the police station the next day, my lords. But the irony is, my lords, the accused is shown to be arrested 3 days after the incident. So very clearly, identification is a issue, my lords. And my lords, my humble submission is no test identification parade is done. There is no way they could have identified the person, my lords. My humble submission is on that ground. That ground, the trial court is completely ignored. My humble submission is, if I were to read the chief and the cross-examination, it would clearly show that the identification of the accused.
Who are the eyewitnesses in the incident?
My lords, sir.
my lord, as per the PW 3, my lord,
Hmm.
he is one of the eyewitness.
Hmm.
He deposes that he was trying to hold the accused,
Hmm.
but he escaped.
Hmm.
Before the court, he identifies the accused persons. This is the person I tried to.
That is his
hold.
statement and that is also his evidence.
Yes, my lord.
So that is
Deposition, in his
in
deposition.
his deposition.
Yes, my lord.
So this is stated anywhere else
PW3.
also? This fact is stated anywhere else also?
So I have seen
Complaint
that.
FIR? Who gave the
Complaint,
complaint?
In complaint, it is not there, my lord. As
The
per the
complaint.
PW 3, in his
Who's the
deposition,
complainant?
complainant is a PW 1, my lord.
Who's he? Where was he? How did he
Was
know?
going along with the deceased.
He was going along with deceased.
Yes.
He was a pedestrian or walking by. What is the case?
My lords, they were going together, my lords.
They were pedestrians, not connected with the accused.
No, my lords, they were not connected with the accused. They were pedestrians. My
So this which is the vehicle?
lords, a lorry, my lords.
So he was taking a reverse.
He was taking a reverse, my lords.
So
And it runs over one of the.
he was alone or was there a cleaner?
My lords, there was no other person.
No other
No
person.
other person.
So PW3,
After the incident, the lorry driver immediately escapes from the place. He is not there.
what is the evidence of PW3?
Lords, PW3 is, Lords, they say that the incident happened. They have not seen the person.
We'll read the evidence.
Yes, my lords. If I may draw your lordship's attention to
What is it?
PW 1, the complainant witness, Malleshappa. If I may quote, if I may read.
PW1.
Yes, minutes. ಮಲ್ಲೇಶಪ್ಪ ಹೆಸರು ತಂದೆ ಹೆಸರು ಬಟ್ಲ ಮಲ್ಲಯ್ಯ 60 ವರ್ಷ ವ್ಯವಸಾಯ ಹಿರೇಹಳ್ಳಿ ನನಗೆ ಆರೋಪಿ ಗೊತ್ತಿಲ್ಲ ನನಗೆ ಚಾಸ 2, 3, 13 ಹಾಗೂ 14 ಗೊತ್ತು ದಿನಾಂಕ 10/9/13 ಸಂಜೆ ಹೊಸೂರು ಅಂದ್ರೆ ಐ ಥಿಂಕ್ ದೇರ್ ಇಸ್ ಅ ಮಿಸ್ಟೇಕ್ ಆರ್ ಸಮಥಿಂಗ್ ಹೊಸೂರಿನ ಬಳಿ ನಾನು ನಡೆದುಕೊಂಡು ಬರುತ್ತಿದ್ದೆ ನನ್ನ ಜೊತೆಗೆ ರಾಮಚಂದ್ರಪ್ಪ ಮಲ್ಲಿಕಾರ್ಜುನ ಕೊಲ್ಲೂರಪ್ಪ ಇಸ್ ದ ಡಿಸೀಸ್ ಬರುತ್ತಿದ್ದರು ಹಿರೇಹಳ್ಳಿ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಬಳಿ ಹೋಗುತ್ತಿದ್ದೆವು ಎದುರುಗಡೆಯಿಂದ ಲಾರಿ ಬಂತು ನಾವು ಸೈಡ್ ಕೊಟ್ಟೆವು ಲಾರಿ ಮುಂದೆ ಹೋದ ಮೇಲೆ ನಾವು ರಸ್ತೆಗೆ ಬಂದೆವು ಆಗ ಲಾರಿ ಹಿಂದಕ್ಕೆ ವಾಪಸ್ಸು ವಾಹನ ತಂದ ಕೊಲ್ಲೂರಪ್ಪ ಟೈರ್ಗೆ ಸಿಕ್ಕಿಕೊಂಡು ಸತ್ತು ಬಿಟ್ಟ ನಾವು ಆ ಕಡೆ ಈ ಕಡೆ ಎಗರಿ ಬಿಟ್ಟೆವು ಚಾಲಕನಿಗೆ ನೋಡುವುದಷ್ಟರಲ್ಲಿ ಓಡಿ ಹೋಗಿದ್ದ ಲಾರಿ ಚಾಲಕನ ದುಡುಕುತನ ನಿರ್ಲಕ್ಷ್ಯತನದಿಂದ ಈ ಅಪಘಾತವಾಗಿದೆ. If I may draw your lordship's attention to the cross examination, that's the next page. ದಿನಾಂಕ 13/9/13 ಅಪಘಾತವಾಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಲಾರಿ ನಂಬರ್ KA 16 B 5001 ಆಗಿತ್ತು ಎಂದರೆ ನಾನು ನೋಡಿಲ್ಲ. ಮಹಜರ ಸ್ಥಳ ನಾನೇ ತೋರಿಸಿದೆ ಎಂದರೆ ಸರಿ. ಸುರೇಶ್ ಚಂದ್ರಪ್ಪನ ಸಮಕ್ಷಮ ಮಹಜರನ್ನು ಬೆಳಿಗ್ಗೆ 10:10ವರೆಯಿಂದ ಮಾಡಿದರು. ದಟ್ ಇಸ್ ನಾಟ್ ಕ್ಲಿಯರ್. ಮಾಡಿದರು ಎಂದರೆ ಸರಿ. ಅಪಘಾತ ಪಡಿಸಿದ ಲಾರಿಯನ್ನು ಅಮಾನತು ಪಡಿಸಿದರು ಎಂದರೆ ಸರಿ. ನಂತರ ಲಾರಿಯ ಚಾಲಕ ಶರಣೇಶ್ ಎಂದು ಗೊತ್ತಾಯಿತು. ಅದರ ಬಗ್ಗೆ ಮರು ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ. Lordships may kindly appreciate, ನಂತರ ಲಾರಿ ಚಾಲಕ ಶರಣೇಶ್ ಎಂದು ಗೊತ್ತಾಯಿತು. He has not seen the person. If your Lordships were to kindly see the next party savalu, the cross examination. ನಾನು 10ನೇ ತರಗತಿಯವರೆಗೆ ಓದಿದ್ದೇನೆ. ಪೊಲೀಸರ ಕೋರಿಕೆ ಮೇರೆಗೆ ಸಹಿ ಮಾಡಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ ಕನ್ನಡ ಬರೆಯಲು ಬರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಫಿರ್ಯಾದಿನಲ್ಲಿರುವ ಅಂಶಗಳಿಗೂ ಹಾಗೂ ನನ್ನ ಸಹಿಯ ಬರವಣಿಗೆಗೂ ವ್ಯತ್ಯಾಸ ಇದೆ ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ P1 ನನ್ನ ಬರವಣಿಗೆಯಲ್ಲಿಲ್ಲ ಇಲ್ಲ. ನಿಶಾನೆ P1ರಲ್ಲಿ ಏನು ಬರೆದಿದ್ದಾರೆಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. The last paragraph, if I may draw your Lordship's attention, ಮಹಜರ್ ಸ್ಥಳದ ಪೂರ್ವಕ್ಕೆ ಡಾಬಾ ಅಂಗಡಿ ಇದೆ. ದಕ್ಷಿಣಕ್ಕೆ ಮನೆ ಇದೆ. ಪೊಲೀಸರು ಮಹಜರನಲ್ಲಿ ಏನು ಬರೆದಿದ್ದಾರೆಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಕೇವಲ ಸಹಿ ಹಾಕಿದ್ದೇನೆ. ದಿನಾಂಕ 13/9/2013 ಎನ್ನುವ ದಿನಾಂಕ ಸರ್ಕಾರಿ ವಕೀಲರು ಹೇಳಿದ್ದರಿಂದ ಗೊತ್ತಾಯಿತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. So my humble submission is, he has not seen the
What is who's PW2?
PW2, Milords, is Mallikarjuna, the other person, Milords, who was there along with the deceased. If I may quote, if I may draw your Lordship's attention, if I may, in fact, if I may draw your Lordship's attention directly to the next page, Milords, the second page, if I may quote, sorry, if I may just draw your Lordship's attention to the first page of that PW2, Milords, the second paragraph, the last sentence, ಅಪಘಾತ ತಕ್ಷಣ ಆರೋಪಿ ಸ್ಥಳದಿಂದ ಓಡಿ ಹೋದ. Next page, if I may draw your Lordship's attention to the second paragraph. ಆರೋಪಿಯನ್ನು ಇದೇ ದಿನ ಮೊದಲ ಬಾರಿಗೆ ನೋಡುತ್ತಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ. ದಿನ ನಾನು ಆರೋಪಿಗೆ ನೋಡಿಲ್ಲ. ಆದರೆ ಘಟನೆ ಮಾರನೇ ದಿನ ಠಾಣೆಗೆ ಹೋದಾಗ ಇವರೇ ಆರೋಪಿ ಎಂದು ಗೊತ್ತಾಯಿತು ಎಂದು ಸಾಕ್ಷಿ ಸ್ವತಃ ನುಡಿಯುತ್ತಾರೆ. ಮಾರನೇ ದಿನ, so the next day he says he's seen him in the police station and I get to know that he is the accused. ಮಾರನೇ ದಿನ ನನಗೆ ಪೊಲೀಸರು ಠಾಣೆಗೆ ಕರೆಸಿದ್ದರು. ನಾನು ಠಾಣೆಗೆ ಮೊದಲ ದಿನ ಹೋದಾಗ ಆರೋಪಿ ಇರಲಿಲ್ಲ. ಮತ್ತೆ ಹೇಳಿಕೆಗೆ ಮಧ್ಯಾಹ್ನ ಕರೆದಾಗ ಆರೋಪಿ ಠಾಣೆಯಲ್ಲಿದ್ದರು. ಪೊಲೀಸರಿಗೆ ಕೊಟ್ಟ ಹೇಳಿಕೆಯಲ್ಲಿ ಏನು ಬರೆದಿದ್ದಾರೆಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. So my humble submission is, he says that he's seen the next day. If I may draw your Lordship's attention to PW3, Milords. PW3 is Ramchandrappa. If I may draw your Lordship's attention to directly the second paragraph, Milords. ಲಾರಿ ಆ ದಿವಸ ಯಾರು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಲಾರಿ ನಂಬರ್ KAB 5001 ಆಗಿತ್ತು. ನಾನು ಚಾಲಕನನ್ನು ಹಿಡಿದುಕೊಂಡೆ. ನನ್ನನ್ನು ನೋಡಿ ಆತ ಓಡಿ ಹೋದ. ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ವ್ಯಕ್ತಿಯೇ ಆ ವ್ಯಕ್ತಿಯಾಗಿರುತ್ತಾನೆ. ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ಚಾಲಕನ ಕಾರಣದಿಂದಲೇ ಅಪಘಾತವಾಗಿದೆ. ಲಾರಿಯನ್ನು ನೋಡಿದರೆ ಗುರುತಿಸುತ್ತೇನೆ. ಅದರ ಬಗ್ಗೆ ಪೊಲೀಸರಿಗೆ ನಾನು ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ನಿಶಾನೆ P3 ಮತ್ತು 4ರಲ್ಲಿರುವ ಲಾರಿಯಾಗಿರುತ್ತದೆ. Those are photographs, P3 and P4. ಪಾರ್ಟಿ ಸವಾಲು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. 15ನೇ ತಾರೀಕು 2013 ಶುಕ್ರವಾರದಂದು ಹಿರೇಹಳ್ಳಿಗೆ ಬಂದಿದ್ದೆ. ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ಆರೋಪಿಗೆ ಈ ದಿನವೇ ನೋಡುತ್ತಿದ್ದೇನೆಂದರೆ ಸರಿ. ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ಆರೋಪಿ ಈ ದಿನವೇ ನೋಡುತ್ತಿದ್ದೇನೆಂದರೆ ಸರಿ. ಆವತ್ತು ತಪ್ಪಿಸಿಕೊಂಡು ಹೋದವನು ಇವತ್ತೇ ನೋಡುತ್ತಿದ್ದೇನೆಂದರೆ ಎಂದು ಸಾಕ್ಷಿ ಸ್ವತಃ ನುಡಿಯುತ್ತಿದ್ದಾರೆ. In fact, PW says that he saw the accused the next day. If I may now draw your Lordship's attention to the IO's witness, the investigation officer.
But PW3 says he caught hold of him.
But Milords, in the cross examination, he says, I'm seeing him in the court for the first time.
But There may be minor inconsistencies. But you have not denied the question or put a question that you have never caught him. He ran away from the spot. Did you put such a question?
If I may draw your lordship's attention
You
to
are
the
making
second
a
paragraph.
false statement. You are making a false statement. You did not catch him. He was not caught at that time. He ran away.
That's,
That is not denied.
that is not this one. Suggestion is not put. But he says that you are seeing him for the first time in the court minutes.
No, after that day, he said, further you read.
If I may just read it, see if I may just read.
ನ್ಯಾಯಾಲಯದ
ಮಿಲಾದ್ಸ್ ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ಆರೋಪಿಗೆ ಈ ದಿನವೇ ನೋಡುತ್ತಿದ್ದೇನೆಂದರೆ ಸರಿ. ಆವತ್ತು ತಪ್ಪಿಸಿಕೊಂಡು ಹೋದವನು ಇವತ್ತೇ ನೋಡುತ್ತಿದ್ದೇನೆಂದರೆ ಎಂದು ಸಾಕ್ಷಿ ಸ್ವತಃ ನುಡಿಯುತ್ತಾರೆ. ನಾನು ಘಟನೆ ದಿನ ಆರೋಪಿಯನ್ನು ನೋಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಹಿಡಿದುಕೊಂಡಿದ್ದ ಆತ ಓಡಿ ಹೋದ ಎಂದು ಸಾಕ್ಷಿ ಸ್ವತಃ ನುಡಿಯುತ್ತಾರೆ. ನಾವು ಮಲ್ಲೇಶನ
satisfies.
Milords, my humble submission is, Milords, your lordships may kindly see the next, this one. He also says, I've seen him the next day in the police station. No.
See,
No.
These
My
are all,
humble submission is
what
this.
is the occupation of this man? What
The
is his
occupation is
vocation?
ಕೂಲಿ ಕೆಲಸ.
ಮತ್ತೆ how they will know to answer what all.
My humble
We have
submission
to
is,
understand the evidence of a witness on the basis of his education, occupation. Adina nodidira, but he never denies that. He says that he saw it, he caught hold of him in chief. In the cross examination, Adina is seeing him for the first time. But on the previous day, he ran away. And the other question you put is denied by him.
but my humble submission is, Milords, the situation is, there is no test identification. He's a new person, he is a stranger. Milords, identification is required, Milords. My humble submission is,
Identification is required when a person has not at all seen him.
Milords,
It's the eyewitness who caught hold of him.
Milords, my humble submission is, Milords, he's seen him after a gap of so many months, Milords. The incident happened, Milords, in 2013, Milords.
Incident happened on?
13/9/2013.
All right.
The cross-examination, Milords, happens,
Just about 6 months.
no, Milords.
Twenty-six, 3/14 is the evidence.
Answer given. Milords.
Anything else in your favor other than this? See, if your story could have been believed if that person just ran away, nobody saw him. These people, PW 1, 2, and 3 were accompanying the deceased. One of them has caught hold of him. Other 2 has probably said in your favor. If the third witness had not said that I did not catch him, he ran away, I did not see him, then it would have been different.
Milords, my humble submission is, if I may just draw your lordship's attention to the third paragraph also, Milords. My humble submission is, I'm also relying on a case law insofar as the test identification parade, Milords.
No, that is
Though-
not in dispute.
Yes, Milords. So my humble submission is, Milords, it wouldn't have been, Milords, your lordships may kindly appreciate the incident happened at 9 o'clock in the night, Milords. There was no proper lighting. In fact, the situation is there is some jatre happening in the village. And my lords, my humble submission is, he could not have identified in the dim light. And such being the case, it was necessary to at least ensure that there is proper corroboration by conducting a test identification parade. my lords.
All right. Next.
That's it. my lords.
Now, whether it is 9 o'clock or 12 o'clock in the night, once a person is caught hold, you catch hold of a person, he's so close proximity that you cannot miss him, miss the sight of him. You have seen him on the next day.
Next day, he's not seen, my lords.
Ah.
My humble submission is that is a discrepancy, my lords. In fact, he's arrested 3 days later. If I may draw your lordship's attention to the evidence of the IO, my lords.
Ah.
IO, my lords.
Because he ran away from the spot.
Yes, my lords. He was brought, or probably he was arrested 3 days subsequent to the incident. my lords. If I may draw your lordship's attention to the Manjunath, sorry, PW 8, my lords. Manjunath, the police inspector. If I may draw your lordship's attention to the second paragraph. ದಿನಾಂಕ 16/9/2013 ಲಾರಿ ಚಾಲಕನಾಗಿದ್ದ ಆರೋಪಿ ಟಿ ಶರಣೇಶ್ವರ್ ಅವರನ್ನು ದಸ್ತಗಿರಿ ಮಾಡಿರುತ್ತೇನೆ. So there is no way he could have been seen in the police station on 14. That is the next day of the incident. In fact, the owner is summoned, owner is examined.
As?
Let's, CW 4 minutes. Shilpa.
PW?
PW 4 minutes. In fact, he says that I'm not aware who was driving the vehicle on that day. Lords, my humble submission is all the drivers list could have been elicited. The drivers could all be summoned and test identification not to have been conducted. my lords.
All right. What have you stated in your 313 statement?
We have denied it.
So only now PW3 is 1, 2, 3. PW3 is the one who positive statement is that he's caught hold of you and seen you. What
Yes.
about other witnesses?
PW2, he says, I've seen the next day. On the face of it, it gets demolished. PW1 says he hasn't seen me.
What about others? They're all
The others are not eyewitnesses.
Other witness and
Other
police.
witnesses.
Yes.
Lord, as per the PW3, my lord, it clearly states, ಲಾರಿ ಆ ದಿವಸ ಯಾರು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದರು, ಆದರೆ ಲಾರಿ ಸಂಖ್ಯೆ KA 16B 5001 ಆಗಿತ್ತು. ಹಾಗೂ ನಾನು ಚಾಲಕನನ್ನು ಹಿಡಿದುಕೊಂಡೆ. ಆಗ ತನ್ನನ್ನು ನೂಕಿ ಆತ ಓಡಿ ಹೋದ.
This is your in chief. In
Yes,
chief.
my lord. Yes.
Where are you?
ಓಡಿ ಹೋದ ಹಾಗೂ ನ್ಯಾಯಾಲಯ ಮುಂದೆ ಇರುವ ಆರೋಪಿಯೇ.
Where are you reading? Where are you reading?
This is judgment observed by I don't have deposition, my lord.
Sir, last time.
But the deposition Odayan Prajana, you have to read that. I mean, judgment Odayan Prajana. You have to read the deposition. Now you are reading what? Judgment?
Yes.
No, that judgment is in challenge before this court.
You
You can't
I'll
read
get
that judgment.
observed.
You have to read from the deposition whether the trial court judge has extracted what is told by the witness. You get hold of the deposition from him.
Because I gave him last time.
ಕೊಟ್ಟಿದ್ರಂತಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ ಸರ್ ಕೊಡ್ತೀನಂದ್ರಿ ಕೊಟ್ಟಿದ್ರೆ ನಮ್ಮ ಹತ್ರ
ಫೈಲ್
ಇರುತ್ತೆ.
ತಗೊಂಡು ನೋಡ್ಕೊಳ್ರಿ.
ಕೊಟ್ಟಿದ್ರೆ ನಮ್ಮ ಹತ್ರ ಇರುತ್ತೆ
Sir,
ಕೊಡ್ಲಿಲ್ಲ.
On the last
There is
occasion.
no point in reading the trial court and appellate court order. So trial court, if committed error, appellate court upholding that again is an error. So it has to emanate from depositions, like he was reading. The PW3 according to you court hold of him. That is what you have to read. So read that further. I listed on Wednesday.
Please.
Go through that. PW3 is your main witness now.
Yes.
Anybody else you see? Because he is
Motor
not
vehicle.
fully read 1, 2 and 3.
Who
You can-
issued IME report.
Ah.
There is no mechanical defect.
No, even if there is no mechanical defect, there has to be something cogent. It's pinpointing that the accused was the one who was driving the vehicle. He was apprehended, caught, arrested at that point of time, or eyewitnesses or circumstantial evidence to pinpoint the guilt against the accused beyond all reasonable doubt. So your main witness, as of now, what it appears to me is
PW3.
PW3.
Yes.
I don't know about others, you read it. All this matter on 18th.
Yes.
You want, you can take the file or give him one set
I'll give one more set.
and take one signature always from Lakshman.
Yes. Sir.
Much better.
68, Sri Mohan Kumar D, SPP.
Appear for the petition in this case, my lordship. Short accommodation, my lordship. Senior not feeling well. Decided
Counsel
discharge, my lord.
seeks adjournment on the ground of ill health of a senior colleague, arguing counsel. Senior colleague, but arguing counsel. Call this matter on 23rd,
23rd September.
Mallikarjuna.
69 adjourned, December
Sampath.
70, Sri A. Sampath, HCGP. Sri A. Sampath,
71, my lord.
What is the offense, Mr. Lakshman?
Not 6, my lord.
306?
306 IPC.
Ah.
Misappropriation.
Ah.
Criminal breach of trust.
Hmm.
Petitioners. 406, my lord, not 306. It's a 406.
406.
Please, my lord, criminal breach of trust. The sole accused, my lord. It's a concurrent finding. My lord, he has been convicted for 3 years and directed to pay compensation of 7,20,000.
Hmm.
Case of prosecution is that, my lord, the sole accused, my lord, they claim he's a driver, my lord, working under the owner, CW4. The complaint says that, my lord, the accused, my lord, is a driver. CW1, who is a complainant, is a manager come accountant. And CW2 is a worker who is also works with the owner CW4. CW3, my lord, is a common person, my lord, who joined this, all these 3 persons. The accused CW1, 2, my lord, and 3, 4 people, my lord, they say they went to purchase the mangoes at for vending for the owner. They say, my lord, the vendor who is the owner, who is the CW4, is the he is a businessman who, my lord, say business of the mangoes. For that purchase, my lord, purpose, the CW1 went to purchase the mangoes, accompanied by the driver, my lord, the accused. They went, my lord, Srinivaspura, the place of Srinivaspura, and they stopped the vehicle, who is a Bolero vehicle.
Srinivaspura, Kolar.
Please, my lord, Srinivaspura, Kolar. They say, my lord, they stopped the vehicle there at about 3:30 p.m. And now, my lord, leaving alone the accused, who is the driver, the manager, who is the complainant CW1, and, my lord, the 2 other persons, my lord, they say 7,20,000, which was given by the owner CW4 for purchasing the mangoes to the CW1, 2, 3, my lord, for all these persons. They say, my lord, instead of they carrying the amount to purchase the mangoes, they say, my lord, they gave that amount to the driver accused, who's a driver, and they said, you keep this amount of 7,20,000, which is a cash. We'll go and we'll just negotiate with the purchase of the mangoes. And they say, my lord, leaving the amount with the accused, 7,20,000, they went to negotiate the mangoes While they returned back, my lord, the accused along with the money and the car was not found. Then, my lord, they apprehended that, my lord, he has fled with the amount. They complained to the owner what to do, my lord. This owner claimed that try to search the accused with the, if he not found, my lord, give a complaint. And they say, my lord, next day they gave a complaint. After 3 days, my lord, the bolero, the vehicle was found in a forest. No, my lord, the prosecution also says, my lord, they are unable to trace the accused. And the C report was filed, my lord. After 8 years, the accused was found in the bus stand, some Kolar bus stop, and he was charge sheeted for 406 months. And my lord, all the witness, my lord, they say, the case, my lord, the incident happened in the year 2004, my lord. Not what comes in my mind is my humble submission. It was 7,20,000 the cash amount, my lord. And what was the authority or the entrustment? Why they have gave this amount to the driver when, my lord, the manager already accompanied with 2 other persons? Is the one doubts, my lord, which comes in my mind. Because 7,20,000, my lord, huge amount in the year of 2004. My lord, such an amount, my lord, what is the trust, my lord, they have to show? They got such a trust to give that amount to a driver who is accused. Lord, the accused defense is, my lord, he said, I am not a driver, I never worked. And it is his defense is that, my lord, the owner had some enmity with this accused. So that is why, my lord, so normally has been fit in this case, but that is a defense. Well, to prove the case beyond reasonable doubt is on the prosecution. The first contention we took is that, my lord, the accused was not a driver. But to prove that, my lord, they not even produced some salary certificate, salary receipt, or any kind of something to show, my lord, they were paying some amount. So firstly, my lord, they did not do, my lord, they just narrated what was in the complaint. The first fact, my lord, they proved, my lord, that I was a driver. And second thing, my lord, the breach of trust, my lord, they have to show what was the trust they had in me, my lord, to give the 7,20,000, though they had the other tall man, my lord, the gentleman with the CW. I would have assumed, my lord, the complaint CW who alone had went with the driver accused, and there was no other person apart from the CW1. Then could have believed, my lord, that only the one single person is there. He cannot carry such a huge amount to the market for negotiation. In that situation, I would have understood, my lord, believed some amount has been kept in the car so that I cannot carry whole amount. Some pickpocket might have arisen. Along with the CW, there are 2 other persons, my lord. So the trustworthy, my lord, is not being forthcoming. And secondly, my lord, the breach of trust, my lord, is my humble submission. Initially, the amount of 7,20,000 is been entrusted by the CW4 owner to the CW1 complainant, my lord. But the complainant is the one who breached the trust, my lord, because CW4 owner never said, my lord, the amount you have to give it to the driver in case if you are going for negotiation. He never said, or the accused driver is not the authorized person to carry such amount. So it is the breach of trust has been done by violated or breached by the complaint CW1 because he has never been told to give the amount while you go for the negotiation for market. But it is the CW1 who has breached the trust, not the accused. And there are no materials to show, my lord, the amount has been entrusted to me apart from self-serving statement, my lord. This is one, my lord, the defense. My lord, my lord, they shown the capacity of the statement because, my lord, CW4 is a businessman. He had a capacity of the amount. But the point for breach of trust is only, my lord, the entrustment, my lord, is not been proved apart from self-serving statement. And as I stated, my lord, they failed to prove I am the driver, my lord, no certificate or something, nothing has been produced. And, my lord, in the PW1, my lord, the chief examination, they say, my lord, ಉಳಿದ ಹಣವನ್ನು ಅಕ್ಯೂಸ್ಡ್ಗೆ ಆರೋಪಿಗೆ ಕೊಟ್ಟು ಹೋದ್ವಿ ನಾವು ಅಂತ ಹೇಳ್ತಾರೆ. They say ಉಳಿದ ಹಣ. It is a PW1 chief, my lord, if lordship's take, my lord.
Yes.
PW1 chief, my lord, is. We just read, my lord. Initially, it starts as ಆರೋಪಿ ಚಾಸ ನಾಲ್ಕರವರ ಬಳಿ ಬುಲೋರೋ ವಾಹನ. Please, Nagesh, my lord, please. He's the complainant CW1 who is the manager, accountant, my lord, who was entrusted with 7,20,000. He's the main person, my lord. But he says, my lord, ಆರೋಪಿ ಚಾಸ 4ರವರ ಬಳಿ ಬುಲೆರೋ ವಾಹನದ ಚಾಲಕನಾಗಿದ್ದನು. ಸಿರಿಸಿಯಿಂದ ನಾವು ಚಾಸ 2, ಚಾಸ 3 ಮತ್ತು ಆರೋಪಿ ಸಿರಿಸಿಯಿಂದ ಮುಳುಬಾಗಿಲಿಗೆ ಬುಲೆರೋ ನಂಬರ್ ಸೋಯನ್ಸೋ ವಾಹನದಲ್ಲಿ ಆರೋಪಿ ಚಲಾಯಿಸಿಕೊಂಡು ಬಂದಿದ್ದೆವು. ಚಾಸ 4 ಮಾವಿನ ವ್ಯಾಪಾರಕ್ಕೆ 7,20,000 ರೂಪಾಯಿ ಹಣವನ್ನು ನಮ್ಮ ಕೈಯಲ್ಲಿ ಕೊಟ್ಟು ಕಳಿಸಿದರು. 9/6/2004 ಅಂದು ಮಧ್ಯಾಹ್ನ 3:30 ಸುಮಾರು ಮುಳುಬಾಗಿಲಿನಿಂದ ಶ್ರೀನಿವಾಸಪುರಕ್ಕೆ ಜೀಪಿನಿಂದ ಬಂದೆವು. ಶ್ರೀನಿವಾಸಪುರದ ಹಣ್ಣಿನ ಮಂಡಿಯ ಹತ್ತಿರ ಸಾಯಿ ಲಿಂಕ್ಸ್ ಮುಂಭಾಗ ಜೀಪಿನಲ್ಲಿ ಬಂದು ಅಲ್ಲೇ ನಿಂತಿದ್ದೆವು. ಆರೋಪಿ ಕೈಯಲ್ಲಿ ನಾವು ಉಳಿದ 3 ಹಣ ಕೊಟ್ಟು ನಾವು ಹಣ್ಣಿನ ಬೇರೆ ಮಂಡಿಗಳಿಗೆ ಹೋಗಿ ಬರುತ್ತೇವೆ ಎಂದು ಹೇಳಿ ಹಣ ಕೊಟ್ಟು ಅಲ್ಲಿಂದ ಹೋದೆವು. So, my lord, I paused. My lord, they say ಉಳಿದ ಹಣ. My lord, what is they did not say, my lord, out of I had a 10 lakhs, out of which, my lord, I carried some amount and gave the 7 lakhs to him. They say ulida. Everyone stated. So what is this remaining amount? They are not stated. It's not corroborating. My lord, they just narrated what has, my lord, they stated. There is nothing, my lord. They what complaint is. My lord, apart from this, there is nothing, my lord, to say. Point out to any. And this is one, my lord, everyone carried that they the ulida hana kotru anta. My lord, the PW2, my lord, he's also a person who was working with the owner, accompanied the CW1, my lord. He also stated the same. 7 lines, my lord, links.
Other.
Please, my lord. The 7 lines, links ಮುಂಭಾಗ ಜೀಪಿನಲ್ಲಿ ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. ಲಿಂಕ್ಸ್ ಮುಂಭಾಗ ಜೀಪಿನಲ್ಲಿ ಬಂದು ಅಲ್ಲೇ ನಿಂತಿದ್ದೆವು. ಆರೋಪಿ ಕೈಯಲ್ಲಿ ನಾವು ಉಳಿದ 3 ಹಣ ಕೊಟ್ಟು ನಾವು ಹಣ್ಣಿನ ಬೇರೆ ಮಂಡಿಗೆ ಸೇಮ್ that has been repeated. And the next, my lord, is Mr. Gauss Sahib. He's also said the same thing, my lord. He is also accompanied with the incident with CW1 and 2. Lord, this PW4, who is the owner, my lord, he gives a different date, my lord, of the when they send the persons for purchasing the mango. PW4, my lord, Mr. Abdul Karim, lord, he says, my lord, just read the. ನಾನು ಸಿರಿಸಿಯಲ್ಲಿ ಹಣ್ಣಿನ ವ್ಯಾಪಾರವನ್ನು HKB ಎಂಬ ಹೆಸರಿನಲ್ಲಿ ನಡೆಸುತ್ತಿದ್ದೇನೆ. ಚಾಸ 1 ನನ್ನ ಬಳಿ ಮ್ಯಾನೇಜರ್ ಕಮ್ ಅಕೌಂಟೆಂಟ್ ಆಗಿದ್ದರು. ಚಾಸ 2 ನನ್ನ ಅಂಗಡಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ಆರೋಪಿ ನನ್ನ ಬಳಿ ಬುಲೆರೋ ವಾಹನವನ್ನು ಚಾಲಕನಾಗಿದ್ದು ಚಾಸ 3 ನಮ್ಮ ಅಂಗಡಿಗೆ ಬಂದು ಹೋಗುತ್ತಿದ್ದರು. 8/8/2004 ನಾನು ಚಾಸ 1, 2, 3 ಆರೋಪಿ ಜೊತೆ ನನ್ನ ಮಹೀಂದ್ರ ಬುಲೆರೋ ನಂಬರ್ ಸೋಯನ್ಸೋ ವಾಹನದಲ್ಲಿ 7,20,000 ಹಣವನ್ನು ಕೊಟ್ಟು ತೋತಾಪುರಿ ಹಣ್ಣಿನ ವ್ಯಾಪಾರ ಮಾಡಿಕೊಂಡು ಬರಲು ಕಳಿಸಿಕೊಟ್ಟೆ. 9/6/2004 ನನಗೆ ಚಾಸ 1 ಆರೋಪಿ ಹಣ ಮತ್ತು ವಾಹನದೊಂದಿಗೆ ಪರಾರಿಯ ಬಗ್ಗೆ ವಿಷಯ ತಿಳಿಸಿ ನಾನು ಆತನಿಗೆ ಪೊಲೀಸರಿಗೆ ದೂರು ನೀಡಲು ತಿಳಿಸಿದ್ದೀನಿ. ಪೊಲೀಸರು 12/6/2004 ನನ್ನನ್ನು ಫಾರೆಸ್ಟ್ ಪ್ಲಾಂಟೇಶನ್ ಹತ್ತಿರ ಕರೆದುಕೊಂಡು ಹೋಗಿ ನನ್ನ ಬುಲೆರೋ ವಾಹನವನ್ನು ಪಂಚನಾಮೆಯಡಿ ಅಮಾನತುಪಡಿಸಿಕೊಂಡು ಅದನ್ನು ನೀಪಿ 3 ಸಹಿ ಎಂದು ನೀಪಿ 3A ಎಂದು ಗುರುತಿಸಿ ನಾನು ಬಾಂಡ್ ಬರೆದುಕೊಟ್ಟು ದೇ ರಿಲೀಸ್ ಮಾಡಿ. ನೋಡಿ, he gave a date, my lord, 8/8/2004. ನಾನು ಚಾಸ 1, 2, 3 ಆರೋಪಿ ಜೊತೆ ಕಳಿಸಿದ್ದೆ. They say, my lord, the 8/8/2004, but the incident, my lord, they say 9/6/2004, my lord, that is prior to the complaint. 2 ತಿಂಗಳಿಗಿಂತ ಮುಂಚೆ ಕಳಿಸಿದೆ ಅಂತಾರೆ, but the incident has happened, my lord, 2 months before to that. There is some contradiction, my lord.
So incident happened on
9/6/2004. Lord, the owner, my lord, who says 8/8/2004, I sent all the managers CW1 to accused for purchasing the mango. On 8/8/2004, he says.
Must be some typographical error.
No, my lord, that is also come in the judgment.
Further after, 3 lines after, the same date is also shared.
Please. But even assume, my lord, that typographical error, it could be, my lord, some 9/8 or something. that the 8-8 could not be, my lord, treated, and that has not been re-examined, my lord, by the.
All right.
Please, my lord. Lord, see, PW5, my lord, is
Abdul Rahman.
please, my lord, is a punch witness, my lord. PW6, my lord, is the investigation officer. But the 7, my lord, is, they say, PW7.
Who's PW7?
The PW7 is the person, my lord, they examined, who says that, my lord, the CW1 and 1, 2, 3, my lord, they said, my lord, they will go and negotiate for the purchase of the mango. They negotiated with the CW4, that the PW7. He is the person with where they have negotiated. While they return back, my lord, the vehicle was not on. He has been examined as PW7, who is also.
Read what?
Please, my lord. ಕಳೆದ 17 ವರ್ಷಗಳಿಂದ ಶ್ರೀನಿವಾಸಪುರದಲ್ಲಿ ನಾನು ಮಾವಿನ ಮಂಡಿ ಇಟ್ಟುಕೊಂಡಿದ್ದೇನೆ. ಚಾಸ 4 ನನ್ನ ಮಂಡಿಯಲ್ಲಿಯೇ ವ್ಯಾಪಾರ ಮಾಡುತ್ತಾರೆ. 2004ರಲ್ಲಿ ಚಾಸ 4ರವರು ಗುಮಸ್ತ ಮತ್ತು ಗೌಸ್ ಎನ್ನುವವರು ಹಣ ಕೊಟ್ಟು ಕಳಿಸುತ್ತೇನೆ ಎಂದು ಫೋನಿನಲ್ಲಿ ವಿಷಯ ತಿಳಿಸಿದರು. 9/6/2004ರಂದು ನಾಗೇಶ್ ಮತ್ತು ಗೌಸ್ ನನ್ನ ಮಂಡಿಗೆ ಬುಲೆರೋ ವಾಹನದಲ್ಲಿ ಸಂಜೆ 4 ಗಂಟೆಗೆ ಬಂದರು. ನ್ಯಾಯದ ಮುಂದಿರುವ ಆರೋಪಿಯ ಈ ಬುಲೆರೋ ವಾಹನದ ಚಾಲಕನಾಗಿದ್ದನು. ಬುಲೆರೋ ವಾಹನ ನನ್ನ ಮಂಡಿಯ ಮುಂದೆ ನಿಂತಿತ್ತು. ಆ ವಾಹನದಲ್ಲಿ ಆರೋಪಿ ಕುಳಿತಿದ್ದನು. ಉಳಿದವರು ನನ್ನ ಮಂಡಿಯಲ್ಲಿ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದರು. ನನ್ನ ಹತ್ತಿರ ವ್ಯಾಪಾರ ಮುಗಿಸಿ ನಾಗೇಶ್ ಮತ್ತು ಗೌಸ್ ಹಣ ತರಲು ಆಚೆ ಹೋದವರು ಪುನಃ ಗಾಬರಿಯಾಗಿ ಒಳಬಂದು ಬುಲೆರೋ ವಾಹನ ಮತ್ತು ಅದರ ಚಾಲಕ ನಾಪತ್ತೆಯಾಗಿದ್ದಾರೆ ಎಂದು ತಿಳಿಸಿದರು. ಜೀಪಿನಲ್ಲಿ 7,20,000 ಹಣ ಇದ್ದ ಬಗ್ಗೆ ನನಗೆ ತಿಳಿಸಿದರು. ನಂತರ ನಾವು ಶ್ರೀನಿವಾಸಪುರದ ಅಲ್ಲೇ ಎಲ್ಲ ಕಡೆ ಹುಡುಕಿದ್ದೇವೆ. ನಂತರ ಜೀಪು ಮತ್ತು ಚಾಲಕ ಸಿಗದ ಕಾರಣ ನಾಗೇಶ್ ಅವರು ದೂರು ನೀಡಿದರು. ಆರೋಪಿ ಗುರುತಿಸಿದ್ದಾರೆ. The cross, my lord, there were some suggestions, but nothing, my lord, the contradiction.
Very effective.
Please. But that, my lord, the what, my lord, is 7,20,000 India, 2004, my lord, it's a huge amount. And totally, my lord, feels, my lord, how they interested.
So it could not have been given.
Please, my lord, normally, my lord, it could have been understood, my lord, the only 2 persons, my lord, I and the accused, the driver will go a long time. And we worked
Who
for.
gave this 7,20,000?
The CW4, who is the owner.
All right, he's examined.
He's examined.
Did you cross-examine him that he did not have the capacity? Where did you get the money from?
That has been done, my lord. They also, that capacity, my lord, he is a businessman. They also produce a bank statement. There is some capacity. The entrustment of the amount, my lord, that is then the breach of trust, my lord, 406. The entrustment they need to prove, my lord. And my lord, the accused was not the authorized person to keep this amount. And as I submitted, my lord, it's my humble submission. CW1, my lord, who was the one who breached the trust, because, my lord, he was the one who is not only a normal man, my lord, he's a manager come accountant, my lord. Because he is the only sole responsible person to carry the amount. My lord, everything is on the accused, my lord, sorry, PW1, who is the complainant.
Yes.
That's all.
Lord, the accused was arrested by the PW8 police constable after 7 years of this incident.
PW8 arrested the accused.
Yes. In the
That
bus
is after
stand.
how many years?
After 7 years.
PW8 is the
Incident. Yes,
IO, no?
police constable.
Constable who arrested.
Yes, CW 8 and 9 almost dated. He was arrested. PW8, the police constable arrested the accused persons. So on his on the voluntary statement of the accused and also bank statement of the CW4 who given the money to the interested money to the CW1 to 3. So after seeing the bank statement and voluntary statement, the charge sheet has been filed against the accused persons. So as per the PW 123, they are along with the accused persons. All of them went to purchase the mango. So they see PW 123 and 7, PW 7 clearly discloses that the accused ran away from the vehicle when and also they deposes that the PW4 was given a sum of rupees 7,20,000 to them.
To whom?
PW4.
Gave it to whom?
This accused PW 123, the driver was also there, my lord. He was driving, accused was driving the vehicle. So they entrusted. What they said, the PW 123.
No, whether he have made out prosecution that entrustment of that amount by PW4 was made to accused
As
or
per the bank statement, my lord, it was
whether
capacity
it was
to-
made to accused or PW 123.
The PW 123 clearly deposes, my lord, he entrusted the money, 7,20,000 to them to purchase mango.
The PW4 gave it to 123.
Yes, my lord.
Not to the accused.
Not for accused.
123 gave it to accused.
Accused was a driver.
Correct.
So they went to purchase. They informed the accused, they will go and inquire and they will come back.
They went to PW7.
Yes, my lord. PW 123.
Went to PW7.
Went to PW7 to inquire, to purchase the mango. Thereafter, after coming back, he escaped
ran away.
along with the money and the vehicle. Thereafter, after 7 years, the PW8 was arrested. Constable arrested the accused person on his voluntary statement and also bank statement of the PW4 who entrusted money. So on the basis of this, police have filed a charge sheet. On the evidence of PW 123 and PW7, so this accused persons committed the offense alleged against the accused, committed the breach of trust under section 406. Escaped along with the vehicle with money. PW 123 and 7, they are supporting the case of prosecution as per their evidence, cogent evidence. This accused persons committed the offense alleged against him.
Yes.
The learned trial judge rightly convicted the accused, punishable under section 406 IPC. The revision petition may be dismissed.
The bank statement, if I just, bank statement exhibit P7, on the date of incident, my lord, on the earlier date, but they have not shown that that amount has been withdrawn, my lord. On that day, nothing has been done. In fact, there is a debit, my lord, like withdrawal. On that day also, my lord, they failed to show, my lord, they in fact, my lord, borrowed the amount. That's one sample submission.
All right. Withdrawal ಇದೆಯಲ್ಲ ಅದರ exhibit P7 ಅಲ್ಲಿ.
Andre,
The withdrawal of 3 lakhs and 6 lakhs on.
Please, my lord, they say 7,20,000, but they,
Even if that is not shown,
please,
he could have still kept that in his house.
that presumption, my lord.
That is, may not be crucial. That is an additional thing in favor of complainant.
Please. In fact, that the 3 lakhs is a credited amount, but not the debit. 3 lakhs, my lord, it's a credited amount. What is, my lord, the amount which has been debited is only, my lord, 10,000, 17,000, 54,000 and some. Before to that, my lord, there is no such, my lord, huge amount being withdrawn. To a tune of 7,20,000, my lord, is not forthcoming.
So accused was the driver of CW4.
Please, my lord, accused was the driver of the CW4, my lord. The CW4 is the owner who is the businessman. Under him, my lord,
The owner.
under him,
He was the owner of that businessman PW4.
please, my lord, he is the owner.
No.
Under him, my lord, the,
PW4 is the owner.
please, my lord,
See that accused, he was a driver of this.
Please,
businessman.
please. It is their case, my lord, that the accused was the driver, but no materials to show, my lord, the accused was
Have
the
you cross-examined by saying that he is not the driver?
Please, my lord, that was suggestion was made, my lord, they formally denied. But, my lord, it was burden on them to show, my lord, at least the salary receipt or something, my lord, to show.
Salary receipt ಕೊಡ್ತಾರ್ರಿ ನಿಮ್ driver ಕೊಡ್ತೀರಾ ನೀವು?
Now, my lord, the, not salary receipt, my lord, at least the amount being credited.
But then at least now people have started sending it by.
Phone pay or some. So,
ಎಲ್ಲಿ lawyers ಕೊಡ್ತಾರಾ?
my lord, on that, at least, my lord, they would have stated what is the amount, my lord, they give for the driver. And, my lord, when the driver, my lord, he says, I'm not a driver, at least some little, my lord, the evidence they would have made, my lord, apart from showing the capacity of the amount, nothing they placed to show, my lord, I was the driver, my lord. Or they say, my lord, there are many persons work with him. They not examine those persons to show, my lord, apart from the.
What is the requirement of the 406?
My lord, the requirement is that, my lord, there has to be an entrustment, my lord, which is the main factor. And for that entrustment, my lord, there has to be legal contract or express or impliedly. Now, my lord, the main person is that, my lord, CW4, who is the owner. And, my lord, his main entrustment is on the CW1, my lord. He is the manager, accountant, who is the only responsible person to hold the amount. And, my lord, if that person, my lord, without authorization, information, nothing, my lord, they are not even stated that, my lord, like whenever they go for it, they will give such an amount. And, my lord, what confidence, my lord, they have to give such an amount for this driver is also one point, my lord, needs to be reconsidered.
From how many years say this accused was working with the PW4?
Lord, the accused case is that, my lord, he was never working with the person. There are some enmity. It is his case, my lord. Accused denied totally, I am not a driver at all. He works somewhere in Andhra Pradesh, my lord. That was his case. The entrustment by the owner is in the CW1 complaint, my lord. And they never stated that, my lord, this is the transaction they do whenever they go for negotiation. For some safety, my lord, I understand they would have kept the amount in the car. But, my lord, that situation may come only if the driver and the CW1 alone were there in the persons. Along with them, two other persons, my lord, they would have entrusted the amount.
As per the PW7, my lord, owner of the mandi. So it clearly states that the PW 123, they went to purchase the mango. By that time, the accused Larry was parking in front of his mandi and driver was sitting inside the lorry,
Lorry alla, the Bolero vehicle.
a Bolero vehicle. So thereafter, from there, he escapes from the money along with the vehicle.
Now, my lord, here the legal contract or express or impliedly about the money entrustment is between the CW4 and CW1. I am the driver, my lord.
Just check the technical legalities of that.
Please.
That entrustment has to be with that person or it could be through another person.
That's one aspect.
That is the only thing you have to find.
Please, my lord, that's one.
On the legality of that
Please,
406.
Please.
Because even if he's an employee, he can be roped under 406.
Please, my lord,
But it is not the case of prosecution that it was given to the accused by PW.
Please, my lord, that
7.
would, please, my lord. If that was the case, my lord, then I would have no case. Directly, there is a contract or express impliedly. No, my lord, here the contract is between the CW1 and the.
No, my lord, PW7 is the mandi owner.
PW,
So
your case is prosecution case is PW7.
Yes.
Give it to PW 1 to 3 to go to the mandi.
Yes.
Purchase mangoes. PW, the accused is the driver.
Yes.
Of PW7. 1 to 3 took the accused, went in Bolero car.
By that time, this fellow.
They stopped there. They went to 1, 2, 3, went to PW7
Yes, my lord.
to buy. When the time they came back, the vehicle is missing, so also the driver.
Yes.
Now, whether PW4 gave the amount to 1 to 3 or did he give it to the accused? It is your own case that you give it to 1 to 3. Whether entrustment is done to the accused or whether to 1 to 3.
But his accused is a driver.
Whether you give the money to driver or you gave it to 1 to 3, who
driver.
in turn gave it to driver, and whether that can attract 406 is the question. Understood?
Yes.
ಅದು ನೋಡಿ 406 ಓದಿ. Call this matter on 26th.
Please.
So when there is a entrustment, it has to be entrusted to the person whom you are alleging.
Please.
Please.
So if the entrustment is made to the accused, 406 will apply. Otherwise, some other provision may apply. I don't know. Just loudly think.
And now, my lord, their purpose, my lord, went to purchase the mango. They say, my lord,
He
PW7.
is working under PW4.
Yes,
Driver.
sir. Working fine. That also you have not placed anything.
Yes.
Secondly, if it's your case that PW4 gave it to the accused, where have you said so? It is your own case, prosecution, that you gave it to PW 1 to 3 who are CW 1 to 3.
Yes, my lord.
Entrustment ಯಾರಿಗೆ ಮಾಡಿದ್ದಾರೆ?
PW 1 to 3 again.
Whether 1 to 3 in turn gave it to accused when they got down and went to the mandi.
But accused is also working under PW4.
ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು.
He is the driver under the PW4.
ಹೇಳ್ಬೇಕಲ್ಲ ಡ್ರೈವರ್ ಬಟ್ ನಿಮ್ಮ ಅವ್ರು ಕೊಟ್ಟಿರೋದು entrustment is by whom? Who was entrusted that money? And why you did not file a case against CW1? Who was your manager? Who was your accounts manager?
Please.
Yes.
So the theory put forth by him that you have some enmity will crop up. And if that was the case, you would have had all the documents to show that he was your driver.
Yes.
You would have produced more evidence to show that he was working with me as a driver. Where are those? Next case.
71. The Abu Bakr Shafi.
Lord, 71, my lord, I appear for the petitioner, my lord.
Respondent, my lord.
Lord, in this case, what happened, my lord, that respondent got the resolution of marriage from the family court order, and also I have filed the her second marriage photographs, but your lordship directed me to collect some more evidence for the second marriage. So I am trying, my lord, and my party contacted the local.
My lord, I've kept my,
1 minute.
I've kept the respondent present, my lord. She's ready to swear on oath
that she is not married for the second time, and the photograph or any, she has nothing to do with those photographs. The dissolution of marriage has taken place. We don't deny that. We admit it. My lord, she is rightly entitled for maintenance is our case. Their case is that she has married again, and hence maintenance does not, the question of maintenance does not arise. I've kept her present, my lord.
regarding
She's also
that-
ready to swear on oath. My lord, we will file an affidavit if required, my lord. We are ready to do that.
And we have also contacted, my party also contacted the local masjid where the marriage has been performed. And my lord, it may be taken on 30th. Before that, I'll produce the document from the local mosque where the marriage has been performed.
Lord, I'll file a proper memo for that, my lord. I've just received that. That local masjid has said that, my lord, there is no such marriage that has taken place.
File body.
I will file that. Lord, may be taken on record.
I will get the proper evidence, my lord. It may be taken on 30th of this month, my lord. Photographs which was given to me, I furnished, and also the maintenance given up to 10/8/2022. That I furnished, and dissolution of marriage, that with the memo I have furnished the documents.
All right. Learned counsel for the petitioner seeks time. Counsel for
My lord.
respondent along with the respondent is present. Is this matter on 30th?
Maybe
30th of this month, my lord.
Huh?
30th, 30ನೇ ತಾರೀಕು.
ಓದ್ತೆ ಕೊಟ್ಟಿರೋದು.
ಅದೇ ಡೇಟ್ ಸರ್.
I'll file an affidavit, my lord, that I have not remarried. Please, obliged.
You need not keep her present on the next date.
No,
She
please.
did not come to the court.
Please, man. Obliged.
72 ಅದೇ
30th, my lord.
30th ಕೊಟ್ಟಿರೋದ್ರಿ ಮಿಸ್ಟರ್ ಶಫಿ.
ಆಯ್ತು, obliged.
73 ಶ್ರೀ ಬಾಲರಾಜ್ ಎಸಿ ಶ್ರೀ ಪೃಥ್ವಿ ಪ್ರಹ್ಲಾದ್ ಕಟ್ಟಿಮನಿ.
Due to paucity of time, release this matter on 26th.
Chamber 74 ಶ್ರೀ ಗಂಗಾಧರಪ್ಪ ಎವಿ.
Same order.
Chamber 77 ಶ್ರೀ ಕೆಂಪರಾಜು ಶ್ರೀ ರಾಜೇಂದ್ರ ಕೆ.
I appear for respondent in this case, Lordship. Lordship, it's a criminal review petition filed by the petitioner, Lordship, under 397.
What is the offense?
138, Lordship.
All right. Due to paucity of time, call this matter on 26th.
Much obliged.
78 ಶ್ರೀ ಪ್ರಸನ್ನ ಡಿಪಿ ಶ್ರೀ ಶಶಿಕುಮಾರ್ ಆರ್ ಗೌಡ.
For respondent in this case, my lord, it's a 138 proceedings, my lord.
We'll have it on 27th.
My lord,
27th.
I vote.
Passed
Call.
out matters. Chamber 62 ಶ್ರೀ ಎನ್ ಜಿ ಪರಮೇಶ್ವರಪ್ಪ ಶ್ರೀ ಟಿ ಹರೀಶ್ ಭಂಡಾರಿ.
Really, you sought for time.
Yeah, pray for time.
Learned counsel for the petition seeks time. Call this matter on. When do you want? ಯಾವಾಗ?
2 weeks may be granted.
Date ಕೊಡಿ.
30th September. Chamber 64 ಶ್ರೀ ಪ್ರಸಾದ್ ಬಿ ಎಸ್.
Yes, call this matter on.
30th September.